ಇಲ್ಲ ನಾವು ಹುಡುಕಿಸಿದಾಗ ಅಲ್ಲೇನು ಸಿಕ್ಕದೇ ಇಲ್ಲ. ಹಂಗಿರ್ಬೇಕು, ರೆಡಿ ಇಲ್ಲದೆ ಇರೋ ಇರೋದನ್ನ ರೆಡಿ ಮಾಡಿಸ್ಕೊಂಡು ನಾವು ನೆನ್ನೆ 7 ಗಂಟೆವರೆಗೂ ಹುಡುಕ್ಸಿದ್ದೀವಿ. ಬೈತಾರೆ ಇಲ್ಲ ಬೈತಾರೆ ಒಂದ್ಸಲ ಹಾಕಿಸ್ಬಿಟ್ರೆ ನಾನೇನು ಕ್ಲರ್ಕ್ ಅಂತ ಹಾಗೆ ನಿಮ್ಗೆಲ್ಲ ಯಾಕೆ ಉಸಾಬ್ರಿ ಅದೆಲ್ಲ ಬೇಕಾದವನು ಮುಂದೆ ಮಾಡ್ತಾರೆ ಗೊತ್ತಿಂದ ಸಮಾಜಕ್ಕೆ ಹೋಗಲ್ಲ. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಆಗಿದೆಯಾ? ಆಗಿದೆ. ಕಂಪ್ಲೈ ಮಾಡ್ಬಿಟ್ಟು ಬರಲ್ಲ, ಕಂಪ್ಲೈ ಮಾಡಿ ಬರಲ್ಲ ಅಷ್ಟೇ. 2 ದಿವಸದಲ್ಲಿ ಬರುತ್ತೆ. 2 ದಿವಸ ಕಂಪ್ಲೈ ಮಾಡಿ 2 ದಿವಸದಲ್ಲಿ ಸಾಹೇಬ್ರು ಬರ್ಬೇಕು. ಪೆಂಡಿಂಗ್ ಎಲ್ಲ ಮೆನ್ಷನ್ ಸಾಹೇಬ್ರು ಸರ್ ಆಗಿದೆ. ಹಂಗಾರೆ ಸಾಹೇಬ್ರು ಬರ್ಬೇಕು. ಕೂತ್ಕೊ. ಸರಿ ಸರ್, ಸಾಹೇಬ್ರು ಬರ್ಲಿ. ಕಂಪ್ಲೈ ಮಾಡಿದ್ದೀರಾ? 15,000 ಇದೆ. ಮತ್ತೆ ಅವಾಗ ಸಾಹೇಬ್ರು ಬರ್ಬೇಕು. ಅದೇ ಸಾಹೇಬ್ರು ಬರ್ಬೇಕು. ಒಂದು ಸಲನೂ ಬರದೇ ಇದ್ರೆ ಮಾತ್ರ, ಒಂದ್ ಸಾರಿನೂ ಕೋರ್ಟ್ ಮುಂದೆ ಬರದೇ ಇದ್ರೆ ಮಾತ್ರ ನೀವು ಕೊಡ್ಬೋದು. ಅಂಥದ್ದು ಮಾತ್ರ ಬರ್ಬೋದು. ಒಂದ್ ಸಾರಿ ಬಂತು ಅಂದ್ರೆ ಹೋಯ್ತು. ಅದಕ್ಕೆಲ್ಲ ಸಾಹೇಬ್ರು ಇವಾಗ ಅವ್ರು ಕೇಳಿ ಡೇಟ್ ಕೊಡ್ತಾರೆ. ಏನ್ ಮಾಡ್ತೀವಿ? ಹೌದೌದು. 26 ಸೆಪ್ಟೆಂಬರ್ ಬರುತ್ತೆ. 19 ಅಥವಾ 26 ಸೆಪ್ಟೆಂಬರ್ ಬರುತ್ತೆ. ಈ ಮಂತಲ್ಲಿ 2 ದಿವಸದ ಲಿಸ್ಟ್ ಔಟ್ ಆಗೋಗಿದೆ. ಫಸ್ಟ್ ವೀಕ್ ರಜೆ ಇದೆ, ಅದಕ್ಕೆ ನಾನು ಸೆಕೆಂಡ್ ವೀಕ್ ಅಥವಾ ಥರ್ಡ್ ವೀಕ್ ಹೇಳಿ. ಫಸ್ಟ್ ವೀಕ್ ಫ್ರೈಡೆ ರಜೆ
ಸರ್. ರಿಟ್ ಅಪೀಲಲ್ಲಿ ಡಿಸ್ಪೋಸಲ್ಗೆ ಆರ್ಡರ್ ಆಗಿದೆ, ರಿಟ್ ಪೆಂಡಿಂಗ್. ಅದು ಮೆಮೊ ಕೊಡ್ಲಾ? ಇಲ್ಲಿ ರಿಟ್ ಪೆಟಿಷನ್ ಇದೆ ಅಲ್ವಾ, ಸೊ ಅಲ್ಲಿ ರಿಟ್ ಅಪೀಲಲ್ಲಿ ಡಿಸ್ಪೋಸಲ್ಗೆ ಆರ್ಡರ್ ಆಗಿದೆ.
ಅದು ಹೇಳ್ಬಿಟ್ಟು ಕೊಡ್ಬೇಕು ಸಾಹೇಬ್ರು.
ಹೇಳ್ಬಿಟ್ಟು ಕೊಡ್ಬೇಕಾ?
ಅಲ್ಲ ನಾವು ಕೊಡ್ತೀವಿ, ಬಟ್ ಏನಾಗಿದೆ ಮುಂಚೆನೆ ಕೊಟ್ಬಿಟ್ಟಿದೀವಿ ಜಾಸ್ತಿ. ಹಾಗಾಗಿ ನಾನು 2 ವಾರ ಕೇಳ್ತಾರೆ. ಯಾಕಂದ್ರೆ ನಾನು ಆತರ ತಪ್ಪಾಗಿ ಹೇಳ್ಬಾರ್ದು. ತುಂಬಾನೇ ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ದಾರೆ. 2 ವಾರದಲ್ಲಿ ಯಾವತ್ತೋ ಒಂದು ದಿವಸ ಬರುತ್ತೆ. 24th ಅಂತೂ ಕನ್ಫರ್ಮ್, 26th ಕನ್ಫರ್ಮ್, 19th ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ. ಯಾವ ರೀಶ್? ದೇವದಾಸ್ ಸಾಹೇಬ್ರ ಹತ್ರ. ಈಗ ಯಾರಲ್ಲಿ ಅಡಿಷನಲ್ ಯಾರ ಇನ್ನೊಬ್ರು ಕೊಡ್ತಾರೆ. ಯಾವ ಬ್ರಾಂಚ್ ಹಾಕಲ್ಲ ಒಂದು ಅಪೀಲು ಸರಿ ಹಾಕೊಡ್ತಾರೆ. 2 ಮೊಬೈಲ್ ಇಟ್ಕೊಂಡು ಕೆಲಸ ಕಾರ್ಯ ಬರಲ್ಲ. ನನಗೆ ಜೂನಿಯರ್ ನಮ್ಮ ಲಿಸ್ಟ್ ಅಲ್ಲಿ 5 ಜನ ಬಿಟ್ಟೋಟೋರು. ಆಗ ಅವ್ನಿಗೆ ಲಕ್ ಸಿಕ್ತು. ಅಡಿಷನಲ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ, ನಾಟ್ ಇವನ್ ಮೆರಿಟೋರಿಯಸ್ ಕ್ಯಾಂಡಿಡೇಟ್. ನಮ್ದ್ರಲ್ಲಿ 5 ಜನ ತುಂಬಾ ಟಾಪ್ ಮೆರಿಟ್ ಇದ್ದವರು ಬೇರೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್. ಹಾಗಾಗಿ ಇವನು ಆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದ್ದವನು ಬಂದ. ಆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದ್ದವನು ಇವನು ಬಂದ. ಇವಾಗ ಅವ್ನ ಲಕ್ಕು ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಇವತ್ತಿಗೂ ಏನ್ ಎ ಅಂದ್ರೆ ಬಿ ಗೊತ್ತಿಲ್ಲ, ಬಿ ಅಂದ್ರೆ ಸಿ ಗೊತ್ತಿಲ್ಲ. ಬರ್ಲಿ ಸಾಹೇಬ್ರು ಬರ್ಲಿ. ಒಂದ್ಸಲ ಬಂದ್ಮೇಲೆ ಆಯ್ತು ಅಷ್ಟೇ. ನಮ್ಮ ಜೂರಿಸ್ಟಿಕ್ಷನ್ ಸೀಸ್ ಆಗ ಇನ್ನೇನಿದ್ರು ಎಲ್ಲ ಸಾಹೇಬ್. ಬರ್ಲಿ ಕುತ್ಕೊಳ್ಳಿ.
promotion list withheld ಆಗಿದೆ. Copy sir, and sir.
ಅವ್ರ ಮೇಲೆ ಬರ್ತಾ ಇದಾರೆ ಫಸ್ಟ್ ಕೇಳ್ಕೊಂಡ್ಬಿಟ್ಟು.
ಅಯ್ಯೋ ಅವ್ರು ಏನಲ್ಲ ಅಷ್ಟೊಂದು ಮುಂದೆ ಹೋಗ್ಬಿಟ್ಟು ಟಿವಿ ಮೇಲೆ ಕೈ ಇಡ್ತಾರೆ. ಟಿವಿ ಮೇಲೆ ಬಿದ್ದಿದ್ದಾರೆ.
No, you are appearing for whom? Interim order is there. If interim order is not complied, you file in a contempt. Yes. Read this matter on 15th. Yes. 15th.
Promotion list withheld ಆಗಿದೆ. By hand service ಮಾಡಿದ್ದೀನಿ ಕಾಪಿನ. My kindly
15th September. Yes. 16 days.
My lordship, you send copy BPT court. Hence, matter already order and the one
Yes. 16 days.
ಸ್ವಾಮಿ ಇದರಲ್ಲಿ ಜುಡಿಷಿಯಲ್ ಮೆಂಬರ್ ಆಗಿದೆ.
Fresh matter, there is no stay granted, but challenge not appointment of not post of clerk. Any date what?
Yes. 16 days.
My lord, it is a stay issued in the year 2023, my lord. I am the respondent university. It may kindly posted for it. I have already filed a statement objections I have filed.
17.
The matter pertains to
Submit.
selection, my lord.
Obliged.
His name was not shown in the final selection list. There is no interim stay also.
No, fresh matter or old?
Old matter, my lord.
17 days.
Lord, due to interim order, Lord, the person who is having without authority is continued in the post, Lord, it may be taken any date.
No, vacating application.
Vacating ಹಾಕಿದೆ, objection ಹಾಕಿದೆ.
Yes. Read this matter on 29.
Obliged.
The old matter, my lord, was referred to mediation. Mediation failed, my lord. The parties are old.
Yes. Yan RFA na?
Yes, my lord.
RFA 12. Yes.
RFA 2010 matter, madam, what pioneering matter.
12. RFA. RFA kodi.
ಇದು fresh matter.
RFA 12 to 19th. Yes.
ಇದು fresh matter, sir. After
Yes.
subjection.
16th.
ಸ್ವಾಮಿ ಇದರಲ್ಲಿ ಜುಡಿಷಿಯಲ್ ಮೆಂಬರ್ ಸ್ವಾಮಿ ಇದು.
My lord, this is a
Yes, tomorrow.
my lord, this is a WP service matter. It has been pending since 6 years before your lordship.
What is that matter?
It's a service matter, my lords.
All are service matter only. Yes, 17th. Yes.
Service matter, petitioner is daily wager, my lord. They have not
Yes.
confirmation their order, my lord.
17th. Yes.
ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ ಇದರಲ್ಲಿ ಜುಡಿಷಿಯಲ್ ಮೆಂಬರ್
Pending. Yes, 17th.
ಸ್ವಾಮಿ ಸರ್ವಿಸ್ ಮ್ಯಾಟ್ರು ಜುಡಿಷಿಯಲ್ ಮೆಂಬರ್ ಇದರಲ್ಲಿ ಅರ್ನರ್ ಲೀವ್ ಹಾಕೊಂಡಿದ್ರು, ಅದ್ರ ಮೇಲೆ ಅವರು ರಿಸೈನ್ ಮಾಡಿದ್ದಾರೆ, ಈಗ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಕ್ ಬಿಡ್ತಾ ಇಲ್ಲ, ಇದು ಆಗ್ತಾ ಇಲ್ಲ, ಹಾಗಾಗಿ ಅರ್ಜೆನ್ಸಿ.
Yes. Read this matter on 10th. Yes.
The retired employees for the gratuity amount of not
Yes, 16th. Yes.
Terminated from the service, 2023 matter.
17th. Yes.
This is D matter, my lord. Dishonorable court granted interim order due to pending of this promotion was withheld. P group.
Yes, 18th.
18th September.
Allowed. Yes, 11th.
One more fresh matter is there, my lord.
Fresh matter.
Oh, fresh.
Fresh matter.
ಅಲ್ಲ ಅದು 5000 ಫ್ರೆಶ್ ಇಲ್ಲ ಸರ್. ಆಯ್ತು ನೋಡಿ ಫ್ರೆಶ್ ಇದ್ರೆ ಕೊಡಿ.
Yes, 4th.
Short,
Pension. Yes, 12th.
lords, it's a pending matter. A short question of mandamus is involved. Considering my representation, they have not replied back.
Yes, 12th.
Lords,
during the pendency, juniors are being promoted.
Promotion. Yes, 17th. Yes.
lords, this,
22 lot.
matter, I have sought an area for direction, may be posted on
Direction of what?
lords, direction to consider to whether I have whether I should be posted in the place or not.
Yes, 16th. Yes.
Great.
Matter for B group, my lord, matter of 2017. But the petition has been terminated, my lord, without any.
17th. Yes.
This is fresh matter, my lord.
Fresh matter tomorrow. Yes.
ಇದು ಫ್ರೆಶ್. ಸರ್ ಅಡ್ಜರ್ಮೆಂಟ್ಸ್ ಇಫ್ ಎನಿ ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಅಡ್ಜರ್ಮೆಂಟ್ಸ್.
Serial of
Serial number 4, my lord. You got directed, my lords, to find out where what is the vacancies in the my lord's service. My lords, I have applied for in RTA, my lords. We did not get this my lord's report. But after 2 weeks, my lords, any date.
Yes, at the request of counsel for the petitioner, leaves this matter after 2 weeks.
Yes.
My lord,
20.
serial number 37, my lord. I'm for R2, seeking a short accommodation.
30?
37, serial number 37. I'm for R2, my lord. Any date,
37, you are appearing for respondent number.
R2, my.
Have you informed the petitioner?
R2 served unrepresented.
R2 ಯಾರು ಇಲ್ಲಲ್ಲ, ನಿಮ್ಮ ಹೆಸರೇನು?
My lord, Vamshi Krishna is the advocate.
R1.
R1, sorry, my lord.
No, that have you informed other side? You
I'll
informed that?
intimate the other side, my lord. If
Yeah, after that you move that matter. Yes.
My lord,
Serial number 16, my lords.
serial number 4 was urgent, my lord. He had not informed me. And in that matter, actually, they were supposed to answer on the last occasion because it's a frivolous writ petition, my lord. Some date may be given. That is all I'm requesting.
Yes, anyhow, there is no any interim order or anything.
Nothing. They were required to answer. Otherwise, they have no case.
Yes, this on third.
Please.
Yes.
Great.
Lord 20, my lord.
Serial number
Request
16,
Time
my
as
lord.
senior is not
Serial
in
number
town.
16.
16, my lords, there are multiple matters, connected matters in that. I am representing on behalf of the fifth respondent, my lords. Request for a week's time. I am not keeping
Have you
well.
informed?
It is for the arguments from our side, my lords. In fact, the petitioner had commenced their arguments. It is for us to
No, have you
listen.
informed other side?
I'll inform Mr. Subramanya Bhatt, my lords.
No, first you have to be informed and then move that.
In fact, I tried calling him, my lords. His phone was not answerable. In fact, I'll right away I'll inform him, my lords. Once again, I'll
Yes.
inform.
When
A week's
the
time, my
matter-
lords.
No, when the matter is called, you can mention that. Yes.
Very well. Grateful.
20, my lord. Serial number 20. Request a week's time as senior is not in town, my lord.
20, you are appearing for?
A petitioner.
Yes, at the request of counsel for the petitioner, leaves this matter after 2 weeks.
Serial number 36, Your Lordship.
Obliged.
Applying for the petition on this matter, we have informed the respondent counsel.
36,
Please, Your Lordship. Seek 2 weeks
the request
accommodation.
of counsel for the petitioner, leaves this matter after 2 weeks.
So date may be fixed, Your Lordship.
2 weeks. 16th, yes.
Actually.
In VC, adjournments if any. List number 1 for preliminary hearing, Deepak M for petitioner.
ಅಪಿಯರ್ ಫಾರ್ ಪಿಟಿಷನರ್ ಸ್ವಾಮಿ. ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಎಲ್ಲ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಇದೆ ಸ್ವಾಮಿ, ಇದು ಎಲ್ಲ ನೋಟಿಸ್ ಆಗಿದೆ.
ಏನ್ ಮ್ಯಾಟರ್ ಅಪ್ಪ?
VRS ಆಗಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ಬಿಟ್ಟು, VRS ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ಬಿಟ್ಟು ಹಾಕಿರೋದು.
In VRS issue it mandamus appropriate response to pay the petitioner outstanding compensation along with that interest of 12%. ಏನಕ್ಕಪ್ಪ interest? ಏನ್ರಿ, what is this, Mr.
My lord, the second and third respondents, they were working in Mysore paper mills, my lord. They have voluntarily retired. The retiral benefits are not given. That is the reason.
Yes.
Second round of litigation after the contempt was closed, my lord.
Yes, issue emergent notice. Government advocate is directed to take notice for respondent number 1. Counsel for the petitioner is directed to serve 1 set of copies, emergent notice to 2 and 3.
Serial number 2, Sandesh Shetty.
Yes, Mr. Sir.
Lord, in respect of the grant-in-aid school, petitioner is the petition number 1 and 2 is the grant-in-aid high school. And there was a vacancy accrued in respect of Kannada teacher. And subsequently, government has granted the permission and a representative was also sent and interview was called, interview was conducted, 7 members were participated. In the interview, the petition number 3, she has secured more marks and she has been appointed as the Kannada teacher and the proposal was sent to appropriate authority for the approval. But authorities have written back the proposal stating that, my lords, in annexure M, my lord, page number 28, assigning the reasons that ಉಲ್ಲೇಖ ಒಂದು ಷರತ್ತಿನ ರಾಜ್ಯ ಜಿಲ್ಲೆ ಪ್ರಚಲಿತ ದಿನಪತ್ರಿಕೆಗಳಲ್ಲಿ ಪ್ರಕಟಿಸಿರುವುದಿಲ್ಲ. In the Kannada Prabha, we have the publication is made and consequent to publication, permission is given and representative from the authorities have come to the participated in the interview also.
Yes, you take notice. Or issue notice. Government advocate is, all government advocate is directed to take notice 1 to 5. Counsel for the petitioner is directed to serve 3 sets of copies and.
Published.
Serial number 3, Srinivasa K for petitioner. A. Chandrachud.
Lordship recollects, this is the matter wherein even in the first round, we had submitted papers through software, that is by the pen drive and as well as sort. But after your lordship told us, they just told us which are the documents which they again require. In fact, my respectful submissions on instructions is that we had already supplied those papers.
No.
But I will make it clear, once again, I have brought it before your lordship. And I will, ಇಲ್ಲಿ ಸಂಪೂರ್ಣವಾಗಿದೆ ಸ್ವಾಮಿ. ಇದರಲ್ಲಿ ಒಟ್ಟು 9,800 ಪೇಪರ್ಸ್ ಇದಾವೆ.
ನಿಮ್ಮ ಹತ್ರ ಇರೋ ಪೂರ್ತಿ ಕೊಟ್ಬಿಡಿ.
ಪೂರ್ತಿ ಕೊಟ್ಟಿದ್ದೀನಿ. I was really shocked that senior counsel ಹೇಳಿದ್ಮೇಲೆ ತಾವು ಹೇಳಿದ್ಮೇಲೆ I made my complete endeavor. ಸಂಪೂರ್ಣವಾಗಿ ತರಿಸಿದ್ದೀನಿ. Let there not be again a question mark on us that we have not supplied. ಇದರಲ್ಲಿ ಅವರಿಗೆ ಒಂದು ಲಿಸ್ಟ್ ಸಹ ಹಾಜರುಪಡಿಸ್ತೀನಿ. ಏನೇನು ಪೆನ್ ಡ್ರೈವ್ ನಲ್ಲಿ around 6,000 papers are there. 2,200. Almost 400 papers have already been given, which has got an acknowledgement. We have served on it.
R1 to R64, some other documents according to us.
No, now you see, making a submission that all documents has been furnished or not. Yes.
ಅಲ್ಲ ಲಿಸ್ಟ್ ಪ್ರಕಾರನೇ ಅವ್ರು ಹೇಳಿದ ಲಿಸ್ಟ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಏನ್ ಲಿಸ್ಟ್ ಹೇಳಿದ್ರು ಅದೇ ಲಿಸ್ಟ್ ಪ್ರಕಾರ
page 70.
No, you see that whatever is produced.
ಲಿಸ್ಟ್ ನೋಡಿ ನೀವು ಕೊಟ್ಟಿರೋ ಲಿಸ್ಟ್ ಅದು.
ಸಾಫ್ಟ್ ಪ್ರತಿ 1 to 7 ಅಂತಿದೆ. I believe
each time they cannot start doubting the department.
I believe, my lord, my learned friends
record that you have received all the documents, hence writ petition is disposed of. Yes.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಇವಾಗ ನಾವು ಅವ್ರಿಗೆ ಫೈನಲ್ ಶೋಕಾಸ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ವಿ ಎನ್ಕ್ವೈರಿ ಆದ್ಮೇಲೆ. ಬೇಕಾದ್ರೆ 4 ವಾರ ತಾವು ಟೈಮ್ ಕೊಡಿ ಅವರಿಗೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಲಿಕ್ಕೆ. Then we will proceed based considering their objections to pass orders here. One more submission make. It's a government institution, almost 9,000. ಇವಾಗ RTI ನಲ್ಲಿ ಅವ್ರು ಹಾಕಿದ್ರು ಅವ್ರಿಗೆ ಹಣ ಬರ್ಸ್ಬೇಕಾಗಿತ್ತು. Let them be some penalty so that everything at the hands of this court by way of a writ petition, they're trying to procure papers.
No, my lord, he is made scapegoat.
No, you know that your colleague has a matter.
Not a group D employee. There are
adu gottu.
There are other persons.
My senior
there are
is
other persons who are
at least
responsible.
the government could be at least RTI ನಲ್ಲಿ ಹಾಕಿದ್ರುನು 3 rupees.
I will record that hereinafter he should not file any petition seeking that there is no documents has not been filed.
Yes, ma'am. I will be deeply obliged.
One submission by way of reply, ma'am. There are other persons, my lord, who are responsible. This man was appointed as group D employee.
ನೀವು ಎನ್ಕ್ವೈರಿ ಹೇಳಿ ಅದಕ್ಕೂ ಇದಕ್ಕೂ
ನಾವು
ಅಲ್ಲ ಇವನ್ ದಿ ಪೆನ್ ಡ್ರೈವ್ which is with ಇದು ತಮ್ಮ ಮುಂದೆನೆ ಒಂದು ಇದನ್ನ ಲಿಸ್ಟ್ ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ ಯಾವ್ದೇ ಪೆನ್ ಡ್ರೈವ್
after completion of enquiry final show cause notice has been issued, my lord.
Now you have to give a reply for that.
Yes
sir. Pen drive is also handed over to my senior.
Learned senior counsel appearing for the petitioner as a main grievance that
even the entire hard copies will be handed over.
The final notice has been issued. After that enquiry, second show cause notice has been issued. The petitioner has requested the respondent corporation to furnish all the relevant documents which has been relied upon by.
Not ink page 70, man.
Yes.
1 to 12.
Records which has been relied upon by that enquiry officer to submit a report. That copy has not been furnished to the petitioner.
Special audit report, my lord, at page 70.
Yes,
mentioned
petitioner to submit his reply to second show cause notice. Today, learned counsel appearing for that respondent has furnished. Eshtiದೆ paper adu?
ಒಟ್ಟು 12 ಅವ್ರು ಏನು ಲಿಸ್ಟ್ ನಂಬರ್ 17 ನಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 17 ನಲ್ಲಿ
has been requested by the petitioner has been furnished
as per page number 70 of the writ petition paper book here.
Page, kindly quote that, my lord.
Annexure
page 70, my lord.
70
1 to 12.
The same thing. Now what the list what I have just
which has been sought.
ಆ ಲಿಸ್ಟ್ ನಲ್ಲಿ ಅದೇ ಇದೆ ಸ್ವಾಮಿ.
Item number 1 to 12 along with that all other documents, hard copy as well as soft copy has been.
Even the list is also produced.
Yes, furnished to that petitioner in the court itself. Other relief fought by the petitioner will not survive for consideration at this stage. Accordingly, the writ petition is disposed of. Petitioner is permitted to submit a reply to that second show cause notice within 4 weeks from today.
4 weeks from the date of receipt.
ಅಲ್ಲ ಫ್ರಮ್ ಟುಡೇನೇ ಇರ್ಲಿ ಸರ್. ಇವತ್ತು ನಿಮ್ಗೆಲ್ಲ ಕೊಟ್ಟಿದೀವಲ್ಲ ನೀವು ನೋಡ್ಕೋಬಹುದು.
Within 4 weeks from today. Thereafter, the respondent can take any decision in accordance with that
And
observation.
my lord, all contentions may be kept.
At this stage, it need not be. Yes, all that contentions of the parties are.
With respect to documents, there another one more litigation. This is the second litigation seeking documents only. Your Honor.
Because they have not supplied, because of my learned friend's intervention, my lord, it has been supplied.
I said in respect of other prayer is concerned, it is not necessary to consider. That means to say this prayer for documents is over.
Yes, my lord.
Yes.
It can be ಮತ್ತೆ ಬಂದ್ರೆ
ಇಲ್ಲ ಇಲ್ಲ ಆ ತರ ಎಲ್ಲ ಮಾಡೋದು.
ಕೋರ್ಟ್ ನ ಬರೀ ಡಾಕ್ಯುಮೆಂಟ್ ತಗೊಳ್ಳೋದಕ್ಕೋಸ್ಕರ RTI ನಲ್ಲಿ ಹಾಕಲ್ಲ.
It has been supplied in the court itself.
Deeply obliged.
Yes. Highly obliged.
Yes. Serial number 4 adjourned. Serial number 5 Akshay Ramachandra Uttar.
In this matter, my lords, the petitioner is seeking a writ of mandamus. She is the wife of a late SDA employee, Mahanagar Palike Shimoga, my lords, who passed away due to COVID in the year 2021, specifically 18/6/2021. Therefore, like there is a government notification to the effect that all ex-government employees who passed away from COVID have to be granted compensation. To that effect, my lords, the lordship will find that Annexure B, there is a recommendation by the R2 to R3, my lords.
Where is that government circular?
Lords, it is referred to in Annexure B, my lords.
Yes.
Annexure B, page 12 onwards, lordship will find that this notification, it particularly refers to that government notification by reference number 278/2020, my lords. In that notification, lordship will
read
notice. In this, my lords, they specifically say that this person has passed away due to COVID, and thereafter 30 lakh has to be granted to the employees, my lords, from the urban local bodies. So,
ಆಯ್ತು ಆಮೇಲೆ ಏನಾಯ್ತು?
ಆಮೇಲೆ ನಾವು ಎರಡು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ. Annexure C and D. I am before your lordship seeking consideration of the same because it's not been considered.
Heard. Issue notice. Government advocate is directed to take notice for respondent number 1 and 2. Why you made the respondent number 4 as 40? Who is that? Vidyashri.
Vidyashri is the daughter of this petitioner before your lordship. Is the second wife of this person, my lords, the ex-government employee. First wife passed away, after which she has married this person.
She is first wife's daughter.
The first wife's daughter. And in fact, she has taken compassionate appointment in terms of his ex-spouse.
Let her come, then we'll decide who is entitled. Yes. Subramani is there. Subramani is directed to take notice for respondent number 3. Issue emergent notice to respondent number 4. Counsel for the petitioner is directed to serve 2 sets of copies on government advocate and 1 set on Subramani. Yes.
Brief.
Serial number 6 Narayana Bhatt Mover.
Appear for the petitioner, my lord. My lord, the petitioners, my lord, are the bailiffs and process servers of Hassan district. My lord, this is a very peculiar situation, my lord, which has arisen now. My lord, so far they were required to mark their attendance once in a day. My lord, Hassan, my lord, is a clustered villages district, not like, my lord, Chikmagalur or South Canara. In South Canara, my lord, a bailiff is required to mark his attendance twice a month. My lord, because the villages are not clustered. In Hassan, my lord, they were marking once in a day. This is because, my lord, they are required to reach the village before 8 a.m. And after 8 a.m., my lord, people go for work. My lord, mostly agriculture laborers. So in the households, my lord, there won't be anybody. Otherwise, my lord, they have to wait up to 6 p.m. And only at 6 p.m., my lord, they come. My lord, the traveling allowance provided to them is meager 500 rupees. My lord, in a day's travel, my lord, they incur expenditure for bus ticket. My lord, amount ranging from 50 to 100. And my lord, it breaches this 500 rupees, which is abysmally very low. And my lord, Now what has been required to be done is mark their biometric twice a day, mark their physical attendance in the court twice a day. My lord, there is a practical difficulty. They gave a representation, my lord, there is a practical difficulty, and they also cited, my lord, in other districts, it is like this. So far, my lord, from time immemorial, my lord, it is only once a day. My lord, they come in the morning, they mark their attendance, they go serve, my lord, they return. When they return, my lord, it would be past 8 p.m.
No, suppose you will come in that morning as usual at 9 o'clock.
Please, my lord.
You will mark it. See, you will go to that field. Then you have to mark it by 5 o'clock.
Yes, my
Come
lord.
back at 4. You show that work progress will not be there. Then they will realize.
My lord, this is the practical.
They want that particular rules. You go there because now that they have given the meter and all, where they have reached and all, they will go there, they will take the photos, nobody is available, let them come back. Then they will realize that which is the practically
My
workable.
lord, then they have been warned that they would be subject to disciplinary proceedings. And my lord, this equipment which has been given, my lord, is a 2G SIM of a BSNL. My lord, in most of the villages, BSNL signals won't be there.
No, suppose if that party is not available, you can't serve. What will do? You will come and report. You do your work. Go after 9 o'clock. Come back 4 o'clock.
My lord, your lordship may kindly turn to page 33, my lord. This is the statistics of April 2025, before this was introduced. Your lordship may kindly, the last column, remarks. It is all performance is 100%.
Take notice, yes.
My lord.
Let us see what is that rule and why they have insisted and all. You take hand summons. Yes. Government advocate is directed to take notice for respondent number 3. Yaru Vidulata. PV Vidulata is directed to take notice for respondent number 1 and 2. Counsel for the petitioner is directed to serve 2 sets of copies on Vidulata and 1 set to government advocate. You serve a copy?
My lord, I'll serve it today itself, my lord. Your lordship may give some date, my lord, at the earliest.
Yes, leave this matter on 4th. 4th, yes.
My lord, I have sought for an interim order, my lord.
Now we'll see what is the law, that if law says that they have to be attended morning and evening, I can't bypass that law.
My lord,
they are seek for an amendment.
My lord,
the rule says
there is no such rule, my lord, as far as the process.
I think there is a rule. All employees has to be, given a biometric in the morning and evening. If that is there, unless it is relaxed, I can't do that. Let us see that. We'll ask them. I think it is there in that High Court also.
My lord, High Court, your lordship may kindly see, my lord, in especially my lord, board branch. My lord, they are required to stay up to 8 o'clock. My lord, that compensatory thing, my lord, while coming in the morning, my lord, there is a relaxation. That's what, my lord,
Let us see,
I was informed.
Is there any such power and all? We'll see that. Unless somebody has to brought to the notice, what is that? Even you have not brought to my notice, what is the
My
rule?
lord, I searched, except in the civil rules of practice. My lord, there is no other.
I think circular may be issued by the
Maybe some circular, my lord,
I
I
have
could.
given a hand summons to that, notice to that council who is taking
Please.
High Court, representing that High Court. Let us see. We'll ask them.
Let it be listed in the preliminary hearing list, my lord.
Yes, in the preliminary hearing.
Much obliged.
Yes, dispensation for a period of 4 weeks.
Much obliged.
Seal number 7, Saraswati M.
Petitioner in
Yes.
this matter. My lord, the petitioners were appointed as Bandhu P1s, my lord. Immediately after appointment, they have been removed from the said appointment, my lord, without any reason, my lord.
Working as?
Bandhu P1. Bandhu P1 in the 4th respondent office, my lord. ADLR office, my lord.
Yes. Where is your appointment order?
Appointment order is Annexure D, my lord.
E.
D.
Yes.
On
The
5th
agency
May,
network.
they are being appointed, my lord.
No, what is this Kanti agency and all?
Please, my lord.
No, appointment order issued by that agency.
Agency, my lord, on the
Not
based
been
on
appointed
the
by the government.
based on the tender notification, my lord. Afterwards,
Tender notification is called through that.
the agency only. my
It
lord.
is for the agencies to that government. You have no this thing relationship with that government.
No, my lord, that agency has been removed them, my lord, not the government, my lord.
You have to file in a case against that agency, not that
I have made
Government.
party here also, my lord. They have been made party here also, my lord.
No, how can you maintain a writ to seek any direction against that agency, madam? Is it issued by that agency? Is it, Mr.?
Please, my lord, the writ is not maintainable because the appointment is by a private agency.
And then relief is also against.
Not maintainable.
You have to go to that civil court, madam.
The
Or,
contractual appointment. But between the
Yes.
petitioners and the agency.
Yes.
My lord, the respondent number 4 has nothing, has not stated anything about the.
Even the-
ಆಯ್ತು, ಅದಕ್ಕೆ ಸಿವಿಲ್
qualification.
ಕೋರ್ಟಿಗೆ ಹೋಗ್ಬಿಟ್ಟು ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕಿಲ್ಲ. ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಓನ್ಲಿ ಅಗೇನ್ಸ್ಟ್ ದ ಸ್ಟೇಟ್ ವಿ ಕ್ಯಾನ್ ಎಂಟರ್ಟೈನ್. You can challenge before that civil court. There they will see what is the contract between you and that agency. Then whether there is a violation, then they will pass an order. Yes. Learned
Liberty.
government
may be-
advocate outside.
Liberty may be issued.
Outside submitted that the writ petition filed by the petitioner is not maintainable. They are challenging that order passed by the private agency and seeking any relief against that private agency. In view of the above writ petition is dismissed, reserving liberty to the petitioner to approach appropriate legal forum.
Pending application.
All pending applications are disposed of.
Office objection, first time matter, serial number 8, P. Prasanna Kumar.
That's for the petitioners in this case. Because office has raised two
Private
objections.
agency, it is not an estate. Private agency, it is not an estate under Article 12 and that.
Lord, office has raised two objections, my lords, out of which all advocates have to sign vakalat, which have complied. The second objection is with regarding to certified copy of the annexure impugned, my lords. I may be granted liberty to file dispensation, my lords. Your lordship may overrule it in the interregnum. I have applied for certified copy.
You furnish it, yes.
Please, my lords, in the meantime, I'll file dispensation. Your lordship may post it in preliminary hearing. There is an urgency in this.
No, when do you want?
My lords, your lordship may have it on Friday or.
No, by the time you have to comply that office objection.
Please, my lord. That is, my lord, that is why I'm seeking
2
the
days.
leave of this court to grant liberty to file dispensation, IA.
No, there need not be any leave. You can file it.
Please,
Yes.
please.
2 days time is granted to comply office objection.
And my lord, if complied, post it in,
No, if complied, post this matter for preliminary hearing.
please.
Serial number 9, Govardhan S.
Yes,
Serial number 9, Govardhan S.
yes, none appear. 4 weeks time is granted to comply office objection.
Serial number 10, Shivashankar.
My lordship, kindly at 2:30, my lordship, 2:30, will engaging senior counsel, RS Ravi sir, my 2:30.
Court fee to be paid.
Paid
Each
ಮಾಡಿದೆ, my
case,
lordship, pay ಮಾಡಿದೆ.
Annexure to be marked as a series at each series at that attested. Attestation ಮಾಡ್ದಾನೆ
ಎಲ್ಲ ಮಾಡಿದೆ, my lordship, true copy notary ಮಾಡಿದೆ, my lordship, notary ಮಾಡಿಸಿ attested ಮಾಡಿಸಿದೆ, my lordship. All annexures had been attested ಮಾಡಿದೆ, my lordship.
addresses for the service to be stated at the end of the writ petition.
Yes.
Name made parties to the writ petition has to be clarified. Both commissioners seal to be attested to
ಅದು
all annexures.
ಅಲ್ಲೇ ಆಲ್ annexures ಗಳಿಗೆ notary ಮಾಡಿಸಿದೆ, my lordship. ಮತ್ತೆ ಅದು registry raising the objection oath commissioner ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ, my lordship.
You comply it tomorrow.
My lordship, 2:30 ಗೆ ಬರ್ತೀವಿ,
No,
2:30
if
pass.
you are not complied, I will not take that matter. If you are complied, then only.
Because what happened today is the last date, my lord. Your lordship has the last date, my submission on 14th, my lordship. Today is relieving, my lordship, today.
No, but you have to, without complying that, how can I entertain matter? Without both commissioners signature and
My lordship, kindly
notaries. If
pass
there
on
is an urgency, you have to comply that.
No, my lordship, kindly pass on, my lordship. Now only I will comply it, my lordship.
Yes, pass or if you have complied, then only. Don't think that without compliance. See, dispensation, legible copy, all that we can be excused, but notary signature illa, both commissioner signature illa, annexures is not.
Notary ಇದೆ, oath commissioner ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ, my lord. Notary ಮಾಡಿಸಿದ್ರು, my lordship.
You have to comply all objections, otherwise will not take. Yes.
Office objection, second time, serial number 11, Kamparaju.
For the petitioner, sir, the copy on BESCOM, my lords.
Hmm.
It's in identical matters. Yesterday,
Yes.
notice was.
What is this, Mr.? What is this matter?
My lords, this is a matter where petitioner's marks cards, my lords, were
Yes, notice yesterday, yes. Issue emergent notice. Government ilva?
Government 345, my lords. Respondent number 3, 4 and 5.
Government advocate is directed to take notice for 3 to 5. Counsel for the petitioner is directed to serve 2 sets of copies on government advocate. Issue emergent notice to 1 and 2.
Office objections.
Objection may be overruled.
Yes, submission is accepted, office objection is.
Plus, there are two more connected matters. I'll give the number. It may be connected, my lord.
Call this matter along with that. Notice ಆಗಿದೆಯಾ ಅದರಲ್ಲಿ?
ಆಗಿದೆ.
Yes, along with that so and so.
For orders, serial number 12, Arshita KV, Raj,
Appearing for
Dayanand PA,
Yes.
rupees 2,000 rupees cost was imposed for non-compliance of
Non-compliance of office objection, scrutiny, paying cost. Complain ಮಾಡಿದೀರಾ?
office objections have been complied and I paid the cost to the
ಅಷ್ಟ ಆಯ್ತು. Complain ಮಾಡಿದೀರಾ office objection?
complied.
Serial
Okay,
number.
the annexure, they have sought for the legible copy of one annexure, my lord. That
Underlined to be
annexure,
removed from that page number 23. ಎಲ್ ಮಾಡಿದಿರ್ರಿ? ಸುಮ್ನೆ ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳ್ತೀರ. There are other office objection, 8 office objection. ಸುಮ್ನೆ ಒಂದು ಟೆಸ್ಟ್ ಮಾಡಿದ್ದೆ. Not complete.
one annexure they have sought for the legible copy. That legible copy is not available with me, my lord. That is
No,
the.
there are 8 office objection. Have you seen that? In spite of imposing the cost, you are not seeing that file. See, first is underlining to be removed from the page number 23. I just open that page number 23. All underlines are there. You don't know what is that office objection itself. You office ಗೆ ಹೋಗಲ್ಲ ಯಾರು? Yes. Go and correct it. Yes. At the request, finally, week's time is granted to comply office objection.
serial number 13, Saraswati M,
Yes. What is that office objection?
Annexure
Better
A,
typed
legible
copy
copy.
of annexure
I will
A to be
furnish
filed.
it. I will furnish it, my lord. Any date may be fixed.
Yes. What is this matter, madam?
My lord, that petitioner was appointed as a waterman, my lord. In 2017, at the time of cleaning the tank, he got injury, my lord. Due to that injury, he was not able to attend the work, my lord. After that, after getting cured, he went to the office and they sought for the appointment, my lord. They refused, my lord. Till today, they have not been taken to the duty, my lord.
Where you are working?
Working PDO Vannudke Grama, Tumkur district, my lord.
Where is your appointment order?
The annexure A itself, my lord.
So and so ನೌಕರರಿಗೆ ತಾತ್ಕಾಲಿಕ ಅನುಮೋದನೆ ನೀಡಲಾಗಿತ್ತು. You have been appointed on when?
2006, my lord.
Then after that, what has happened?
Till 2007, he has been regularly attending the work, my lord. In 2017, at the time of cleaning the tank, water tank, he sustains injury to his leg, my lord. Due to that, he was advised to take rest, my lord. After that, after 2-3 months, he went back, my lord. Then he was refused to take to work, my lord. After he has given so many representation for seeking.
ತಿಳಿಸಿದ್ದೇನೆ. ವರದಿ ಮಾಡಿಕೊಳ್ಳಲು ಬಯಸಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಸದರಿ ನೌಕರನ ಕರ್ತವ್ಯ ತೆಗೆದುಕೊಳ್ಳಲು ಈ ಮೂಲಕ ತಿಳಿಸಿದ್ದೇನೆ. There is a direction to that.
After that also, they have not been taken to work.
Yes, you are there, Mr. Gram Panchayat. Yes. Government advocate is directed to take notice for respondent number 1. Deputy Commissioner Jilla Panchayat ಎಲ್ಲಿ ಬರ್ತಾರೆ?
Yes, ಅದು ಡೆಪ್ಟಿ ಸೆಕ್ರೆಟರಿ.
Deputy Secretary ಅಲ್ಲ.
ಡೆಪ್ಟಿ ಸೆಕ್ರೆಟರಿ ಅಂತ.
Commissioner ಅಲ್ಲ, ಸೆಕ್ರೆಟರಿ ಮಾಡಿ. Government advocate 1.
Yes, ಆದ್ರೆ
Assistant Commissioner ತಾಲೂಕ್ ಪಂಚಾಯತ್ ಬರಲ್ಲ ಮೇಡಮ್.
ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಆಫೀಸರ್ ಆಫ್ ತಾಲೂಕ್ ಪಂಚಾಯತ್.
What is this, madam? Panchayat development officer. Correct ಮಾಡಿ ಅದನ್ನ first. Yes.
2, 3, 4 ನಾವೇ.
ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ಗೆ ಚೀಫ್ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಆಫೀಸರ್, ತಾಲೂಕ್ ಪಂಚಾಯತ್ಗೆ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಆಫೀಸರ್. ಪಂಚಾಯತ್ ಕರೆಕ್ಟ್ ಮಾಡಿದ್ದೀರಾ? ನೀವು 2, 3, 4 ಗೆ you will take notice, Mr.
Please.
Yes, Nagarajappa is directed to take notice for 2, 3 and 4. Counsel for the petitioner is directed to serve 1 set of copies on government advocate and 2 sets on Nagarajappa. Correct ಮಾಡಿ ಈಗಲೇ. ಅವ್ರು ನಾಗರಾಜಪ್ಪ ಹತ್ರ ಕೇಳ್ಕೊಂಡು ಮಾಡಿ ಅಲ್ಲೇ. Yes. Yes, submission is accepted, office objection is over.
The group matter, serial number 14.
That I am appealing for the
Submit
petitioner.
for petitioner.
That certain documents was filed by my learned friend.
Yes.
My lord, without filing statement of objection. My lord, we are disputing those documents. For the reasons, my lord, according to me, my instruction, that all the documents are fabricated, my lord. Let my
By
learned friend,
objection, by
let,
affidavit.
let him by way of an affidavit.
My
I will
lord,
counter that. my lord.
What is produced, his own signature is there in the service records. The only issue is whether he was appointed in 2003 or 2006. But along with the memo, the documents which are furnished, your lordships may kindly see the memo. man.
Yes.
ನಾವೇನ್ fabrication ಅಲ್ಲ ಅವರು
Government not produce.
ಗವರ್ಮೆಂಟ್ ಅವ್ರಿಗೆ ಹೇಳ್ತಾ ಇರೋದು ನಿಮ್ಗಲ್ಲಪ್ಪ.
And what is this matter?
Fabrication
My lord,
According
to be
to me, the
admitted to
date of-
grant-in-aid, he should have been appointed in the year 2003 and not 2006. man. So, as per the service records which I have produced, which he has also attested, my lord.
My contention is, my lord, he has joined.
Any of that you file it by objection.
Please, my lord, that's yes. Swearing to an affidavit, then my
Yes.
lord, I will file my count.
Learned government advocate granted 2 weeks time to file objection. Let us.
Lord, there is an order, my lord, directing me to produce the service, original service register. My lord, by a notice, my lord, the department has obtained that book from the management. Therefore, my lord,
Let us see, first let them file.
That is
then
what we have produced, my lord, after obtaining the records from them.
Let him place it on.
ಅಲ್ಲಿ ನಮಗೊಂದು ಡೈರೆಕ್ಷನ್ ಇದೆ, ಇವ್ರ ಕಾಪಿ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ, ಹಾಗಾಗಿ ಕಷ್ಟ.
ಅದೇ ಈಗ ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ then your presence is not necessary for yes.
Serial number 15, Manjunath Prasad V for petitioner. Yes, sir, Rupesh Kumar.
Not petitioner was got appointed as a Hindi assistant teacher on temporary basis. Annexure A, please, your lordship, in page number 14, please. And the aided school has recommended her name to regularize her name for the appointment of the assistant Hindi teacher. By that time, the annexure J, please, your lordship, in page number 28. The DDPI authorities have issued an endorsement saying that she is not eligible for the appointment of assistant Hindi teacher since her qualification is not appropriate and age cannot be relaxed. Already she crossed 32 years general merit candidate, 32 years. As such, they issued an endorsement. By challenging the same, the present petition has been filed. In this regard, I would like to call the attention of your lordships on ink page number 31, please, your lordships. A notification issued by the state government.
You read that endorsement.
Please, your lordship. Endorsement ink page number 28, please, your lordship, annexure J.
That is that you are challenged, annexure J na?
Yes. Shall I proceed, your lordship?
ಏನು ಪ್ರಯರ್ ಅಲ್ಲಿ ಇಲ್ಲ, ಮ್ಯಾಂಡಮಸ್ ಕೇಳಿದ್ದೀರಾ?
ಇಲ್ಲ, my lordship.
You are not challenging that. Yes. What is that endorsement? Read.
Endorsement, I may permitted to read out. ಮೇಲ್ಕಂಡ ವಿಷಯ ಮತ್ತು ಉಲ್ಲೇಖ ಸಂಬಂಧಿಸಿದ ಖಾಸಗಿ ಅನುದಾನಿತ ಪ್ರೌಢಶಾಲೆಯಲ್ಲಿ ಆಡಳಿತ ಮಂಡಳಿ ವತಿಯಿಂದ ತಾತ್ಕಾಲಿಕವಾಗಿ ನೇಮಕಗೊಂಡು ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ಶಿಕ್ಷಕರಿಗೆ ನೇರ ನೇಮಕಾತಿ ಸಂದರ್ಭದಲ್ಲಿ ವಯೋಮಿತಿ ವಿನಾಯಿತಿ ನೀಡುವ ಕುರಿತಂತೆ ಉಲ್ಲೇಖ 1ರಲ್ಲಿ ಸ್ಪಷ್ಟೀಕರಣ ಕೋರಲಾಗಿತ್ತು. ಅದರಂತೆ ಉಲ್ಲೇಖ 5ರ ರೀತಿಯ ನೀಡಲ್ಪಟ್ಟಿರುವ ಸ್ಪಷ್ಟೀಕರಣದಲ್ಲಿ ಸರ್ಕಾರವು ಆದೇಶ ಸಂಖ್ಯೆ ED 82 SLB 2003 ಪಾರ್ಟ್ 17/6/2006 ರಲ್ಲಿ ನಿಗದಿಪಡಿಸುವ ಅರ್ಹ ವಯೋಮಿತಿಯನ್ನು ಕಡ್ಡಾಯವಾಗಿ ಹೊಂದಿರಬೇಕಿದ್ದು ವಯೋಮಿತಿ ಸಡಿಲಿಕೆಗೆ ಅವಕಾಶವಿಲ್ಲವೆಂದು ಸ್ಪಷ್ಟಪಡಿಸಿರುತ್ತಾರೆ. ಮುಂದುವರೆದು ಸರ್ಕಾರ ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ ED 291 LBP 2015 29/9/2016 ವೃಂದ ಮತ್ತು ನೇಮಕಾತಿ ನಿಯಮಗಳ ಪ್ರಕಾರ ಅರ್ಹ ವಿದ್ಯಾರ್ಥಿಯನ್ನು ಹೊಂದಿರಬೇಕಿದ್ದು ಸದರಿ ವೃಂದ ಮತ್ತು ನೇಮಕಾತಿ ನಿಯಮಗಳನ್ನು ನಿಗದಿಪಡಿಸಿರುವ ಪ್ರಕಾರ ಹಿಂದಿ ಭಾಷಾ ಶಿಕ್ಷಕರ ಹುದ್ದೆಗೆ ನಿಗದಿಪಡಿಸುವ ವಿದ್ಯಾರ್ಥಿಯನ್ನು ಹೊಂದಿಲ್ಲದಿರುವುದರಿಂದ ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ ED 25 LGB 2017 ದಿನಾಂಕ 18/4/2017 ಪ್ರಕಾರ ನೀವು ಹಿಂದಿ ಭಾಷಾ ಶಿಕ್ಷಕರ ಹುದ್ದೆಗೆ ನೇಮಕಾತಿ ಹೊಂದಲು ಅರ್ಹರಿಲ್ಲ ಎಂಬ ವಿಚಾರವನ್ನು ಈ ಮೂಲಕ ಸ್ಪಷ್ಟಪಡಿಸಿ ಪ್ರಸ್ತುತ ಸರ್ಕಾರದ ಆದೇಶವನ್ನು ಪ್ರತಿಗಳನ್ನು ಈ ಮೂಲಕ ಕಳಿಸಿಕೊಳ್ಳಲಾಗಿದೆ. ಇನ್ ದಿಸ್ ರಿಗಾರ್ಡ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್
ಎಲ್ಲಿ ರಿಲ್ಯಾಕ್ಸೇಷನ್ ಕೊಡಕ್ಕೆ ಎಲ್ಲಿದೆ ಪ್ರಾವಿಷನ್?
annexure L, please. Ink page number 39. Age relaxations.
ಏಜ್ ಎಲ್ಲ ಅವ್ರು ಹೇಳಿರೋದು ವಿದ್ಯಾರ್ಹತೆ
ಕೊಡ್ತೀನಿ.
ಹಿಂದಿ ಭಾಷಾ ಶಿಕ್ಷಕರ ಹುದ್ದೆಗೆ ನಿಗದಿಪಡಿಸಿರುವ ಅರ್ಹ ವಿದ್ಯಾರ್ಹತೆಯನ್ನು ಹೊಂದಿಲ್ಲವಾದ್ದರಿಂದ.
Page 29, please.
Ink page
29. Relevant portion on page number 31, please, Your Lordship.
Page number
31. From para number 8. ಈ ಮೇಲ್ಕಂಡ ಅಂಶಗಳು ಹಿನ್ನೆಲೆ ಪ್ರೌಢಶಾಲಾ ಹಿಂದಿ ಮತ್ತು ಶಿಕ್ಷಣ ನೇಮಕಾತಿಗೆ ಸಂಬಂಧಿಸಿದ ತತ್ವವನ್ನು ವಿದ್ಯಾರ್ಹತೆ ಕುರಿತು NCLT ಅವರ ಅಭಿಪ್ರಾಯ ಪಡೆದು ರೂಢಿಸಿಕೊಂಡು ತದನಂತರ ಅಂತಿಮವಾಗಿ ಮೇಲೆ ಕ್ರಮಾಂಕ 7ರ ಅಧಿಸೂಚನೆ ಮೂಲಕ ಕರ್ನಾಟಕ ಶಿಕ್ಷಣ ಇಲಾಖೆ ಸೇವಾ ಸಾರ್ವಜನಿಕ ಶಿಕ್ಷಣ ಇಲಾಖೆ ನೇಮಕಾತಿ ತಿದ್ದುಪಡಿ ನಿಯಮಗಳು 2016 ದಿನಾಂಕ 23/3/2000 ಅನ್ವಯಿಸುವಂತೆ ಜಾರಿಗೆ ತರಲಾಗಿದೆ. ಈ ನಿಯಮಗಳಲ್ಲಿ ಪ್ರೌಢಶಾಲಾ ಹಿಂದಿ ಭಾಷಾ ಶಿಕ್ಷಣ ಒಳಗೊಂಡಂತೆ ಪ್ರೌಢಶಾಲಾ ಭಾಷಾ ಶಿಕ್ಷಕರಿಗೆ ಈ ಕೆಳಗಂಡ ವಿದ್ಯಾ ಅರ್ಹತೆಯನ್ನು ನಿಗದಿಪಡಿಸಿರುತ್ತದೆ. Must be a holder of a bachelor's degree not with the concerned language as one of the optional subjects, mainly Kannada, English, Urdu, Hindi, Marathi, Telugu, Tamil and Sanskrit, and must be a holder of a degree in education. Provided in case of a bachelor's degree holder who has not studied the concerned language as optional subject at the degree level, he or she shall be considered eligible if the concerned candidate is holder of a postgraduate degree in the concerned language. In case of Hindi language, assistant must be a holder of a bachelor's degree with Hindi as a major subject and must be a holder of a degree in education with the concerned subject or subject as teaching method. ಮೇಲ್ಕಂಡ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಪ್ರೌಢಶಾಲಾ ಶಿಕ್ಷಕರ ವೃಂದ ಮತ್ತು ನೇಮಕಾತಿ ತಿದ್ದುಪಡಿ ನಿಯಮಗಳು 2016 ಅನ್ನು ಹಿಂದಿ ಭಾಷಾ ಶಿಕ್ಷಕರ ನೇಮಕಾತಿ ಹೊಂದಿರುವ ಅಭ್ಯರ್ಥಿ ವಿಶ್ವವಿದ್ಯಾಲಯ ಧನ ಆಯೋಗದಿಂದ ಮಾನ್ಯತೆ ಪಡೆದಿರುವ ವಿಶ್ವವಿದ್ಯಾಲಯದಿಂದ BA ಅಥವಾ ಸಮನ್ಸ ಭಾಷೆಯಲ್ಲಿ MA ಪದವಿಯೊಂದಿಗೆ NCLT
ಏನ್ ಕ್ವಾಲಿಫಿಕೇಶನ್ ಬೇಕೀಗ?
BA and B.Ed. She got BA and B.Ed in Hindi, my lord.
ಅವರು ಈಗ ಏನ್ ಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ?
ಅದು ಈ ಸರ್ಕ್ಯುಲರ್ ವಿತ್ಡ್ರಾ ಆಗಿದೆ, my lord. ಈ ಸರ್ಕ್ಯುಲರ್ ಕೆಳಗಡೆ ಓದ್ತೀನಿ. 10th ಪ್ಯಾರಾ ಆದ್ಮೇಲೆ ಸರ್ಕಾರವು ಆದೇಶ ಸಂಖ್ಯೆ ED 25 LB 2017 dated 18 April 2007 ಪ್ರಸ್ತಾವನೆ ವಿವರಿಸಿರುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸಾರ್ವಜನಿಕ ಶಿಕ್ಷಣ ಇಲಾಖೆ ಸರ್ಕಾರಿ ಪ್ರೌಢಶಾಲಾ ಸಹ ಶಿಕ್ಷಕರು ಹಿಂದಿ ಹುದ್ದೆ ನೇಮಕಾತಿ ತತ್ಸಮ ವಿದ್ಯಾರ್ಥಿಗಳನ್ನು ಪರಿಗಣಿಸಿ ಹೊರಡಿಸಲಾದ ಈ ಕೆಳಕಂಡ ಆದೇಶವನ್ನು ತಕ್ಷಣದಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ ರದ್ದುಪಡಿಸಿ ಆದೇಶಿಸಲಾಗಿದೆ. ಮೇಲಿನ ಅಂಶಗಳೊಂದಿಗೆ ಪ್ರೌಢಶಾಲಾ ಹಿಂದಿ ಭಾಷಾ ಶಿಕ್ಷಣ ನೇಮಕಾತಿಗೆ ನ್ಯಾಷನಲ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ಟೀಚರ್ಸ್ ಎಜುಕೇಶನ್ ಮತ್ತು ವಿಷಯ ಧನ ಆಯೋಗವು ಮಾನ್ಯತೆ ಹೊಂದಿರುವ ವಿದ್ಯಾರ್ಥಿಗಳನ್ನು ತತ್ಸಮ ವಿದ್ಯೆಗಳಿಂದ ಪರಿಗಣಿಸಿ ಹೊರಡಿಸಿರುವ ಆದೇಶ ಸೂಚನೆ ಈ ಆದೇಶದ ಮೂಲಕ ರದ್ದುಪಡಿಸಿದೆ. So she is eligible for the post of assistant master as a Hindi teacher. She got the degree one subject of Hindi.
Annexure J ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲಲ್ಲ?
But this is the endorsement issued by the DDPI.
DDPI endorsement is not challenged.
DDPI issued the endorsement. We sought the direction against the DDPI to consider the representation by overruling these two. By we produced these documents.
No, ಇದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡ್ಬಿಟ್ಟು this is wrong ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನೀವು ಹೇಳಿದ್ರೆ ಮಾತ್ರ ತಾನೇ ಗೊತ್ತಾಗೋದು.
But we sought.
Then he do it once he said it is not, you are not entitled. Again, how can he say that you are entitled, mister? Unless this is quashed.
But we sought circular directing the fifth respondent institution to appoint the petitioner to the Hindi teacher post and send
ಬರಲ್ಲ ಅಂತ ಅವರು ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟ ಮೇಲೆ ಎಲ್ಲಿ ಬರ್ತದೆ ನಿಮಗೆ?
For the proposal approval to the respondent 1 to 4. We sought the direction.
Education qualification ಇಲ್ಲ ಅಂತ ಅವರು
what we sought, my lordship.
If it is wrong, you have to challenge.
My lords, what we sought to the institution, again send the proposal to the DDPI and others to reappreciate this and consider my appointment. If they have not considered, then I will challenge this.
No.
This direction is only required, my lord.
No, now there is already an order.
Yes,
I can't say directed them to do that, issue one more order unless this is quashed.
My lords, we sought Hindi teachers post and send the proposal for the respondent 1 to 4. Already they have not sent
What
the
is the
proposal in the
qualification
accordance with
required
law.
now, mister? ಎಲ್ಲಿದೆ? Which is that? What is his qualification? No, endorsement ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ದಾರೆ? ಹಿಂದಿ B.Ed ಅಂತ ಹೇಳಿದ್ದಾರಾ? ಹಿಂದಿ ಭಾಷಾ ಶಿಕ್ಷಕರ ಹುದ್ದೆಗೆ ನೇಮಕಾತಿ ಹೊಂದಲು ಅರ್ಹರಿರುವುದಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ವಿದ್ಯಾರ್ಹತೆ ಅಂತ ಏನು? What is that education qualification you required, mister?
She must have one subject in degree as an Hindi and in B.Ed she got one subject as an Hindi.
ಅವ್ರ ಪ್ರಕಾರ ನಿಮ್ದು ಏನ್ ಕ್ವಾಲಿಫಿಕೇಶನ್ ಇರಬೇಕು?
ಅವ್ರ ಪ್ರಕಾರ ಡಿಗ್ರಿಯಲ್ಲೂ ಹಿಂದಿ ತಗೊಂಡಿರ್ಬೇಕು, ಎಂಟೈರ್ ಡಿಗ್ರಿ.
Yes, mister. What is
that was withdrawn.
The qualification you require. ಆಯ್ತು, ಅದು ಏನ್ ಬೇಕು ಫಸ್ಟ್ ಹೇಳಿ ನೋಡೋಣ. ವೆದರ್ ದಟ್ ಕ್ವಾಲಿಫಿಕೇಶನ್ ವಿಚ್ ಇಸ್ ರಿಕ್ವೈರ್ಡ್, is it contrary to that circular or not? We'll see that. You get instruction, mister. ಮತ್ತೆ ಅದು ಏನಂತ ಹೇಳ್ಬೇಕಲ್ಲ, ಇಲ್ಲ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಆರ ಇರ್ಬೇಕು. ಎಸ್, ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್
My lords,
This matter after 2 weeks, yes.
it's a direction, my lords. It's an writ of certiorari. I request your lordship to direct the re-set and send the.
ಅಲ್ರಿ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ, ಆಯ್ತು ನೋಡೋಣ. ಕ್ವಾಲಿಫಿಕೇಶನ್ ಏನಾರ ಇದ್ರೆ ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಡ್ಬೋದು. If you have no qualification, there is no necessity for issuing the direction. Therefore, I want that asking to get. What is the qualification now required, under which law you have to be sure that? Yes. You said only UGC and that NCLT's qualification has to be considered. Whether he is having that qualification or not. Or you have some other this thing. You have to be answered.
I request your lordship to have the date, please.
Yes, when do you want, mister?
Next week, any date.
This
Because
matter
first week.
8th Rajana. 8th Rajana. 5th, 6th, 7th, 8th. Yes, 8th.
Grateful.
Serial number 16, Subramanya Bhattam for petitioner, connected matter, SK Ravi.
Lords, I represent on behalf of respondent number 5.
Time, mister, not well.
Request for a short pass over, my lords.
No, he asking that time in that morning itself.
Lords.
I said that let the matter is reached. He wants the time, he is not
matter
well.
date was fixed by your lordship.
What is your say? He said he is not well, he wants to have any objection.
Let them take time for reply, my lords. We'll do our submission to them.
No. Argument should be at a time. It cannot be by part. Yes.
My lords.
You have any objection? Or you have no objection to grant the time? That's what I am asking. Yes.
My lords, in that case, my lords, a short date may be fixed, my lords.
Yes.
My lords, very short.
Counsel for
maybe next
you are
week.
appearing for which respondent, mister?
Respondent number 5, my lords, in 16 as well as other 2 connected matters.
Objection ಹಾಕಿದಾರಾ ಅವರು?
Lords.
Who has to file? 16 ಹಾಕಿದೇವೆ, my lord, 16 ನಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ. 16.1 and 0.2 ನಲ್ಲಿ ಇಲ್ಲ. 0.2 ನನಗೆ ಕಾಪೀಸ್ ಸರ್ವ್ ಮಾಡಿಲ್ಲ, my lords.
Yes. Who is Harishchandran? Who is Harishchandran? It's at the request of counsel for the respondent.
Lords, it may be had on next week, my lords.
Yes, as a last chance.
The 2019 matter, that's it's an old matter.
On 29.
29.
Yes.
Very well. Great.
He is also giving a signal. See, he is not well. Yes.
Serial number 17, Srinivasa K for petitioner.
My lord, I appeal for the
K Ramesh.
I appear for the respondent number 5 and 6 in this matter, my lords. Senior is not in station, my lords, requesting to adjourn the matter.
Yes, what is this matter, mister?
Lord, this is a matter, my lord, wherein the petitioners, my lord, are working as non-teaching staff, my lord, in the 6th respondent college. They have been, my lord, working since from the year 2011 and 12 for the last 13 years. They have, my lord, paid only, my lord, the consolidated salary of rupees 13,000 to 15,000. They made representations to the respondents, my lord, that seeking for fixation of salary on as per Rule 5 of the Karnataka private institution disciplinary and control rules. So that representations, my lord, have not been considered by the respondents. No orders have been passed. In connected cases, my lord, involving the very same institution, there is already an order passed by the sub court. I filed, my lord, along with the memo. That was filed on the 2nd of February 2024. Herein, my lord,
24.
this honorable court has already, my lord, directed the respondents to adhere to the Rule 5 of the private education institution D and C rules. So that, my lord,
Yes, there is already a direction, madam.
We will take instructions, my lords. Kindly have it on 28.
Petition is allowed respondent to hereby directed to consider the representation financial hereby directing the other to the provision of the rule scale of the petitioner as applicable similarly post in the government education institution. Further directed to pay the arrears paid to the petitioner from the date of filing this petition till realization. Here that arrears 6%. Yes, madam. Same means your institution itself. Some other council has appeared.
Let's kindly have it on 28, my lords.
Not 28. We'll have it on 23rd.
Let's
Saturday. Please.
Let's-
It is covered by decision, madam. It's your
No,
own
my lords,
institution.
in fact, the subject matter is, pending before the division bench, my
I will
lords.
challenge this order. before division bench.
They have
Mine-
challenged the order, my lord,
That
but
is
no
written-
stay has been granted. I have also filed the contempt petition. Both are clubbed together, my lord, and they are coming
Now
for the
this,
hearing.
against this order, there is an appeal.
There is an appeal, but no stay has been
Senior
granted.
will be not in station this week, my
In fact,
lord.
my lord, the matter is covered by
Appeal.
SS Anand's case, my lord, which has been, my lord, held to be, Lord, this
You
is to
get
be.
that appeal to be dismissed or enforce the contempt. What is
Let there
the
be an
date?
order, let there be a similar order in this case. Because
Upayoga
why,
matte.
why, my lord, I am
Contempt aga-
submitting, since from 2019, my lord, we have not been extended with any revision. Though other, we are being punished by, for approaching this honorable court.
29th. Now, if appeal is there, even if I disposed of, no purpose will say, they will say that appeal is pending.
Your lordship, instead of 28th, my lord, I have 29.
28th. Yes. Order implement ಆದ್ರೆ ತಾನೇ covered by decision ಅಲ್ಲಿ ನಿಮಗೆ implement ಆಗಲ್ಲ.
From this order, my lord, there are several other orders. Wherein, my lord, this honorable court has already, my lord, taken a view.
Same institution ನಲ್ಲೇ there is an order when appeal is filed. It is covered by that decision. Why can't you move that appeal?
Still in the office objection stage for last 2 years. They just filed it and
Go and move that contempt.
it's being
Yes,
listed, my lord.
yes. You go and move that contempt saying that they are not complied that office objection.
Cell number 80, Mukkanappa SP for petitioner.
Will to appear for the respondent in this matter.
Yes.
But earlier, my lord, in fact, it was suggested for some kind of settlement. My learned friend, my lord, has furnished the memo of calculation. According to the memo of calculation, my lord, the total claim is 30 lakhs 36,113. And in fact, earlier I told my learned friend saying that my client is ready to pay 15 lakhs. To put an end to that, now my learned friend has said that is not
13
possible.
lakhs.
15 lakhs.
No, you
Now-
said 15.
15.
They said 13 lakhs.
30 lakhs.
Lord,
Now, my lord,
that
in
is
between
4
now
years
I-
earlier.
Somehow,
4 years
somehow
earlier.
my lord, I convinced now my client is ready to pay, to put an end to this lump sum amount of rupees 20 lakhs. If my learned friend is agreeable for
No,
that.
13 lakhs plus interest.
No, interest is not the order. Only
My
the
lord, they
principal
have to give from
calculation itself, my
2018.
lord. It
No.
comes to 30 lakhs and.
No, see, you asked 15 lakhs.
No, no. Now, my lord, I was asked to, in fact, my lord, that it is the petition, the respondent case, my lord, I am representing the management in this.
Oh, you are the appearing for the management.
Appeal, appeal by the management against an order made by the AT. Now the calculation is given, my lord, if now my lord friend, because in fact, I convinced my client so that he can put an end to the further litigation, 20 lakhs, if they are agreeable. If they are not agreeable, my lord, you will also kindly call for the records. We'll argue the matter.
Records are before my lords already, my lord.
Now that you are agreeing for a lump sum 20 lakhs.
20 lakhs.
What is your?
My lord, we have given a memo of calculation and execution petition is pending and there is a stay order. Of
According
by
to
the
you,
Supreme
how much you have?
My lord, that was 4 years earlier, my lord.
What is that 13
Now,
lakhs?
at least they have to give 35 lakhs as per our calculation, my lord. That was 4 years earlier. They are proposing 20 lakh rupees, my lord.
No, 35 or 13?
30.
30 as on that day, 30.
30 lakhs is the claim. What I earlier offered was only 15 lakhs. Now I made my client to, not to accept, ultimately has agreed to pay 20 lakhs.
No, they are agreed for 20.
Now
You are-
20 lakhs,
no,
they
my
are
lord.
here, they are, my lord has to say now whether they are ready to
You
accept
are
that.
agreed for 20.
Yes, I am ready.
My lord, may I humbly submit this, my lord. My lord, I will inquire with my client, but a date may kindly be fixed. On that day, if it is not agreeable, we will go on with the matter.
Please.
No, he may say 20. You also negotiate with the both. Even other figure also may agree.
Please,
If
ma'am.
it is agreed, close it. Yes.
4th or 5th of
Yes. Leave this matter on 8th.
8th.
Yes.
Much
Please.
obliged.
Cell number 19, Narayana Bhatt for petitioner, M. Nagarajan.
Appear for the petitioner.
What is?
My lord, he was hospitalized and because of the lung infection
Lung infection.
and discharged.
Yes.
My lord, he made a request and requested me also. Your lordship may have it on the first week of September, my lord.
Yes, we'll have it on 8th. 8th. 8th ಆಗ್ಬೋದಾ?
ಆಗ್ಬೋದು.
Yes.
Serial number 20, adjourn. Serial number 21, Muralidhar K. for petitioner, government advocate.
Appear for petition in this case. Lord, on the last occasion, my lordship looked into this matter, Lord, with regard to regularization of the matter. In the earlier round of litigation, my lord, this honorable court has been pleased to issue directions to the respondent, my lord, specifically holding that, my lord, petitioner is entitled for regulation in any of the group D post. Even then, my lord, they have issued an endorsement.
Where
saying
is that earlier order?
Earlier order annexed T, my lord, page number 154, my lord. And my lords, Justice R. Devadas, my lord, had passed an order. In the relevant page at page number 160, my lord, 160, para number 7.
Yes,
Lord, may I read, my lord, para number 7.
yes.
As rightly pointed out by the learned counsel for the petitioner, that the Honorable Supreme Court of India in the case of State of Karnataka and others versus ML cases and others reported so and so has held that if an employee who has completed 10 years of service but does not possess the educational qualification prescribed for the post at the time of their appointment, they may be considered for regularization in suitable lower posts. Since the petitioner is not insisting that he should be appointed as an electrician, which is a Group C post, for which the petitioner admittedly does not have the requisite qualification, he could be considered for regularization in Group D post where the petitioner fulfills the requisite qualification. And direction was issued, my lord, to consider his representation within the rate of 3 months. My lord, this is a case where, my lord, the petitioner was initially appointed as electrician waterworks. I showed
Why it is rejected?
it is rejected, saying that, my lord, he does not has the qualification, which is the post of, my lord, training and SSLC for the post of electrician grade 2.
No, now that is Group D.
That is Group C. Group D ಗೆ ಯಾವ educational qualification ಇರಲಿಲ್ಲ. And moreover, my lord, here this qualification.
Now that whether
Yes.
they have considered your case for Group C or Group D.
Group D ಗೂ ಮಾಡಲ್ಲ ಅಂತ ಹೇಳ್ತದ, Group C ಗೆ ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು. Group D ಮಾಡಿ ಅಂತ ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ ಇದ್ರು ಸಹ, what do they say? Endorsement kindly see the endorsement, my lord.
Yes, where is that?
Endorsement annexed W, my lord.
Page.
Page number 167, my lord. Second para.
Yes.
Lord, may I read, my lord, second para. ಅದರಂತೆ ಪರಿಶೀಲಿಸಲಾಗಿ ಉಲ್ಲೇಖ 2ರ ಪತ್ರದಲ್ಲಿ ಗ್ರೂಪ್ ಸಿ ಎಲೆಕ್ಟ್ರಿಷಿಯನ್ ಹುದ್ದೆಗೆ ನೇಮಕಗೊಂಡಿದ್ದು ಗ್ರೂಪ್ ಸಿ ಅಲ್ಲ. ನಿಗದಿಪಡಿಸಿರುವ 10ನೇ ತರಗತಿ ಹಾಗೂ 2 ವರ್ಷದ ಟ್ರೈನಿಂಗ್ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಟ್ರೈನಿಂಗ್ ವಿದ್ಯಾರ್ಥಿಯನ್ನು ನಿಗದಿಪಡಿಸಲಾಗಿರುತ್ತದೆ. ಅದರಂತೆ ವಿದ್ಯಾರ್ಥಿಯನ್ನು ನೀವು ಹೊಂದಿರುವುದಿಲ್ಲ. ಅಲ್ಲದೆ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ಉಮಾದೇವಿ ಪ್ರಕರಣದಲ್ಲಿ ನೇಮಕಗೊಂಡ ಹುದ್ದೆಯಲ್ಲಿ ಮಾತ್ರ ಸಕ್ರಮಗೊಳಿಸಲು ಅವಕಾಶವಿದ್ದು ಬೇರೊಂದು ಹುದ್ದೆಗೆ ಸಕ್ರಮಗೊಳಿಸಲು ಅವಕಾಶವಿರುವುದಿಲ್ಲ ಅಂತ ತಿಳಿಸಬಹುದು. This is totally against the ML case's judgment.
Yes.
And most importantly, my lord, kindly see the government order. My lord. In fact, I had mentioned on the last occasion that petitioner, my lord, was initially appointed as electrician, which was in waterworks, my lord. Kindly see page number 50.
In terms of that earlier direction, they have to consider your case for Group D.
Group D, ಹೌದು.
That they have
ಅವ್ರು
not
ಮತ್ತೆ
done.
ಗ್ರೂಪ್ ಸಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ, ಮತ್ತೆ ಗ್ರೂಪ್ ಸಿ ಅಂತಾರೆ ಅಷ್ಟೇ ಅವರು.
We'll say that reconsider in terms of that
Please.
earlier direction.
Please, my lord. ಡಿ ಗ್ರೂಪ್ my lord.
ಈಗ ಅವ್ರನ್ನ Group C ಬರಲ್ಲ ಅಂತ ಹೇಳಿದ್ದೀರಾ. Group D ಗೆ ಬರ್ತಾರೋ ಇಲ್ಲ ಅಂತ ನೀವು ಹೇಳಿಲ್ಲ. Earlier this court has said, consider his case for Group D if he is qualified.
The court itself says that he is
ಅದನ್ನ
qualified.
ಹೇಳಿಲ್ಲ ಅವರು, ಅದ್ರ ಹೇಳೇ ಇಲ್ಲ ಅವ್ರನ್ನ, ಓದದೇ ಇಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್.
ಹೌದು, ಅದೇ ಹಾಗೆ.
Group C. 90
92 na 92.
ಆಯ್ತ್ರಿ, ನೀವೇನಾರ ಹೇಳಿ Group D ಗೆ this is the qualification, you are not satisfied this qualification, therefore rejecting ಅಂತ ಹೇಳಿದ್ರೆ then we will examine. You said Group C, that is not the direction, consider in Group C, D.
And most important, my lord, what my learned friend is referring, that is of 2004 C&R rules.
Anyhow that
I
if
was
they are-
appointed in 1983,
No, if
1993.
if they rejected your request for Group D, then
Yes.
we'll examine.
Yes,
Why
that
it
they
is
have not done.
Yes, totally.
Lord, this court itself has held that he is eligible to be regularized at Group D, and it has not been challenged by them.
They said Group D, if it is satisfied the qualification.
ಅಲ್ಲಲ್ಲ, ಕ್ವಾಲಿಫಿಕೇಶನ್ ಹೇಳ್ತಲ್ಲ ಸ್ವಾಮಿ ಅವರು. My lord, kindly see, my lord, page number.
Post where the petitioner fulfill the required
Yes,
qualification.
required qualification ಅಂತ ಹೇಳುತ್ತೆ. This court itself has held that, my
We
lord.
consider for the regularizations in Group D post where the petitioner fulfill that
Yes.
required qualification.
Yes. They cannot deny me for Group D at all. They consider only in Group C,
Yes.
which
Now
they
we
could
will
not have
say that
considered.
in terms of that, let him consider. Yes.
Please.
In this writ petition, petitioner called in question order dated 23/9/2019 issued by first respondent, whereby petitioner request for regularization has been rejected. What is that?
Annexure W 14/11/2019, 167.
14/11/2019. Early annexure?
W, my lord, 167, which I read now itself.
No, that, what is that you have challenged in?
Annexure V is the letter of the first respondent.
What is that annexure V?
They said that he is not entitled to ವಿದ್ಯಾರ್ಥ ಇಲ್ಲ ಅದನ್ನ ಅವರಿಗೆ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಡಿ ಅಂತ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
V ಎಲ್ಲಿ ಅದು ನೋಡಿಲ್ಲ.
ಪೇಜ್ ನಂಬರ್ 165 ಮನ.
ನೋ ದಿನಾಂಕ ರೀತಿ ತೀರ್ಪುದಿದ್ದು ಗ್ರೂಪ್ ಡಿ ತಸ್ತಮನ್ನ ಹುದ್ದೆಯಲ್ಲಿ ಸೇವೆಯಲ್ಲಿ ಸಕರ್ಮಗಳ ಅನುಮತಿ ನೀಡಲು ಕೋರಿರ್ತಾರೆ. ಶ್ರೀ ಪಾಪಣ್ಣ ಇವರು ಹೊಸಕೋಟೆ ನಗರ ದಿನಗೂಲಿ ಆಧಾರದಲ್ಲಿ ಎಲೆಕ್ಟ್ರಿಷಿಯನ್ ಆಗಿ ನೇಮಕವಾಗಿದ್ದು ಪ್ರಕಾರ ಷರತ್ತು ಹುದ್ದೆಗೆ ನಿಗದಿಪಡಿಸಿದ ವಿದ್ಯಾರ್ಥಿ ಹೊಂದಿಲ್ಲದೆ ಕಾರಣ ಈ ಪ್ರಕರಣ ಷರತ್ತು ಹುದ್ದೆಗೆ ನೇಮಕ ಅವ್ರ ಅಗೇನ್ ಉಮಾದೇವಿ
ಉಮಾದೇವಿ ಹೇಳ್ಕೊಂಡು ಕೊಡು ಅಂತ ಹೇಳ್ತಾರೆ, ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Both order dated 23/9/2019 wide annexure V and order dated 14/1/2020 issued by second respondent annexure W, whereby request of the petitioner for regularization has been rejected. Still you are working?
Now retired, my lord.
Yes. Petitioner was appointed as an electrician.
Electrician, sir.
Electrician.
Water works.
In where you have appointed?
Town Municipal Council, Hoskote, my lord. City.
Town Municipal Council, Hoskote. Appointed as an electrician on daily wages basis.
Please.
Town Municipal Council, Hoskote, by order dated 18/5/1993.
Please.
Thereafter, by order dated 1/4/1995, the chief officer of the city municipal council fixed the pay scale of rupees 840 to 1340 with effect from 1/4/1995 under equal pay, equal work policy.
Yes.
In terms of the government order dated 16/5/1986.
In group D scale only he was paid, my lord.
Since there was a request from the petitioner and other similarly placed persons for regularization of their service, the Director of Municipal Administration made a communication dated 30/10/1999 to the Chief Officer of the Town Municipal Council, stating that the request of the petitioner and other person for regularization cannot be considered since they have worked for more than 240 days.
They can be extended the equal pay for equal work.
Now that the petitioner requested for, no, earlier writ petition you have sought for only direction.
Earlier writ petition I sought for only direction to consider my representation.
There, since there was a request from the petitioner and the other similarly placed, he was working and equal pay, equal work admale, since petitioner has worked more than 10 years, he has submitted a representation seeking regularization of their service as an electrician, bracketly water works group D,
please,
or in any other group D post. Since the representation of the petitioner is not considered, the petitioner has approached this court in WP number 17184 of 2018. This court by order dated 15th April 2019 has disposed of that writ petition. The relevant paragraph 7 and 8 extract ಮಾಡಿ. This court has specifically directed that respondent to consider the case of the petitioner for regularization in Group D post, where the petitioner fulfilling the required qualification. Please. By impugn endorsement, the respondent has rejected the request of the petitioner. By impugn endorsement, respondent has stated that petitioner has not qualified to be regularize his case as a Group C. This endorsement is issued contrary to the directions issued by this court in WP number 17184 of 2018. On this ground, the above writ petition has to be allowed. The impugn endorsement has to be quashed. Accordingly, the impugn endorsement has been quashed. The writ petition is allowed. Impugn endorsement is quashed. The respondents are directed to consider the case of the petitioner for regularization in Group D post. Consider the case of the petitioner in terms of the directions issued by this court in WP number 17184 of 2018, disposed of on 15th April 2019.
In the Group D portion.
Within the period of 3 months from the date of receipt of certified copies of this.
Group D post ಅಂತಾನೆ ಹೇಳಿ.
ಅಂತಾನೆ ಹೇಳಿದೀವ. ಇಲ್ಲಿ ಅದನ್ನೇ ಹೇಳಿರೋದು. Therefore, that endorsement is not correct because they consider for Group C. Yes.
Much obliged.
All pending applications are disposed.
Serial number 22, Narendra Gowda for petitioner.
For the respondent.
On Saturday, my lord, just now they served copy along with the memo. I will get instruction and Saturday.
I may be permitted to
File it in the.
I'll file it in the registry.
Yes.
Saturday, date may be fixed.
Saturday illa. 30th. Yes, please this matter on 30th.
22.
No, you are appearing for
Already
whom?
entered appearance, man.
You are appearing.
ಅವ್ರಿಗೆ notice ಹೋಗಿತ್ತು ಅನ್ಸುತ್ತೆ, but we have been allocated. We have entered appearance.
Yes. Office is directed to delete the name of Ajit Shetty in the cost list for respondent.
Serial number 23, K. Manjunath Rao Bonsle for petitioner, government advocate.
Petitioner is seeking mandamus to the fourth respondent to send the proposal to the second respondent through the third respondent for approval is post, my lord, for getting pension and pensioner benefits, my lord. That is third round litigation, my lord. Last occasion, my lord, this honorable court is directed to make one more recommendation to the fourth respondent and seek the direction, my lord. The last disposal writ petition, my lord.
Post of the petitioner with effect from date of appointment.
Yes, my lord.
Yes, what is this matter, Mr.?
Is the applicant, my lord, the petitioner, my lord, petitioner is appointed as a lecturer in painting department of the fourth respondent by the fourth respondent to work in the fifth respondent college, my lord. My lord, after retirement, they have not settled. Yes, my lord, he approached the labor court, labor commissioner to pay the DCRG amount, my lord. And the assistant commissioner, my lord, is allowed my petition and directed the respondent fourth and fifth, my lord, to pay the DCRG amount, and thereafter they have filed appeal before the labor commissioner, my lord. Labor commissioner dismissed their appeal, and my lord, thereafter we came to know that when Appajaya is working along with the petitioner has granted the pension benefit, my lord. Thereafter, after came to know that I sought the documents from the respondent 4 and 5, my lord. They have did not furnish the record, my lord. Then I approached the director of technical education, my lord, as per annexure C, my lord. Sorry, my lord, annexure.
Now, where is the directions of that labor court?
Labor court, my annexure B. Labor commissioner, my lord. Labor, no?
Labor commissioner.
Yes, my lord.
But labor court ಅಂದ್ರಲ್ಲ.
Yes. Assistant labor commissioner order, my lord, annexure C, my lord.
ಚಿತ್ರ ವಿಭಾಗದ ಉಪನ್ಯಾಸಕರ ಹುದ್ದೆಗೆ ಸೇವೆಯಿಂದ ನಿವೃತ್ತಿ ಮಾಡಿ ಕರ್ತವ್ಯದಿಂದ ಬಿಡುಗಡೆಗೊಳಿಸಲಾಗಿದೆ. ಅಷ್ಟೇ annexure B.
Page number 23, my lord, annexure C. ಶ್ರೀ ಕೃಷ್ಣ ಅಡಿಗಳ ನಂಬರ್ ಅಜ್ಜಗಡ ಸೋಮ್ ಈ ಉಪವನ್ನು ಅರ್ಜಿದಾರರ ಸೇವೆಗೆ ರಾಜೀನಾಮೆ ನೀಡಿದ 30 ದಿನಗಳೊಳಗಾಗಿ
ಏನ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ?
they paid the amount, madam. They directed to pay the DCRG amount of rupees 3 lakhs. Thereafter, they filed the appeal, madam. In appeal order, madam, I said D, madam. 24. Their appeal is dismissed.
ಆಯ್ತು, ಆಮೇಲೆ ದುಡ್ಡು ಕೊಟ್ರ ಅವರು?
Yes, sir, ದುಡ್ಡು ಕೊಟ್ರು ಅದು. DCRG amount ಬಂದ್, madam.
ಈಗ what is this you want to know?
No, madam. I came to know that when the Appajaya is also working along with the petitioner, madam, he has got pension from the government. Then, my lord, the director of technical education, my lord, they have directed me, issued the direct endorsement stating that if the proposal is sent by the fourth respondent, we will consider it, my lord. In the meantime, that is the order, my lord, that is the endorsement issued on F, page number 28, my lord. Page number 28.
Yes, read.
ಪ್ರಿ ಕೃಷ್ಣಗೌಡ ನಿವೃತ್ತ ಉಪನ್ಯಾಸಕರ ಚಿತ್ರಕಲಾ ಪರಿಷತ್ತು ಬೆಂಗಳೂರು ಇವರ ನಿವೃತ್ತಿ ಸಭೆಗಳನ್ನು ನೀಡುವ ಬಗ್ಗೆ ಉಲ್ಲೇಖ 1ರಲ್ಲಿ ತಮ್ಮ ಮನವಿಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ 33/99 ರಿಂದ 39 22 ವರ್ಷ ಕಾಲ ಚಿತ್ರಕಲಾ ಮಹಾವಿದ್ಯಾಲಯದಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸಿ ನಿವೃತ್ತಿ ಹೊಂದಿರುತ್ತೇನೆ.
ಚಿತ್ರಕಲಾ ಮಹಾವಿದ್ಯಾಲಯವು ಸರ್ಕಾರದ ಅನುದಾನ ಸಹಿತ
ಒಳಪಟ್ಟಿರುತ್ತದೆ. ಅದರಂತೆ ತಮಗೂ ಪಿಂಚಣಿ ಸೌಲಭ್ಯಗಳನ್ನು ಬೇಡಬೇಕೆಂದು ಕೋರಿರ್ತೀರಿ. ತಮ್ಮ ಮನವಿಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಕೆ ಅಪ್ಪಾಜಯ್ಯ ಅವರನ್ನು ಉಲ್ಲೇಖ 2ರ ಸರ್ಕಾರ ಆದೇಶದಲ್ಲಿ ವಿಶೇಷವನ್ನು ಪರಿಗಣಿಸಿ ನೇಮಕಾತಿ ಅನುಮೋದನೆಯನ್ನು ಆದೇಶವನ್ನು ನೀಡುತ್ತದೆ. ಅದರಂತೆ ಸದರಿರುವ ಸೇವೆಯನ್ನು ಪಿಂಚಣಿ ಸೌಲಭ್ಯಗಳಿಗೆ ಪರಿಗಣಿಸಿದೆ. ಹಾಗೇನಾದರೂ ತಮ್ಮ ಹುದ್ದೆಯು ನೇಮಕಾತಿಯನ್ನು ಸರ್ಕಾರದಿಂದ ಅನುಮೋದನೆ ನೀಡಿದ್ದಲ್ಲಿ ತಮ್ಮ ಸೇವೆಯನ್ನು ಪಿಂಚಣಿ ಸೌಲಭ್ಯದಿಂದ ಪರಿಗಣಿಸಬಹುದಾಗಿದೆ. ಅದರಂತೆ ತಮ್ಮ ಕುಂದುಕೊರತೆಗಳನ್ನು ತಾವು ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿ ನಿವೃತ್ತದ ಸಮಸ್ಯೆಗಳ ಮನವಿಯನ್ನು ಸಲ್ಲಿಸುವಂತೆ ಈ ಮೂಲಕ ಕೋರಲಾಗಿದೆ. Thereafter, I have sought document of the Appajaya, my lord. They issued the endorsement, annexure H, my lord. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಮೇ ರೀಡ್ ಮೇಲೆ ಪೇಜ್ ನಂಬರ್ 30. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕಾಗಿ ಉಲ್ಲೇಖದಲ್ಲಿ ತಾವು ಚಿತ್ರಕಲಾ ಮಹಾವಿದ್ಯಾಲಯ ನಿವೃತ್ತ ಪ್ರಿನ್ಸಿಪಲ್ ಆದ ಕೆ ಅಪ್ಪಜ್ಜಯ್ಯ ಅವರ ಕುರಿತು ಕೆಲವು ಮಾಹಿತಿಗಳನ್ನು ಕೇಳುತ್ತೀರಿ. ತಾವು ತಮಗೆ ಸಂಬಂಧಪಡದ 3ನೇ ವ್ಯಕ್ತಿಯ ಕರ್ನಾಟಕ ಮಾಹಿತಿ ಹಕ್ಕು ಅಧಿನಿಯಮ ನಿಮ್ಮ ನೋಡಿಸುವವರಲ್ಲಿ ಕೋರಿರುವ ಮಾಹಿತಿ ಹಕ್ಕು ಅಧಿನಿಯಮ ಕಲಂ 16 ನೀಡಲು ಬರುವುದಿಲ್ಲ ಎಂದ ಕಾರಣದಿಂದ ತಮ್ಮ ಅರ್ಜಿಯನ್ನು ಈ ಪ್ರಕಾರ ವಿಲೇ ಮಾಡಲಾಗಿದೆ ಎಂಬ ಅಂಶ. Thereafter, I give the legal notice as per annexure J, my lord, to the fourth respondent seeking the details of the Appajaya, my lord. They issued the written legal notice, my lord, annexure K. They stated that if the page number 34, my lord, insofar as your client's third parameter, page number 34. Insofar as your client's claim towards the general insurance amount and leave encashment concerned, your client has not filed any application as required before the competent authority regarding non-consideration of the GSLIs, and same was not considered because of the no application was submitted as it. However, if the submit necessary application as required as will be considered and dispose of the representation in accordance with the law. Your client had already approached the competent authority for redressal of his grievance towards the payment of the gratuity. So far, this is not considered, my lord. Therefore, my lord, along with my rejoinder reply, my lord, I have submitted all the documents.
ಆಯ್ತ್ರಿ, ನೀವು ಫಸ್ಟ್ ಹೇಳಿದ್ರಿ ಅವ್ರಿಗಾರಿಗೆ ಪೆನ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ನಮಗೆ ಪೆನ್ಷನ್ ಕೊಡಿ ಅಂತ.
Yes, my lord.
ಇಲ್ಲಿ ನೋಡಿದ್ರೆ ಏನೋ ಜನರಲ್ ಇನ್ಶೂರೆನ್ಸ್ ಅಮೌಂಟ್
ಅದೆಲ್ಲ ಬಂದಿದೆ, ಅಮೌಂಟ್ ಎಲ್ಲ ಬಂದಿದೆ, ಅದೆಲ್ಲ ಬಂದಿದೆ ಅಮೌಂಟ್. Thereafter, I have paid the as per annexure M, my lord, I have given the representation, the technical director. Annexure M, my lord, annexure M, typed copy of annexure M, next page 39. ಇದೆಲ್ಲ
ಏನ್ ಕೇಳ್ತೀವಿ?
Yes, my lord. ತಾವು ದಿನಾಂಕ 1/2/16 ಉಲ್ಲೇಖ ಪತ್ರದಲ್ಲಿ KS ಅಪ್ಪಜ್ಜಯ್ಯ ಎಂಬುವರನ್ನು ಪಿಂಚಣಿ ನೀಡಲು ಪರಿಗಣಿಸುವುದು ಚಿತ್ರಕಲಾ ಪರಿಷತ್ತು ಆಡಳಿತ ವರ್ಗ ನೇಮಕಾತಿಗೆ ವಿಶೇಷ ಒಂದು ಸರ್ಕಾರದಿಂದ ಅನುಮೋದನೆ ಪಡೆದಿರುವ ಕಾರಣವೆಂದು ತಿಳಿಸಿ
ಕಾಲೇಜಿನ ಸೇವೆಯಲ್ಲಿ 22 ವರ್ಷಗಳ ಪ್ರಸ್ತಾಪಿಸಿದ ವೇತನ ಅನುದಾನ ನೀಡುವಂತೆ ತಾಂತ್ರಿಕ ಶಿಕ್ಷಣಕ್ಕೆ ನನ್ನ ವೃತ್ತಿ ವೇತನಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಚಿತ್ರಕಲಾ ಆದೇಶವನ್ನು ಪಡೆದು ಶೀಘ್ರದಲ್ಲೇ ವೇತನ ಸಿಗುವಂತೆ ಮಾಡುವುದರೊಂದಿಗೆ ಕಾನೂನು ಹೋರಾಟಕ್ಕೆ ಆಸ್ಪದ ಒಪ್ಪಿಸಬೇಕೆಂದು ಈ ಮೂಲಕ ತಮ್ಮಲ್ಲಿ ನಂಗೆ ಕೊಡಿ ಪೆನ್ಷನ್.
Yes, my lord. This response is not considered, my lord. Hence, I have filed the writ petition before this honorable court, my lord, annexure N, in writ petition number 26,520 of 17, my lord. This writ has disposed of with liberty to the petitioner to make one more representation to the department, my lord. As per my lord, annexure O, my lord, I have made a representation. Annexure. Thereafter, my lord, they have not considered. I have filed the contempt, my lord. Contempt in the contempt, my lord. So, since the the contempt petition is filed by the, after a limitation period, my lord, the disposed with liberty to file the fresh representation, my lord. In the meantime, my lord, the technical department has been changed over to the higher education, my lord. Annexure G, government order, my lord, annexure
ಆಯ್ತು,
R.
ಆಮೇಲೆ ಏನ್ ಮಾಡಿದ್ರಿ?
I have given the representative to the government, my lord.
ಅದಕ್ಕೂ ಒಂದ್ ರಿಟ್ ಹಾಕಿ.
ಅದಕ್ಕೂ ಹಾಕ್ತೀರಿ, ಅದಕ್ಕೂ ಕೊಡ್ಲಿಲ್ಲ. Then, my lord, this Alma Court has directed to make the representative to the fourth respondent. I have made the representative as per annexure U, page number 54.
To file an appropriate petition before the appropriate forum.
Yes,
What is this?
Appropriate forum, my lord, I have to give the representative to the department, that is fourth respondent. I have given the representation as per annexure U, my lord.
No, this court said, learned counsel after arguing some time, seek permission to withdraw the liberty to file an appropriate petition.
Appropriate forum. Earlier, my lord, it is coming under the technical department. Now is it coming under the higher education, my lord.
ಆಯ್ತು, ಅದಕ್ಕೆ appropriate petition ಏನದು? To file
Appropriate petition and making a representation, my lord.
writ petition ಆ representation?
Representation, my lord.
Petition ಅಂತ ಹೇಳ್ತಾರೆ.
ಅಲ್ಲ, petition ಅಂದ್ರೆ ಮೊದಲೇ ನಾನು ಅಲ್ಲೇ ಡೈರೆಕ್ಟರ್ ಮಾಡಿದ್ದೆ, ಟೆಕ್ನಿಕಲ್ ಡೈರೆಕ್ಟರ್ಗೆ.
Appropriate petition before that appropriate forum ಅಂತಾರೆ.
Appropriate forum and decision, my lord.
This matter is clearly covered by the decision of the apex court in C. Jacob's case. Lord, there was no liberty given after the contempt was closed. Your lordship may kindly see, as my learned friend pointed out, he said there was a liberty given. Page 45. The proceedings come to a close because he does not file the representation as directed by this learned single judge.
And learned counsel.
Para 3 may kindly be noted.
Yes.
On hearing learned counsels, we do not find any merit in this petition. Firstly, the fact that there was no acknowledgement in proof of the earlier representation made. The petition was filed without any acknowledgement. Even then, the learned single judge granted 2 weeks time from that date to file a separate representation. The same was not done within time frame, as could be seen from the acknowledgement by annexure C. Since the order of this learned single judge has been disobeyed by the complainant himself, we find no grounds to proceed further. My lord, now thereafter he gives another representation and he proceeds to file another case. My lord, this action is clearly barred by the judgment of the apex court in C. Jacob's case, where it is held that merely by giving a new representation, a fresh cause of action cannot be created. My lord, this would be for the same cause, he cannot file repeated writ petitions. Lordships may see in para 9, my lord. Para 9.
Yes.
May I read, my lord?
Yes.
The court's tribunals proceed on the assumption that every citizen deserves a reply to his representation. Secondly, they assume that a mere direction to consider and dispose of the representation does not involve any decision on rights and obligations of parties. Little do they realize the consequences of such a direction to consider. If the representation is considered and accepted, the ex-employee gets a relief which he would not have got on account of the long delay, all by reason of the direction to consider. If the representation is considered and rejected, the ex-employee files an application writ petition not with reference to the original cause of action in 1982, but by treating the rejection of the representation given in 2000 as the cause of action. A prayer is made for quashing the rejection of the representation and for grant of relief claimed in the representation. The tribunals, high courts routinely entertain such applications, petitions, ignoring the huge delay preceding the representation, and proceed to examine the claim on merits and grant relief. In this manner, the bar of limitation or the latches get obliterated or ignored. Every representation to the government for relief may not be replied on merits. Representations relating to matters which have become stale or barred by limitation can be rejected on that ground alone without examining the merits of the claim. In regard to representations unrelated to the department, the reply may be only to inform that the matter did not concern the department or to inform the appropriate department. The representations with incomplete particulars may be replied by seeking relevant particulars. The replies to such representations cannot furnish a fresh cause of action or revive a stale or dead claim. My lord, the para 11 is important. When a direction is issued by a court tribunal to consider or deal with the representation, usually the person directed examines the matter on merit, being under the impression that the failure to do so may amount to disobedience. When an order is passed considering the rejection, the claim or representation in compliance with the direction of the court or tribunal, such a order does not revive the stale claim, nor amount to some kind of acknowledgement or jural relationship to give rise to a fresh cause of action. when a government servant abandons service to, my lord, this may not be allowed. My lord, what happened is there was a relief granted to him. He doesn't submit any representation. Contempt
Till
is
my lord,
closed.
till my
Again, he
reference is
proceeds
not
to file
considered and
another
rejected.
representation and litigate once
Till
again.
today, my lord, any one of them are not considered and rejected. This case is applicable only considered and rejected, my lord. In my case, my lord, they are not considered and rejected. And the
Not
meantime,
submit
my
the
lord,
representation.
The case is that submitting the representation, there is a delay.
there is a delay.
Submitting a representation, you cannot create a cause of action for that.
No, no.
Cause of action will be there when you have retired from the service.
Yes, my lord, easy. In the meantime, my lord, government has taken a
Okay.
budgetary.
Where is that court given a direction due to liberty? If
No
such
liberty
a
was granted.
representation is made within period of 2 weeks from today.
Kind annexure 51, my lord.
Within
Annexure
2 weeks,
51, my lord.
have you filed it?
Yes, my lord, annexure 51, one more order, my this honor court, my lord.
Annexure?
Annexure T, my lord. Page number 51.
Yes.
My lord, in the meantime, my lord, the budgetary has been withdrawn from the technical education to, technical education to, and handed over to the higher education, my lord. Kindly see the government order, my lord. Before that, my lord, annexure R, my lord. Annexure page number 48. ರಾಜ್ಯದಲ್ಲಿನ ಚಿತ್ರಕಲಾ ವಿಶ್ವವಿದ್ಯಾಲಯಗಳು ಶಾಲೆಗಳ ಅವ್ಯವಯ ಆಡಳಿತ ನಿರ್ವಹಣೆಯನ್ನು ಕಾಲೇಜು ಶಿಕ್ಷಣ
We'll
ಇಲಾಖೆ.
come to that.
Yes, my lord.
Earlier, this court said you have to make a representation within 2 weeks from today.
Yes, my lord.
Have you made it?
Yes, my lord, I made it, my lord.
Torsi had the representation.
That's why, my lord, contempt is dismissed. In the meantime, my lord, the government has passed the order.
I don't know whether you have read it or not. He has read that. What the contempt order said, mister? Contempt is dismissed that you have not complied that see court said that you yourself has committed in a contempt.
No, my lord, that's why, my lord,
Complied that
I
order.
have produced an acknowledgement for having sent to the earlier, my lord.
No, Mr. Counsel. Have you read that contempt court order?
Yes, my lord, I have read it.
Now, what is that says? You read that para 3.
On hearing learned counsel, we do not find any merit on this petition. Firstly, the fact of there was a no acknowledgement in proof of the earlier representation made, though the petitioner was filed without any acknowledgement. Even then, the learned single judge granted 2 weeks time to from the date to file a separate representation. The same was not done within the time frame, as could be seen from the acknowledgement wide annexure C. Since the order of the learned single judge has been disobeyed by the complainant himself, we find that no grounds to proceed further. Hence, the petition is direct.
Closed, you are right.
Yes,
It's
my lord.
closed there.
My lord, this contempt is filed against the technical education department, my lord. In the meantime, before passing this order, my lord, the government has passed the order, my lord, annexure R, my lord. In the year 2017 itself. 17 itself, my lord. Kindly see, my lord, date, my annexure R, page number 48, relevant page is 49, my lord. ಸರ್ಕಾರಿ ಆದೇಶ ಸಂಖ್ಯೆ so ದಿನಾಂಕ 10/7/2017. The contempt order passed by July 2019. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ತಾಂತ್ರಿಕ ಶಿಕ್ಷಣ ಇಲಾಖೆಯ ವ್ಯಾಪ್ತಿಯಲ್ಲಿಲ್ಲ 2 ಸರ್ಕಾರಿ ಕಲಾ ಕಾಲೇಜುಗಳು, 23 ಖಾಸಗಿ ಅನುದಾನ ಚಿತ್ರಕಲಾ ಕಾಲೇಜುಗಳು, 3 ಅಡ್ಡಾಕ್ ಅನುದಾನಿತ ಕಾಲೇಜುಗಳು ಹಾಗೂ 49 ಖಾಸಗಿ ಅನುದಾನ ಶಾಲೆಗಳ ಒಟ್ಟು 77 ಚಿತ್ರಕಲಾ ಶಾಲೆಗಳ ಪೈಕಿ ಸರ್ಕಾರಿ ಖಾಸಗಿ ಅನುದಾನಿತ ಮತ್ತು ಅಡ್ಡಾಕ್ ಅನುದಾನಿತ ಶಾಲೆಗಳ ಶಿಕ್ಷಣ ಮತ್ತು ಲಿಪಿಕಾ ಸಿಬ್ಬಂದಿಗಳ ಆಡಳಿತ ಮತ್ತು ಅವಯವ ನಿರ್ವಹಣೆಯನ್ನು ತಾಂತ್ರಿಕ ಶಿಕ್ಷಣ ಇಲಾಖೆ ವ್ಯಾಪ್ತಿಯಿಂದ ಕಾಲೇಜು ಶಿಕ್ಷಣ ವ್ಯಾಪ್ತಿಗೆ ಹಸ್ತರಿಸಿಕೊಂಡು ಶೈಕ್ಷಣಿಕ ಚಟುವಟಿಕೆಯಲ್ಲಿ ಸಂಬಂಧಪಟ್ಟ
ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಚೇಂಜ್ ಮಾಡಿದ್ರು that will not give any
yes ma'am, that's why my lord, I have given the reference to the commission of
ಅದು ಚೇಂಜ್ ಮಾಡಲಿಲ್ಲ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ. Where is their compliance of this, mister?
my lord, earlier
you dreamt that they will be change that department?
yes my lord, annexure M can be seen, my lord, annexure M, that is earlier representation.
2018 this court has disposed of giving a right to file a representation within 2 weeks. Where is that representation? You show me. Show me that representation you have complied that. Otherwise, you are given up your right.
No, my lord, I will give it, my lord. Kindly have it next week, my lord. I will produce it.
My
lord,
for the prisoner
if I make a submission, there are 2 points I want to make out in this case.
Yes.
One is he's asking parity on one Mr. K. Appajaya. Mr. K. Appajaya, who is asking parity from, is a government employee who has been sent to my college. The party present here is my employee. So the AD is asking for cannot be given. When he went to labor court also, they told me, they ordered me to pay certain sum of amount, which I paid, which he has also accepted.
No, you are not a government employee to claim that benefit.
Exactly, my
No,
lord.
no,
Let
no,
him
he is
prove
not a
that, my
government
lord.
employee. He is also appointed along with me also, my lord.
ಎಲ್ಲಿದೆ?
That's
ತೋರಿಸಿ.
an appointment letter,
Kindly
my
have
lord,
it,
which I have
I will produce all.
ಹೇಳ್ತಾ ಇದಾರಲ್ಲ, employer is
ಇಲ್ಲ,
saying
ಇಲ್ಲ.
that.
Or if the, I am not a,
Sir, you don't know how he has appointed, therefore you ask.
that's why I also to,
They are giving by filing an objection and saying that he is
ಇಲ್ಲ,
not.
till today, they have not filed any
They
objection.
said in that order, have you read? His appointment has been approved by the government.
My lord, I have
Therefore,
also
you are-
produced
No,
it
no,
in
no.
the written.
That's why, my lord, earlier, my lord, the
is that?
technical director.
R2, my lord, annexion R2. The
Copy
copy
ಕೊಡಿ.
might, you serve ಮಾಡಿದ್ದೀರಿ sir.
ಇಲ್ಲ, ಇಲ್ಲ, ಕಾಪಿ ವಿಚಾರ ಮಾಡಿ. ಇಲ್ಲ, government has.
Where is that? Then we will dispose upon that
Oh,
basis.
Swami, adar
You are
ಮೇಲೆ ಏನು
not,
ಇಲ್ಲ sir.
Kindly have to, next,
And
anyhow, my lord,
one
they have
more
not,
point, my lord.
furnish the copy.
One more point, my lord. His only claim in this petition is that the department has changed.
No, that is nothing.
That is all is
No,
there.
first basic is, his claim is only that Apache has given that.
Yes, he has got and I have to get, but that
But he
person is a different
He
employee.
has satisfied that amount which is granted by the labor court.
Yes,
Subsequently, he came to know that Apache has been given.
exactly, my lord.
Now that question is Apache is different, he is in a different. Because
Exactly,
there
my
his appointment is
My-
approved by the
exactly,
government.
my- Yes.
Yes, sir. Kindly have to, next week, my lord, I will produce it.
My lord,
Where you have stated that.
R2, my lords, and then the written statement of objection ಅಲ್ಲಿ annexure R2, my lords. ಅದು ಚೂರು ಪೇಪರ್ ಇದಾಗಿದೆ.
Yes.
ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ಹಳೆದು ಸ್ವಾಮಿ.
What is this? ಉಪನ್ಯಾಸಕರು.
ಹೌದು
1984 ಇಂದನಾ?
ಹೌದು ಸ್ವಾಮಿ. ಅವ್ರದ್ದು ರಿಟೈರ್ಮೆಂಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಅದರಿಂದ ನೇಮಕಾತಿ ಅನುಮೋದನೆ ನೀಡಲಾಗಿದೆ. His appointment has been approved.
ಯಾವುದು ಸ್ವಾಮಿ?
Where is your appointment has been approved?
ಇದು ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಸ್ವಾಮಿ ಇದು.
Where is that your appointment has been approved by the government?
ಅವ್ರದ್ದು ಇದೆ
That's why, my lord,
ತೋರಿಸ್ಲಿ
for
ಸ್ವಾಮಿ ನಾವು.
approval, I am seeking a direction to send the proposal. As director, my lord, technical education asked me to send the proposal through the
ರಿಟೈರ್
department.
ಆಗಿ
Yes, my lord. I was seeking only mandamus.
Yes.
Yeah, that's why, kindly have to come next week, my lord, I will produce the.
Now that
There is nothing,
he has filed an objection saying
Yes,
that
sir.
you are not
Copy
an.
ಕೊಡಿ.
Give up all these things.
2
Yes.
ವರ್ಷ ಮುಂಚೆನೆ ಸರ್ವ್ ಆಗಿದೆ.
Yes, when do you want?
Next week, can I date me?
Yes. At
ಇಲ್ಲ,
the
ಇಲ್ಲ,
request of
ನಂದು.
counsel for the petitioner. Is this matter on 30th? Yes. On that basis, we will close.
Yes, please.
There are so many other grounds,
ಹೌದು, ಹೌದು.
but this is enough
ಅದನ್ನ
for you.
markings
Yes.
ಇದೆ.
ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಡಿ, ಏನೋ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಅದನ್ನ ಕೊಡ್ಸಿ.
ಇದೆ ಸ್ವಾಮಿ, ಇನ್ನೊಂದು ಕೊಡ್ತಾ ಇದ್ದೀವಿ.
Yes.
ಮಚ್ ಒಬ್ಲೈಜ್ my lords.
Serial number 24, Manjunath Rao Bhonsle for petitioner, AP Rajendra Kumar Sundri.
Petitioner, my lord.
Yes.
Now,
In this case,
petitioner
my
is
lord,
working as a.
Where for respondent. Lord, the order which was challenged is passed by both first respondent and second respondent. my lord.
ಇದರಲ್ಲಿ ಡೀಟೇಲ್
order-
ಸಿನಾಪ್ಸಿಸ್ ಬೇಕಾಗುತ್ತೆ. ಒಂದು ಅಕ್ಯೂಟಲ್ ಆಗಿದ್ದಾರೆ, ಸೇಮ್ ಸೆಟ್ ಆಫ್ ಆರ್ಟಿಕಲ್ ಚಾರ್ಜಸ್ ಮೇಲೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಆಲ್ಸೋ ಹೇಳಿದ ಎನ್ಕ್ವೈರಿ ಅಂಡ್ ಅರ್ಲಿಯರ್ ಪನಿಷ್ಮೆಂಟ್ ಫಾರ್ ಡಿಸ್ಮಿಸಲ್. ದೇರ್ ಆಫ್ಟರ್ ಬಿಫೋರ್ ಪಾಸಿಂಗ್ ದ ಡಿಸ್ಮಿಸಲ್ ಆರ್ಡರ್ ಐ ಹ್ಯಾವ್ ಅಕ್ಯೂಟೆಡ್ ಇನ್ ದ ಕ್ರಿಮಿನಲ್ ಕೇಸ್, ಬಟ್ ಐ ಹ್ಯಾವ್ ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್ ದ ಆರ್ಡರ್ ಇನ್ ದ ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್ ಮೇಲೆ, ಅಂಡ್ ಆಲ್ಸೋ ಸಿನಾಪ್ಸಿಸ್ ಇಸ್ ಆಲ್ಸೋ ನೆಸೆಸರಿ. Kindly have it next week, my lord, in this meeting.
First respondent.
Have been dismissed from the service.
ಆಮೇಲೆ ರೀಇನ್ಸ್ಟೇಟ್ ಮಾಡಿದ್ರು.
Reinstate
The
ಮಾಡಿದ್ದಾರೆ.
entrance of the San Court for earlier occasion, my lord, they reinstated. Now they passed a penalty order without in the 5 increments and treating the suspension period days than, my lord.
Issue rule. Yes.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅದು urgency ಇದೆ, he is going to retire, my lord. On date,
ಆಯ್ತ್ರಿ.
ಅಲ್ಲ date
ನೀವೇ move
ಮೇಲೆ ಅಲ್ಲ
ಮಾಡಿದ್ರಿ.
B group ಮೇಲೆ ಮಾಡಿದ್ರೆ
Now that you are-
in the
yes.
B group ಮೇಲೆ
We will hear, yes.
Yes.
Serial number 25, K Manjunath Rao Bhonsle for
In the
petitioner.
my lord, last occasion, your lordship directed me to produce the pay scale of the craft teacher grade 1 and 2, my lord. Now I am producing.
What is this matter?
This is, he is appointed as a craft teacher. And my lord, in the 212, my lord, considering the C&R rules and also his qualification, my lord, he has granted grade 1 pay scale, my lord. And thereafter, my lord, after 1.5 years, they wanted to record that amount, my lord, on the ground of the JP has raised the audit objection.
Yes.
The copy of the pay scale, my last occasion, my lord, your lordship is directed only to produce the pay scale, where the craft teacher grade 1 and 2 are the same or different, my lord. The first document, my lord.
No, now you give that brief facts.
Yes, please.
You are appointed as what?
Appointed as craft teacher, my lord.
Craft teacher.
Craft teacher.
Hmm,
And
now-
with the diploma holder, he is also SLC pass and diploma holder, my lord.
What is
There is
that?
no dispute, my lord, regarding
No, what is that impugned order?
impound order, my lord. After the direction of the Supreme Court, my lord, they credited me as a craft teacher grade 1. But the fixation is the grade 2, my lord. That is, that order has been challenged.
By you?
Yes, my lord.
Where is that?
Annexure,
F, my lord.
annexure F, my lord.
Yes.
Page number 39.
Read.
ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ರಿಟ್ ಸಂಖ್ಯೆ ಸೋಣಿಸುವ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ದಿನಾಂಕ 18/1/2001 ನೀಡಿರುವ ತೀರ್ಪನ್ನು ಅನುಸರಿಸುವ ಬಗ್ಗೆ. ಲಾಸ್ಟ್ ಪೇನ್ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಆಫ್ ದ ಆರ್ಡರ್, ಮೈ ಲಾರ್ಡ್. That is page number 44. ಗವರ್ನಮೆಂಟ್ ಆರ್ಡರ್ ಮೇಲೆ ಇನ್ ದ ಮಿಡ್ಲ್ ಆಫ್ ಮೇಲೆ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಅಂಶಗಳ ಮತ್ತು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ದಿನಾಂಕ 18/1/2021 ಅಂತಿಮ ತೀರ್ಪಿನನ್ವಯ ಶ್ರೀ ಜ್ಞಾನಮೂರ್ತಿ ವೃತ್ತಿ ಶಿಕ್ಷಕ ಶ್ರೀ ಜಗದ್ಗುರು ಒಡೆಯ ಶಂಕರಸ್ವಾಮಿ ಪ್ರೌಢಶಾಲೆ ಹಿರೇಕಲ್ಮಠ ಹೊನ್ನಾಳಿ ತಾಲೂಕು ದಾವಣಗೆರೆ ಜಿಲ್ಲೆ ಇವರು ನೇಮಕಾತಿಯನ್ನು ಮಾಡಿಕೊಳ್ಳುವ ಸಂದರ್ಭದಲ್ಲಿ ಅನುದಾನಿಕ ಆಸಕ್ತಿಗಳಲ್ಲಿ 1967ರ ವೃಂದ ಮತ್ತು ನೇಮಕಾತಿ ನಿಯಮಗಳನ್ನು ಮಂಜೂರಾದ ಗ್ರೇಡ್ 1ರ ಸರ್ಟಿಫಿಕೇಟ್ ಹೋಲ್ಡರ್ ಹುದ್ದೆಯ ವೇತನ ಶ್ರೇಣಿಯನ್ನು 1940ರಿಂದ 1900 ಸಂವಾದಿಯಾಗಿ ವೇತನ ನೀಡಲು ಈ ಕೆಳಕಂಡ ಷರತ್ತುಗಳಿಗೆ ಬಿಟ್ಟು ವೇತನವನ್ನು ಪುನರ್ನಿರ್ಮಿಸಲು ಆದೇಶಿಸಿದೆ. But my lord, this Honorable Court has considered, my lord, kindly see the annexure E, my lord, page number 24. Earlier order passed by this Honorable Court. This is the operative portion of the order, my lord, page number 37. 37. Writ petition is allowed in part. The respondent 1, 2 and 5 are directed to refund the amount of 2,40,000 to the petitioner within the 3 months from the date of the receipt of the order. The respondent 1 to 2 and 5 also directed to consider the whether a petitioner would be the craft teacher 1, craft teacher grade 1 or craft teacher grade 2 and fix the appropriate salary obtained in the such post within the 3 months from the date of receipt of this order.
One ಅಂತ decide
One
ಮಾಡಿ
middle
ಅಂತ.
They have decided craft teacher 1, my lord.
ಒಂದು ಅಂತ ಮಾಡಿ ಅಂತ ಏನ್ ಹೇಳಿಲ್ಲ.
1 or 2.
Now that they have decided that you are 2.
Yes, my lord. They say, they are treated me 1, but fixation is 2.
ಎಲ್ಲಿದೆ?
ಅಲ್ಲಿ operative portion order ಮೇಲೆ. Page number 44.
ಮಂಜೂರಾದ ಗ್ರೇಡ್ 1.
Grade 1 certificate holder ಹುದ್ದೆಯ ವೇತನ 1 grade 1. They have treated me grade 1. But fixation is grade 2 ಮಾಡಿದ್ದಾರೆ. That's my last occasion my lord.
ಅವ್ರು grade 1 ಅಂತ ಅದು ತಪ್ಪಾಗಿ ಅಂತ ಹೇಳೋದು ಅದು ಓದಲ್ಲ.
ಅಲ್ಲಲ್ಲ. Kindly earlier kindly see them earlier order, my lord.
See, on what basis you are fixing that on appointment?
Lord, may I
He has
request?
been appointed as what? Yes.
Lord, he was appointed as a craft teacher. That is only a craft teacher, my lord. The reason why this order is passed, my lord, the school is having only the post which is earmarked for the craft teacher.
Yes.
There is no such post as a grade 1 teacher, my lord. So because of that reason, it may read rules, my lord.
Yes.
Shifting staff patterns, my lord.
There are 3 types of grade craft teachers, my lord. One is grade 1 ನಲ್ಲಿ different 2 types ಇದೆ. Kindly say them. Document now produced.
Lord, that 99 rules, my lord. 99 rules ಅಲ್ಲಿ annexure 4, my lord.
Annexure 4.
ಹೌದು ಸ್ವಾಮಿ. annexure 3 ಇಂದ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತೀನಿ.
Annexure 4.
Annexure 3 is very important, my lord.
Yes.
Lord, may I read, my lord, annexure 3, see rule 3, category of post with qualification, my lord. Lord, category of post, my lord, may I read assistant master physical education teacher lower higher primary school. That is note ide senior responsible headmaster. That is not a dispute, my lord, in this matter. ಕೆಳಗಡೆ ಬಂದ್ಬಿಟ್ಟು headmaster secondary school or / secondary school assistant grade 1, secondary school assistant grade 2, physical teacher and / craft grade 2. Craft grade 2. Lord, this is the staffing pattern, my lord. ಅದರಲ್ಲಿ ನಂಬರ್ ಆಫ್ ಪೋಸ್ಟ್ ಇದೆಯಲ್ಲ ಸ್ವಾಮಿ.
ಕ್ರಾಫ್ಟ್ ಟೀಚರ್ ಗ್ರೇಡ್ 2 ಮಾತ್ರ ಇರೋದು.
ಗ್ರೇಡ್ 2. ಅದ್ರ ಮುಂದೆ ನಂಬರ್ ಆಫ್ ಪೋಸ್ಟ್ಸ್ ಅಂತ ಇದೆಯಲ್ಲ ಸ್ವಾಮಿ ಹೆಡ್ಡಿಂಗ್ ಅಲ್ಲಿ. ಅದ್ರ ಕೆಳಗಡೆ as per approved staffing pattern specified in the 4 my lord. May I read 4 my lord. Lord, ಇದರಲ್ಲಿ education qualification also important lord. May I read that also. ಅದರಲ್ಲೇ 3 ಅಲ್ಲಿ as prescribed under the Karnataka Education Department Services Department of Public Instruction and Recruitment Rules 1967 as amended time to time, Lord. That is the qualification has to be seen in that rules, my lord. Yes. May I read 4, my lord. The minimum strength of the actual student attending each of the schools or high schools standards so and so to 25 each section each class. Accordingly, high school with so and so. My lord, headmaster 1. Headmaster 1 post, assistant master, language teacher, physical education teacher grade 1, Hindi teacher if taught so compulsory language, my lord. The teacher craft teacher, my lord, it is only there is no such classification as a
that
grade
means
1.
to say craft teacher 1, 2.
How?
Yakandre that staffing pattern is that only now this category of the post is only craft teacher 2. Grade 2.
ಹೌದು.
67 C&R rules ಇದೆ.
C&R rules ಗೊತ್ತಲ್ಲ 99.
C&R rules are very clear, my lord. 67 C&R rules.
C&R rules ಇರಲ್ಲ sir
appointed
ಇಲ್ಲಿ.
Now you have produced.
We will come, let him finish.
ಇದು
come to your. Yes.
This is the pattern, my lord, how it was, and the my lord, it is depends on the approval of his my lord. May I read, my lord, what qualification is having? That qualification is very important. He is having an JOC, my lord, not a diploma in this thing.
Where is that qualification has been prescribed for the craft teacher 2?
Lord, that I have to see that rules.
Page number 31 my lord. The earlier my lord.
ಬರ್ತೀನಿ ತಡೀರಿ.
ಅಲ್ಲ ರೂಲ್ಸ್ ಇಲ್ಲೇ ಹೇಳಿದ್ದಾರೆ ಸಾಹೇಬ್ರು ಮೊದಲೇ ಸಾಹೇಬ್ರು ರೂಲ್ಸ್ ಇಲ್ಲೇ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿಸಿದ್ದಾರೆ.
Will come, Mr.
Yes.
Where is that rule which prescribes?
1967, sorry, my lord.
Yes, Mr. What is?
On page number 31, my lord, in my writ petition, the rules are extracted by this Honorable Court, my lord. Annexure E, page number 24. Relevant page is the page number 31, my lord.
Karnataka Education Department.
Yes, Karnataka Education Department instructions, recruitment rules, so far as it concerned to the appointment of the craft teachers are registered.
Now, what is this 67 rules, Mr.? When he has appointed?
He has 91, my lord, 89, my lord. He has 89. New rules, new C&R rules came to the force in the 1998, my lord. 1998 only.
No, he is earlier this court has referred the 1967.
Yes, my lord. Because he is appointed under these rules only.
Yes, Lord, that is not disputed, my lord. If he is appointed in that rule, my lord, who is to be considered as a grade 1 teacher, that is a qualification prescribed for that, my lord.
No, we'll see earlier what is the qualification which is prescribed. Yes, craft teacher.
Craft teacher grade 1, my lord, male read. Craft teachers grade.
Instructor.
Swinging mistress, wood craft teacher, sir. Namdu barte craft teacher grade 1 ಅಲ್ಲಿ. What is the qualification, my lord? For the direct recruitment, associated with a diploma or certificate in the craft subject concerned to the awarded by the state government or an equivalent recognized qualification. Note, preference will be given to the diploma holders.
Yes.
Family, na? Family, craft teacher grade again, subsequent page, my lord. Who are the craft teacher grade 2, my lord? Serial number 74 ado, idu 73 burde craft teacher. Craft teacher grade 2. ಅವರಿಗೆ qualification, no? The direct recruitment were in the basis of the old 8th standard or new 7th standard and a certificate of the craft subject. Those who are past the 8th standard old, my lord, and 7th standard,
yes.
With the certificate, they were the card is a craft teacher grade 2, my lord.
What is your qualification?
I'm a diploma, my lord. That's my lord. Next page 34, my lord. Para number 9, my lord. In the terms of the above extracted rules, craft teachers grade 1 should be possessed the qualification of the SSLC.
Appointment order.
My appointment order, my lord. My appointment is at this present, I have not produced.
ಇಲ್ಲ ನಾವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀವಿ.
ನೀವು ಮಾಡಿದಿರಲ್ಲ?
Objection ಅಲ್ಲಿ ಇದೆ. Lord, annexure R1, my lord, sorry, my lord, I beg your pardon, it is not
Yes.
readable one, my lord.
ಆಮೇಲೆ there is no dispute my lord. ಇದರಲ್ಲಿ ಪ್ಯಾರಾ ಮೇಲೆ ಹೇಳ್ತಾರೆ. In terms of the aforesaid extract of the craft teacher grade 1 should possess the qualification of SSLC with a diploma.
I am asking him to see that you have not produced your appointment order.
Yes, my lord.
Yes, let us see first what you have been. Yes.
Qualification ತೋರಿಸಿ.
ಮುಳ್ಳಗೇಳ್ಳಿ ಇಲ್ಲಪ್ಪ ಚೆನ್ನಪ್ಪ ಪ್ರೌಢಶಾಲೆ ಮಂಡಳಿಯಲ್ಲಿ ಮಾಡಿಕೊಂಡಿರುವ ಕೆಳಕಂಡ ನೇಮಕಾತಿಗಳನ್ನು ಪ್ರಾಂಶುಪಾಲರು ಒಂದು ಕಡೆ ಸೇವಾವಧಿಯಿಂದ ತೃಪ್ತಿಕರವಾಗಿ ಮೀಸಲಾತಿ ಹುದ್ದೆಯಲ್ಲಿ ವಾಸಂಖ್ಯೆ ಸೇರಿತು. ನಿಮ್ಮ ಹೆಸರೇನ?
ಜ್ಞಾನಮೂರ್ತಿ. ಎಸ್.ಕೆ. ಜ್ಞಾನಮೂರ್ತಿ. ಎಸ್.ಕೆ. ಜ್ಞಾನಮೂರ್ತಿ.
ಮುಡಿಗಳ್ಳಿ ಮಹೇಂದ್ರಪ್ಪ. ಎಸ್.ಕೆ. ರಾಮಮೂರ್ತಿನ ಜ್ಞಾನಮೂರ್ತಿ?
ಜ್ಞಾನಮೂರ್ತಿ.
ಎಸ್.ಕೆ. ಜ್ಞಾನಮೂರ್ತಿ. ಸಲಹಾ ಕೊಟ್ರಪ್ಪ. ಹುಟ್ಟಿದ್ದು ಸೋನ್ಸೋ. ಇವರು ತೋಟಗಾರಿಕೆ ವೃತ್ತಿ ಶಿಕ್ಷಕರಾಗಿ. ಯಾವ್ದ್ರಿ ಇವ್ರದ್ದು ಅದರಲ್ಲಿ? ಅದೇನು
Lord, ಇದು fourth serial number 4
ಟೈಪ್ ಮಾಡ್ಸಕ.
Lord, serial number 4 my lord.
ಏನದು?
Serial number ಶ್ರೀ ಎಸ್ ಜ್ಞಾನಮೂರ್ತಿ ಸೋನ್ಸೋ ಅವರು 1-11
ತೋಟಗಾರಿಕೆ ವೃತ್ತಿ ಶಿಕ್ಷಕರಾಗಿ ಅಂತಂದ್ರೆ ಏನದು?
ತೋಟಗಾರಿಕೆ ಅಂದ್ರೆ he got a diploma ಇದು JOC from ತೋಟಗಾರಿಕೆ ಇಲಾಖೆ. ಹಾರ್ಟಿಕಲ್ಚರ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್.
ಶಿಕ್ಷಕನಾಗಿ ಮೀಸಲಾತಿ ಹುದ್ದೆಯಲ್ಲಿ MC ಅವರನ್ನು ಮುಂದಿನ ಹುದ್ದೆಯಲ್ಲಿ ST ಮಾಡುವ ಷರತ್ತಿನೊಳಗೆ ಅವ್ರನ್ನೆಲ್ಲಿ ಕ್ರಾಫ್ಟ್ ಟೀಚರ್ ಅಂತ ಅಪಾಯಿಂಟ್ ಮಾಡಿಲ್ಲ?
ಲಾರ್ಡ್ ಇಲ್ಲ, ಕ್ರಾಫ್ಟ್ ಟೀಚರ್ ಅಂತಾನೆ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ದಾರೆ. ಬಟ್ he was having a qualification of JOC my lord, job oriented course.
ಅಲ್ರಿ ಅದು ಓದಿ ಅದನ್ನ ಏನಂತ ಇದೆ ಓದ್ರಿ.
ಲಾರ್ಡ್ ಸೋನ್ಸೋ ಜ್ಞಾನಮೂರ್ತಿ ಹುಟ್ಟಿದ ದಿನಾಂಕ ಸೋನ್ಸೋ ಆದ್ಮೇಲೆ ಇವರನ್ನು ತೋಟಗಾರಿಕೆ ವೃತ್ತಿ ಸಹ ಶಿಕ್ಷಕರನ್ನಾಗಿ ಅಂತ JOC ಅಂತ ಏನೋ ಇದೆ.
ಆಯ್ತು, ಕ್ವಾಲಿಫಿಕೇಶನ್ ಇರ್ಲಿ, ಅದೇನು ಓದ್ರಿ. ವಾಟ್ ಇಸ್ ದಟ್ ಮೀನಿಂಗ್? ಆ ಪೋಸ್ಟ್ ಅಲ್ಲಿ ಇವ್ರನ್ನ ಖಾಲಿ ಇರೋ ಜಾಗಕ್ಕೆ ಪೋಸ್ಟ್ ಮಾಡಿದ್ರು.
ವೇತನ ಶ್ರೇಣಿ ಇದು ವೇತನ ಶ್ರೇಣಿ ಇಟ್ಬಿಟ್ಟು ಅವರಿಗೆ
ಆಯ್ತು. ಅವ್ರ ತೋಟಗಾರಿಕೆ ವೃತ್ತಿ ಅಂತೀರಾ, ಇವ್ರು ಕ್ರಾಫ್ಟ್ ಟೀಚರ್ ಅಂತಾರೆ. ವಾಟ್ ಇಸ್ ದಿಸ್ ಮಿಸ್ಟರ್?
Lord, he was having a qualification of that, Lord. May read objection, my lord. Para 4 and 5, my lord.
Iವ್ರನ್ನ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ as not as in a craft teacher.
ಇವ್ರು ಕ್ರಾಫ್ಟ್ ಟೀಚರ್
ವೃತ್ತಿ ಅಂದ್ರೆ ಬರುತ್ತೆ. ವೃತ್ತಿ ಶಿಕ್ಷಕರನ್ನ ಕ್ರಾಫ್ಟ್ ಅಂತ.
Para 4 and 5.
ತೋಟಗಾರಿಕೆ ವೃತ್ತಿ ಶಿಕ್ಷಕರಾಗಿ.
ತೋಟಗಾರಿಕೆ ವೃತ್ತಿ ಶಿಕ್ಷಕರು ಅಲ್ಲೇ ಬಂದ ಕ್ರಾಫ್ಟ್ ಟೀಚರ್ ಬರ್ತಾರೆ.
May read
ಅಂದ್ರೆ ಕ್ರಾಫ್ಟ್ ಟೀಚರ್.
ತೋಟಗಾರಿಕೆ ವೃತ್ತಿ ಶಿಕ್ಷಕರು. ವೃತ್ತಿ ಶಿಕ್ಷಕರು means ಕ್ರಾಫ್ಟ್
May read
ಟೀಚರ್.
para 4 and 5, my lord. That will clarify
the meaning of ತೋಟಗಾರಿಕೆ ವೃತ್ತಿ ಶಿಕ್ಷಕ.
In the diploma holder in horticulture, my lord, they are appointed as assistant teacher in craft subject. He is coming under the craft subject.
Oh, that is not.
Yes, it is not.
May read para 4 and 5, my lord. That clarifies.
Sometime that court order will creating new post to that.
Illa. That's why, my lord, same rules can be seen, my lord. There are two types of craft teachers.
Yes. Para 4, my lord. It is submitted that the fourth respondent school did not have a grade 1 craft teacher post, my lord. And there is no provision upgradation of the post of private management schools. Hence, the annexure is wrongly refixed order, and it is objected by the audit authority by Davangere so and so. It clearly shows that, my lord, this para is only that the school which is having, it doesn't have any post which is a grade 1 post, my lord.
This is not that annexure, impugn annexure is wrongly fixed. This is objection is wrongly filed.
No, it is.
See, you are relying on that new rule and making this objection.
Yes.
He is on 60-67. There is a craft teacher 1 and 2, mister. That is
ನಾನು
what the.
ಅದನ್ನು ಹೇಳ್ತೀನಿ, ನಾನು ಅದನ್ನು ಓದ್ತೀನಿ, ಅವ್ರು ಓದಿದೆ ಓದ್ತೀನಿ ಆಮೇಲೆ. Lord, this para is I am reading only one line, my lord. That is the school which is where he was working, my lord. There is no such post as a grade 1 post. That is want to clarify.
From where you are getting that school has different posts. It is only on that staffing pattern, is it not?
How the staffing pattern? But that school should have that grade 1 post always. Where he is working to upgrade his post.
Alri, each school ಗೆ ಬೇರೆ ಬೇರೆ ಇರುತ್ತಾ?
Lord,
school appointment pursuant to that every staffing pattern.
ಹೌದು.
Is it not?
ಹೌದು.
ಸ್ಟಾಫಿಂಗ್ ಪ್ಯಾಟರ್ನ್ ಅಲ್ಲಿ ಗ್ರೇಡ್ 1 ಗ್ರೇಡ್ 2 ಬೋತ್ ಇದೆ.
ಹೌದು.
ಅವ್ರನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ರೆ ಗ್ರೇಡ್ 1 ಆದ್ರೆ ಅಪ್ಗ್ರೇಡೇಷನ್ ಗ್ರೇಡ್ 2 ಎಲ್ಲಿ ಬಂತು ಅಲ್ಲಿ?
ಅದಕ್ಕೆ ನಾನು ಹೇಳ್ತಾ ಇರೋದು ಅಪ್ಗ್ರೇಡ್ ಗ್ರೇಡ್
2 ಗೆ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಗ್ರೇಡ್ 1 ಗೆ ಅಪ್ಗ್ರೇಡೇಷನ್.
ಹೌದು.
ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಇಟ್ ಸೆಲ್ಫ್ ಇಸ್ ವಾಟ್ ವಿ ಆರ್ ನಾಟ್.
ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಇಸ್ ಫಾರ್ ಗ್ರೇಡ್ 2.
ಎಲ್ಲಿದೆ ಅದು?
ಐ ವಿಲ್ ಶೋ ದಟ್.
Yes.
ಇದು ಗ್ರೇಡ್ 1 ಅಲ್ಲಿ ಪೋಸ್ಟ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅದು ಹೇಳ್ತಾರೆ, ಅದು ಒಂದಕ್ಕೆ ಮಾತ್ರ ಇದು
ಆಯ್ತು,
relay
ನೀವು
ಆಗ್ತೀನಿ.
grade
May
2
read
ಮಾಡಿದ್ರೆ-
para 5 my lord.
Yes.
It is submitted the petitioner education qualification SSLC and job oriented course in horticulture department. This qualification is considered as undergraduate certificate course and there is no provision to upgrade the post in refixing a pay scale of private management institution, hence Jilla Panchayat Davangere so and so. Lord, may I read what the Lord, my learned friend has read the C&R rules, my lord. What is the provision of that this thing, Lord? The judgment which is referred in earlier judgment.
Is 31.
Lord, 74 serial number, my lord. Lord, first 73 which is craft teacher grade 1, my lord. ಅದು 70 next page ಅಲ್ಲಿ 74 ಇದೆ. Craft teacher grade 2. A special teachers for schools for deaf and blind workshop, mechanical, weaving, instruction, industrial training, craft, assistant, film operator, clay, modeling, instructor, practical instruction teachers, manual labor instructors, vocational teachers, craft teachers, special subject teachers, tailoring, instructing, booking, book binding and printing instructor work, so and so instructor, floor making instruction, beekeeping instructor, domestic science instructor.
In the craft teacher different, even agriculture and horticulture also there is a craft teacher.
ಇವರೆಲ್ಲ ಇದ್ದಾರೆ. ಅದರಲ್ಲಿ for the direct recruitment he was appointed under this rule, not what he is showing in the first one, my lord.
No,
Qualification
why you are saying that he is appointed in this? Why can't that he is appointed under that craft teacher one?
Lord, may
He has a qualification.
ಇಲ್ಲ qualification ತೋರಿಸ್ಲಿ ಅವರು.
SSLC with the diploma.
ಡಿಪ್ಲೊಮಾ ಅಂತ ತೋರಿಸ್ಲಿ ಅವ್ರು ಅವತ್ತು ಡೇಟಿಗೆ ಇತ್ತಂತ ಹೇಳಿ.
SSLC with diploma or certificate in that craft subject.
ಹೌದು.
Yes, my lord.
Where is your qualification?
Yes, diploma, my lord. Kindly see the page number 9, para number 9 of the same judgment, my lord.
Yes.
Para number 9, my lord, page number 34. In the terms of the aforesaid rules, craft teachers grade 1 should possess the qualification of the SSLC with a diploma or certificate in the craft subject concerned awarded by the state government. And for the teacher grade 2.
ಆಯ್ತು, ಅದನ್ನೇ explain ಮಾಡಿ.
7th or 7th ಮಾಡಲ್ಲ. The petitioner is an SSLC with a diploma or is not dispute. And it is the qualification of the prescribed in the recruitment rules appointed to the craft teachers is also not dispute.
Has a diploma in discipline of horticulture.
Yes.
It is the
Lord, may I request, my lord, this judgment what finally, my lord, it says that whether he is a grade 2 or grade 2, that is kept open, my lord. He should show before this court whether he is having such qualification or that I am asking.
Where is that certificate, Mr.
Certificate, my lord.
You are having an.
Yes, yes, sir. Now I am, my lord. I will produce along with memo, my lord. Kindly have next week, my lord. I will produce. ಇದೆ ನನ್ನ ಹತ್ರ ಇದೆ.
ಇವೆಲ್ಲ ಇಂಪಾರ್ಟೆಂಟ್ ಒಂದು.
ಇಲ್ಲ earlier, my lord, this is the third round litigation and also third round contempt, my lord.
ಆಯ್ತ್ರಿ, ನಿಮ್ಮ ಹತ್ರ ಇದ್ರೆ ನಿಮ್ ಕ್ವಾಲಿಫಿಕೇಶನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಕ್ಕೆ.
Yes, just I will.
First thing is that you should show the court that I have qualified to be appointed as a grade 2. This is my qualification. Then that document has to be produced.
ಇಲ್ಲ ಅವತ್ತಿನ ಡೇಟಿಗೆ ಅವರ ಹತ್ರ
ಇತ್ತು
ಕ್ವಾಲಿಫಿಕೇಶನ್
ಆ ಡೇಟ್ ಆ ಬೇಸಿಸ್ ಮೇಲೆ ನಮಗೆ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡಿರೋದು.
ಕೊಡ್ರಿ.
ಹೇಳಿ.
Job oriented pre-university diploma.
ಅದೇ.
Can it be considered as a diploma?
Yes, my lord. That is my lord. This is extracted, my lord. Certificate or diploma. Qualification to be.
Job oriented is not.
SSLC with a diploma or certificate in craft subject. Subject concerned awarded by the state government. And equivalent, my lord. Equivalent recognized by the qualification of.
Any equivalent?
Yes, diploma.
See, diploma in regular course, Mr. Not
yes,
oriented.
Regular course. Regular course ಅಲ್ಲಿ ಮಾಡಿರೋದು. Kindly see the my lord. Next page serial number 74. Craft teacher grade 2 ಏನು ಆಗಿರಬೇಕು ಅಂತ ಹೇಳಿದ್ರೆ you pass in the old 8th standard or new 7th standard in a certificate in the craft teacher. I am the diploma holder.
ನೀವು craft 2 ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
Yes, yes, ಅಲ್ಲ craft 2 craft 1 ಅಂತ ಡಿಕ್ಲೇರ್ ಮಾಡಿದ್ದಾರೆ, but fixation is made by the craft.
You show me that craft 1 teacher, one should have an SSLC with the diploma.
Yes, my lord.
Where is your diploma?
That is the copy, my lord. That is the copy.
Job oriented course in pre-university is not a diploma.
Yes, yes, sir. 2 years course, my lord. That is a 2 years regular course.
Job oriented is not equal to the diploma which is to be conducted for 3 years course.
ಇಲ್ಲ 2 years diploma
that
2
has
years
to be
ಬರುತ್ತೆ.
issued by
2 years agli.
Horticulture.
It's a job oriented, Mr.
ಅಲ್ಲ ಜಾಬ್ ವಾರಂಟಿ ಆರ್ಡರ್ ಬಟ್ ಸಿ ಅಂಡರ್ ರಿಸ್ಟ್ರಿಕ್ಷನ್ ಮೇಲೆ ಓನ್ಲಿ SSLC plus diploma. Second grade 2 ಗೆ
Diploma means, what is that diploma? Diploma is you should have been regular course, Mr.
Yes, my lord, that's it, my lord.
Show me that
I'll
job.
produce it, my lord. I saw it, my lord.
Yeah,
Kindly have next week, my lord.
ನೀವು ಎಲ್ಲದಕ್ಕೂ ನೀವು
ಅಲ್ಲ.
ಗುತ್ತಿಗೆ ಬಂದ ತಕ್ಷಣ I will
ಅಲ್ಲ
show it.
earlier, my lord, 3 occasions there is no dispute, is a diploma holder. ಸಾಹೇಬ್ರನ್ನ ಹೇಳಿದ್ದಾರೆ earlier access ಮೇಲೆ.
ಹೇಳಿದ್ದಾರೆ.
Lord,
That is not the final. You show me that you have a diploma, then we'll consider that. Not that their objection says
issued
that.
by ಯಾರಂತ ತಾವು ನೋಡಿದ್ರೆ.
ಅಲ್ಲ issued by ಅದೇ ಗವರ್ನಮೆಂಟ್ ಇದೆ, ಟೆಕ್ನಿಕಲ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್.
Council for Vocational Education.
Council ಅಂತಂದ್ರೆ that is only JOC, my lord.
No, JOC, it is there in that this thing.
ಮೇಲ್ಗಡೆ ಟಾಪ್ ಅಲ್ಲಿ ಇದೆ.
Job oriented diploma is not a diploma, Mr. Unless you show me that government order saying that this is equivalent to this. Otherwise it is not that.
Okay,
It is not
equivalent. Also I produce the appointment order.
Judgments are there.
ಒಟ್ಟಲ್ಲಿ ಈಗ ನಮ್ ಬೆಂಚ್ ತಪ್ಪಿಸ್ಬೇಕು ನಿಮಗೆ.
Appointment order.
ಕೇಸ್ನ ನಾವು ಆರ್ಗ್ಯೂ ಮಾಡಿ ಹಿಡಿದು ಕರೆಕ್ಟ್ ಪಾಯಿಂಟ್ ಗೆ ಬಂದ ತಕ್ಷಣ ಲಾಯರ್ಸ್ ವಿಲ್ ಆಸ್ಕ್ ದಟ್ ವಿಲ್ ಗೆಟ್ ಎನ್ ಎ ಟೈಮ್. Yes. This is what you are not qualified to be grade 1, Mr.
ಇಲ್ಲ earlier access C and R as per you have to go by.
ಹಿಂಗೆ ಹೇಳಿದಿರ ಸಾಹೇಬ್ರು ಏನೋ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ, ನೀವು ಅದನ್ನ ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟು
ಅದೆಲ್ಲ ನೋಡಿ ಅವರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ನೋಡ್ಬಿಟ್ಟೇ ಮಾಡಿರೋದು.
Job oriented course, unless there is a government notification, it is not equivalent to that. Otherwise everybody will go and do that job oriented and go to that diploma ಮಾಡಿದರಿಗೆ ಇಂಜಿನಿಯರಿಂಗ್ ಗೆ ಪರ್ಸೆಂಟೇಜ್ ಆಫ್ ಎಂಟ್ರಿ ಇದೆ. ಜಾಬ್ ಓರಿಯೆಂಟೆಡ್ ಇಲ್ಲ ನಿಮಗೆ.
ಲ್ಯಾಟರಲ್ ಎಂಟ್ರಿ ಇದೆ ಅವರಿಗೆ.
Yes. If you are not ready, ಹೇಳ್ಬಿಡಿ.
Appointment order also.
Yes. Yes. Yes, leave this matter after 2 weeks.
Cell number 26, Pankajamani E.R. Raghunatha C. for petitioner, government advocate.
I'm for petition here.
Yes.
The petitioner is daughter of Annadanappa, who was an assistant executive engineer in irrigation department.
Yes.
And he has retired on 31/7/1997. His salary was not settled. His arrears of salary was not settled for absence, and his suspension period was regularized, and his absence was treated as compulsory waiting period.
Where is that order? Directing the respondent to settle the pensionary benefit late fee Anandappa along with that interest from today until date of payment of insurance. Yes. Where is that? Why you have pensionary benefit is not settled?
Yeah, because I was absent for certain period, and that my absence was treated as a waiting period, and the suspension period was regularized as per Annex F, Your Lordship.
Yes, Mr. You consider that there is no decision has been taken. Have given a representation.
No, we have given representation, and the authorities A4 has also directed to draw leave salary and all, and it is to be disbursed. And petition Annadanappa has given 2 representation in the year 2001 itself, and subsequently in the year 2002 he died. His wife also given a representation for disbursement of the family settlement, family payment, and then arrears of the salary for husband. During this period, this Nirmala, husband of Annadanappa, also died. This petitioner is an adopted daughter of the Nirmala and Annadanappa.
She has also given representation.
She has also given representation.
Where is that?
In the year 2020, Your Lordship, as per annexure.
Lord, page 23H, my lord.
As per annexure H, Your Lordship.
Yes. Yes, you consider that, Mr. Whether our
Lord, may I request?
grandfather.
No, my father.
No, petitioner father.
Petitioner's father.
Petitioner father.
Both father
is
and
dead.
mother has given the representation.
So after that, she has given dead. Now that daughter. Yes.
In accordance with like.
Yes. In this writ petition, petitioner sought following relief.
And twice the department has directed to
Petitioner.
settle the dispute.
Petitioner father, late B. Annadanappa. Annadanappa was working as an assistant executive engineer in irrigation department. who retired from the service on attaining the superannuation on 31/7/1997. At that time, he was working in Karnataka, Krishna Bhagya Jala Nigama Limited. After his retirement, his retirement benefit and arrears of salary is not settled by the respondent. Hence, he has submitted a representation.
As per Annexure A and B.
Annexure A and B. When he has that,
He has died in the year third,
thereafter, he died. When, madam? It is not there.
it's
Thereafter
there,
he
Your
died.
Lordship.
Thereafter, petitioner.
On 29/3/2002, he died.
23?
29/3/2002.
Yes, 29/3/2002.
Yes.
He has given a representation annexure A and B.
The immediate next
Died
sentence is
on
that.
29/3/2002. Thereafter, petitioner mother has.
Nirmala.
Petitioner mother Nirmala has submitted a representation. Wide annexure D.
Annexure C, Your Lordship.
Annexure C, what is that? Kept under suspension, treating compulsory. Has given a representation wide annexure D.
Annexure E, Your Lordship, at page
Annexure
16
E
and 17.
has submitted
Annexure
an
E.
annexure E. Thereafter, C died on
She died in the year 2016, 7/3/2016, as per Annexure G.
7/3/2016.
2016, as per Annexure G, page 26.
Thereafter, the petitioner is daughter or adopted.
Yes, adopted daughter.
Petitioner is adopted daughter of the late
Annadanappa
Annadanappa,
Nirmala,
has submitted a representation wide annexure H
36/2020.
on 30/6/2020, seeking for retirement benefit of her father and also arrears of salary. Till today, no action has been taken by that respondent. Hence, the petitioner is before this court.
And refixing of the pension is also to be decided.
Yes, fixation of the pension, retirement benefit, and arrears of salary.
Yes. Along with
Alternate counsel
interest.
appearing for government advocate appearing for the respondent has submitted that the representation submitted by the petitioner wide annexure H will be considered in accordance with law. In view of the above, without expressing any opinion on the merit of the case, who has to consider, Mr. 3 and 4 are. Respondent number 3 is directed to consider that representation wide annexure H dated 30/6/2020 in accordance with law as expeditiously as possible, not later than 3 months from date of. J another.
For disbursement.
Annexure H is considered in accordance with law. Within 3
Along with the
months from
interest,
date.
Your Lord. Along with the interest.
Huh?
Along with the
Adai,
interest.
other ಕೇಳಿದಿರಲ್ಲ, everything they have to be
ಕೇಳಿದ್ದೀನಿ.
considered and passed.
ಆಯ್ತು, ಆಯ್ತು.
Yes.
Cell number 27,
Much
Padmanabha
obliged.
R for petitioner.
Yes, Mr.
Petitioner hearing, my lord, promoted as a headmaster, my lord.
Hmm.
The management sent a proposal to approve his promotion, my lord. That has been rejected, my lord. On the ground that, my lord, the PK Pavitra case is pending, my lord. The PK Pavitra case is pertains to reservation, the promotions to the reservation candidates, my lord. Herein, my lord, the
ಆಯ್ತು,
promotion
ನಾವು
is.
BK Pavitra case ಇದಾಯ್ತಲ್ಲ, whether you are eligible now.
Yes, my lord, I am eligible, my lord. My predecessor, my lord, has been, promotion has been approved, my lord. By the annexure C, my lord.
Now, is there any candidate, it is in a single post question of.
Yes, my lord, single post, my lord, reservation is
The
not
problem is
applicable.
he has retired before the promotion could be given. His case for promotion could not be considered.
My lord, he is
Retired by the
when
time it could be.
when he is in
There is
service,
only
my
a
lord,
right
promotion
to be
given. My lord.
considered from for promotion.
He
my
is in
lord.
service, my lord.
But there are
promotion has
several
been given, my lord.
instances where, my lord, sometimes promotions, DPC is held, but by the time promotion is effected, candidate retires. They cannot come and file a case that give me retrospective promotion.
Where is that law which says that you are entitled for retrospective
My lord,
promotion?
my before my retirement, my lord, proposal has been sent. For the proposal, my lord, they have saying that BK Pavitra case is pending. After the subsequent retirement, my lord.
Only the stage where your junior is given a promotion, you can get in a right. Even after retirement, you is entitled. Otherwise, you have no right, Mr. Even assuming that there is no BK Pavitra case, there is a vacancy. If they don't want to promote, you can't claim it as a matter of right.
Employer cannot be compelled to appoint, even if there is a vacancy.
They may say that we will not do it because of a financial constraint. You can't say that you have to be given that promotion. Unless your junior is promoted.
My lord, they are saying the reason is, my lord, itself is illegal, my lord.
Aito, kodla illa antitically. What is your right? I am asking that.
My lord, I have made a representation after my retirement, my lord. That is not been considered, my lord.
Why they have to consider? Now that considered and rejected, Annexure G, what is that G?
Annexure G is, my lord, I have been retired. That is the only reason, my lord.
Aste, that's correct reason alla. What is wrong in that? Annexure G, ellide?
And page number 20, my lord.
Yes. Yes, that's all. Tali. This writ petition, petitioner called in question.
Lord, give me some time, my lord. I will ask, my lord. I have to take instructions from my client.
Any instruction tantri, ella case alla now, when I come to the conclusion, you are saying that then I can't decide any case.
Whatever the
Only case where I can be disposed
there
of.
may
and
be any communications
allowed.
made. There may
I
be
can't
any,
dismiss any case.
there may be any communications made before the authority.
Communication illa avaru helta idare ನೀವು ರಿಟೈರ್ಡ್ ಆಗಿದ್ರೆ ಕೊಡಕ್ ಬರಲ್ಲ ಅಂತ ಅಷ್ಟೇ.
Only 2 days, my lord. Only 2 days.
Yes. If you get any instruction, it is this thing, you challenge it by filing an appeal, then it will be there. Seeking.
Last occasion, my lord, your lordship convinced, my lord, but the lordship has asked whether the appointing authority is the can give a promotion to the headmaster, my lord.
Huh? Where is the question of appointing authority? Now the case is that promotion itself is not given. Yes.
Discrimination is there is a discrimination, my lord.
What is discrimination?
My predecessor has been given promotion, my lord. That has been approved. Then also the BK Pavitra case is pending, my lord. After, my lord, subsequent to my retirement, my lord, the candidate has been
cannot be
approved.
given because that you have already retired from the case.
My lord, I was in service, my lord. The proposal has been sent, my lord.
Yes, you show me that your junior has been promoted.
My lord, the annexure
it is only one post. Yes.
Not junior, my lord. Subsequent to my retirement, my lord, the eligible candidate has been promoted.
Yes.
That is not dispute, my lord. Annexure H, my lord.
Yes.
Nagendra Rao, Sahashikshakaru, Abhinav Bharati Vidya Kendra Praushala.
Seeking quashing of endorsement dated 28/2/2022, issued by which respondent, Mr.
Third respondent.
Third respondent. Whereby request of the petitioner for approval of Immunian management or appoint Madidra.
Yes, my lord.
Yes.
Annexure D, my lord.
Where is that?
Page 17.
Yes. Rejected that petitioner is retired from the case. By the time considering his proposal sent by that management, he has retired from the case. Learned counsel appearing for the petitioner has submitted that.
They have to show that where is this stated, my lord. After retirement, the promotion cannot be.
You have to show me that even after that you are entitled, Mr.
That is why, my lord, I am asking for time, my lord.
No, you are arguing or your senior?
My senior will argue.
You have any instruction?
Yes, my lord.
to argue the case.
Now, in the next date, my lord, my senior will argue.
Who is that your senior?
Padmanabh.
Padmanabh. You have no instruction to argue this case.
I have instructions, my lord, but at this development, my lord, I have
Only
to.
if it is allowed and disposed, you can. Otherwise,
But
your
not like
senior.
that.
Yes, let his senior come, Mister. Yes, anyhow that. Yes. Yes, when do you want, Mister?
Lord,
You ask him to come
first week,
answer
first
your
week of
senior.
September.
Yes, second.
Second,
Yes.
not, please, my lord, second, fourth,
Third.
third.
Yes. Anyhow, why he has to be. Yes.
Cell number 28, BL Sanjeev for petitioner, Sundararaman MV.
For the respondents, my lords. My lords, we pray for a week's time in this matter. We're led by Senior Counsel Mr. Dhyan Chinnappa. The issue in this is whether or not it's the petition is maintainable, because it's as against a private entity. So we have filed detailed objections.
Which is
with
the private entity? Yes.
ONGC, my lord.
I don't think it is a private entity. Some
My lords, it's not amiable to
There
get
are
jurisdiction because
judgments, my
it
lord.
does.
Right, when do you want?
My lords, anytime
Request
next
for
week,
first,
my
my lord. May I request for first Monday, my lord.
First we have matter, second or
Second,
third?
my lord.
Yes, second.
Grateful.
Yes, at the request of counsel
Lord,
for the
may I
respondent.
request, my lord, that no adjournment be taken after that, my lord.
No, that, what is that you are challenging?
Lord, I am challenging the termination order, my lord.
Termination.
She is without any financial benefits, my lord.
Yes, why it is terminated?
My lord, only because I have asked for seniority, my lord, I sent out legal notices, my lord. That
Yes.
shockingly, they sent me a termination notice.
Yes, second last chance.
Much obliged.
The last chance at the request of respondent, leave this matter on second. Yes.
Much obliged.
Cell number 29, Prasad Hegde KB for petitioner, Rajesh Shettigar.
At the time of filing writ petition, my lord, he has not retired, my lord, sought for promotion, my lord. Promotion is rejected as per Annexure A on the ground that, my lord, previous principal, my lord, filed a case under Atrocity Act. Since the case is pending, my lord, they have denied the increment and
Now you have retired.
Now
What is the-
retired, my lord, pension is not given in any of the pendency of that criminal case, my lord.
Now that pension.
No, my lord.
No, who has given a criminal case?
Earlier principal, my lord.
Has given a complaint against him.
Under Atrocity Act, my lord, on the ground.
That is pending.
Now state, madam, I produced that was challenged in Annexure V is the order
Now,
possible.
is it related to his service condition?
Yes, that's what.
May I request, my lord? That is the institute and the employee between the, ಅವ್ರು ಏನಾಗತ್ತಂದ್ರೆ ನಮ್ಗೆ ಅಪ್ರೂವಲ್ ಕಳಿಸ್ಲಿ ಅಂದ್ರೆ ನಿಮ್ಮ ಅಪ್ರೂವಲ್ ನಾಟ್ ನೆಸೆಸರಿ ಅಂತ ಹೇಳ್ತಾರೆ. ನಾವು ಸ್ಯಾಲರಿ ಅದಕ್ಕೆ ಕೊಡ್ಬೇಕಂತ ಕೇಳೋದು ಅಷ್ಟೇ ಇರೋದೀಗ. It is a dispute between the management and the employee.
Aided post, aided.
No. This is aided institution.
ಹೌದು, ಅವರೆಲ್ಲಾನೇ
ಅವ್ರದ್ದೇನೋ ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ರೆ
ಅವ್ರ ಪೆನ್ಷನ್ ಗೆಲ್ಲ ಅಪ್ರೂವಲ್ ಪ್ರಪೋಸಲ್ ಕೊಟ್ರೆ ಇವ್ರು ಮೂವ್ ಮಾಡ್ತಿದ್ರು.
ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಅವ್ರು ಕಳ್ಸಿಲ್ಲ.
ಗೊತ್ತಿಲ್ಲ ನನಗೆ, instruction ಇಲ್ಲ.
ಕಳ್ಸಿದ್ದಾರೆ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಅವ್ರು. Where is that? That has been rejected now.
No, not rejected, madam. They have not considered. Therefore, I made the AG as a party by implementing him as a.
Now that your first prayer will not survive, second prayer you will directed to consider your proposal sent by the management.
Management, my lord.
Management. Annexure yes is there, Mister.
Yes, you can take.
Annexure yes, sir. Proposal ಇದೆಯಲ್ಲ annexure yes. ಅಥವಾ ಉಪನ್ಯಾಸಕರಾಗಿ ಕೊಟ್ರೇಶ್ ಅವರಿಗೆ ಪದೋನ್ನತಿ ನೀಡುವ ಅನುಮತಿ ಕೋರಿ ಅನ್ನೆಕ್ಸರ್ ಎಸ್ ಅಪ್ರೂವಲ್ಗೆ ಉಪನ್ಯಾಸಕರಾದ ಇವರಿಗೆ ಪದೋನ್ನತಿ ನೀಡುವ ಅನುಮತಿ. ಪದೋನ್ನತಿ ನೀಡಲು ಅನುಮತಿ ಕೋರಿ ಅಂದ್ರೆ ಪದೋನ್ನತಿ ಅಂದ್ರೆ ಏನು? ಪ್ರಮೋಷನ್.
ಪದೋನ್ನತಿ ಅಂದ್ರೆ ಪ್ರಮೋಷನ್.
ಅದು ಆಯ್ತಲ್ಲ. Your retirement benefit.
Retirement benefit, my lord. Recently they have sent, my lord. They sought some clarification from the AG, from the management again. Recently.
ಅದೆಲ್ಲಿದೆ ಕಾಪಿ ಇಲ್ವಾ?
Produce.
You are not sought for that.
ಇಲ್ಲ, ಅದ್ರ amendment ಮಾಡಿಲ್ಲ. Only next week ಇದು ಮಾಡಿದ್ರೆ I will produce that.
Or you give a representation and file in a first writ petition seeking a direction to
pensionary benefit.
Settle that pensionary benefit.
Amendment ಮಾಡ್ತೀನಿ ಅದರಲ್ಲಿ.
ಇದರಲ್ಲಿ ಏನಕ್ಕೆ amendment ಮಾಡ್ತೀರಾ? Respondent approve the proposal of the first.
ಇದು increment ಬೇಕಾಗ್ತದೆ. There are two increment withheld due to pendency of this criminal case.
No, that we can see. Here both relief is only for giving in a promotion. That is over now. Now you have retired.
Then let them consider, my lord, AG is also party.
No, but there is no any prior or representation. That's what I am asking. Why can't you file a fresh writ petition? Withdrawing this and file a writ petition for this thing, for pensionary benefit.
Amendment application is, my lord, in the amended application, it was allowed. Thereafter, not made as a separate prayer.
Amendment allow agidi. ಏನು amendment ಹಾಕಿದ್ದೀರಾ?
ಅದು AG
AG ಪಾರ್ಟಿ ಮಾಡಿದ್ದೀರಾ?
Party ಮಾಡಿ
Prayer
amendment.
ಇದಲ್ಲ.
prayer ಇಲ್ಲ.
Grant such other relief. ಆಯ್ತು representation ಆರು ಇಲ್ಲ ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ, ಅದು ಆಫ್ಟರ್ ರಿಟೈರ್ಮೆಂಟ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್
ಕೊಡಿ ಅದ್ರ
ಮಾಡಿಲ್ಲ. This was filed during 2023. He retired at December 24.
Amendment, you better file in a fresh writ petition. Yes, in this writ petition, petitioner sought following relief. Learned government advocate submits that since petitioner is already retired from the service, his case for promotion cannot be considered at this stage. In view of the above, at this stage, learned counsel appearing for the petitioner submitted that even after retirement, petitioner retirement benefit and ಇನ್ನೊಂದೇನು increment,
2 increment.
and 2 increment has not granted. To that effect, he has submitted a representation. Be that as it may, in this writ petition, he sought only prior for approval of that promotion. In view of the submission of the government advocate, the same will not survive for consideration. Hence, the above writ petition is disposed of, reserving liberty to the petitioner to file an reserving liberty to the petitioner to approach appropriate competent authority for any other relief in accordance with law. All pending applications are displayed.
Serial number 30, Vijay Kumar for petitioner, MS Narayan.
Appear for respondent in this matter, my lord.
Yes.
Petitioner
Yes.
is working in the BWSSP, my lord. Her claim for promotion as junior engineer, but is being rejected on the ground that she is overqualified.
Yes.
Lordship, may kindly see the C&R rules, my lord, which are produced at page 56, my lord. I'm sorry, page 36. my lord.
Yes. Which post to which post you are seeking?
Blood, the post, page 25, my lord. Sorry, my lord. The rules start at page 23.
Yes.
Lordship got it.
Yes.
Page 25, my lord.
Yes.
Serial number 7.
Yes.
Junior engineer, my lord. 90% by direct recruitment, 10% by promotion from the ministerial cadre staff, group C of the board possessing requisite qualification. Now, my lord,
You are in a group C.
group C cadre person.
Yes. In
Junior assistant, I have been appointed as junior assistant, but I had the qualification of BE degree, my lord.
yes.
Now, your lordship may kindly see for promotion, 3 years diploma in engineering or technology or equivalent, preferably in public health engineering, 6 months duration course in computer science.
Yes.
But the petitioner was appointed as a junior assistant, my lord, on 16/2/2008. On the basis of a SSLC marks card.
Junior assistant.
Yes, my lord. Now, it's a group C cadre post.
Yes.
Lord, a list of ministerial staff, my lord, were called for, my lord, to grant promotion to the cadre of junior engineer, including the petitioner's name.
Yes.
Page 34, my lord.
Yes.
Lord, page 44, my lord, I'm sorry, my lord.
Yes.
Annexure E, my lord.
Yes.
Lord, this is the list, my lord. Tantrika Vidya, your lordship got it?
Yes. Yes.
ತಾಂತ್ರಿಕ ವಿದ್ಯಾರ್ಹತೆ ಹೊಂದಿದ್ದು ಸಿ ದರ್ಜೆ ತಾಂತ್ರಿಕೇತರ ವೃಂದಗಳಲ್ಲಿ ಸೇವೆ ಸಲ್ಲಿಸುತ್ತಿರುವ
ಕೆಳಕಂಡ ನೌಕರರ ಸೇವಾ ಪುಸ್ತಕ, ತಾಂತ್ರಿಕ ವಿದ್ಯಾರ್ಹತೆ ಸಂಬಂಧಿಸಿ ಪ್ರಮಾಣ ಪತ್ರ ಮತ್ತು ಅಂಕಪಟ್ಟಿ ಮೂಲ ಪ್ರತಿ ಸಹಾಯಕ ಸಿಬ್ಬಂದಿ ವ್ಯವಸ್ಥಾಪಕರು 3ನೇ ಮಹಡಿ ಕಾವೇರಿ ಭವನ ಇವರಿಗೆ ತಲುಪಿಸಬೇಕೆಂದು ಸಂಬಂಧಪಟ್ಟ ಬಟವಾಡೆ ಅಧಿಕಾರಿಗಳಿಗೆ ಕೋರಲಾಗಿದೆ. Lord, in this the name of the applicant is at serial number 17, my lord.
Yes.
Lord, the applicant's claim was not considered, my lord, while promoting the other ministerial candidates by order dated 7/9/2010, page 46, my lord, annexure F.
Yes.
Lord, she was subsequently, my lord, placed in independent charge of the post by order dated 23/2/2012, my lord.
Yes.
Lord, page 51, my lord.
Yes.
That is annexure L, my lord. Some pagination not properly done, my lord.
51 is that some long list.
Yeah, page 61, my lord, annexure L.
Yes.
61, my lord. Blood serial number 3, my lord. Blood ಮಂಡಳಿಯ ತಾಂತ್ರಿಕ ಸಿಬ್ಬಂದಿ ಕೊರತೆ ಇರುವುದರಿಂದ ತುರ್ತಾಗಿ ತಾಂತ್ರಿಕ ಸಿಬ್ಬಂದಿಯವರ ಅವಶ್ಯಕತೆ ಇರುತ್ತದೆ. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ತಾಂತ್ರಿಕ ವಿದ್ಯಾರ್ಹತೆ ಹೊಂದಿದ್ದು ವಿವಿಧ ವೃಂದಗಳಲ್ಲಿ ಸೇವೆ ಸಲ್ಲಿಸುವ ಮಂಡಳಿಯ ಈ ಕೆಳಕಂಡ ತಾಂತ್ರಿಕೇತರ ಸಿಬ್ಬಂದಿ ಪ್ರಸ್ತುತ ಅವರು ಹೊಂದಿರುವ ಹುದ್ದೆ ಮತ್ತು ವೇತನ ಶ್ರೇಣಿಯಲ್ಲೇ ಮುಂದುವರಿಸಿ ಯಾವುದೇ ಹೆಚ್ಚುವರಿ ಆರ್ಥಿಕ ಸೌಲಭ್ಯವಿಲ್ಲದೆ ಅವರುಗಳ ಹೆಸರಿನ ಮುಂದೆ ತಿಳಿಸಿರುವ ಕಚೇರಿ ಸ್ಥಳಗಳಲ್ಲಿ ಕಿರಿಯ ಅಭ್ಯಂತರರ ಕಾರ್ಯನಿರ್ವಹಿಸಲು ವರ್ಗಾಯಿಸಿ ನಿಯೋಜಿಸಲಾಗಿದೆ. Lordship got it?
Yes, yes.
Page 61, my lord, serial number 3.
Yes.
K.N. Rupa. It's shown that BE civil engineering, my lord, electrical and electronics engineering, my lord, she has been posted on in charge basis as a junior engineer.
Yes.
Lord, thereafter, my lord, she submitted representation, Lord, requesting that her claim be considered for promotion on regular basis as junior engineer. Lord, on 31/10/2013, my lord. Since that was not considered, my lord, she approached this honorable court in WP 55882 of 2014, not which I have produced at page.
Yes.
69, my lord, annexure Q.
Yes.
Page 71 is the order portion, my lord.
Yes.
Having regard to the note of the submission made by the learned counsel appearing for the parties, the petitioner has made a representation 31/10/2013 to writ petition within time specified thereunder. However, taking into consideration the fact that the above representation has been made 9 years back, I am of the view that the petitioner is permitted to make one more representation to the respondent board, and in the event if such representation is made within 2 weeks from today, the same may be considered by the respondent board within 8 weeks from the receipt of such representation. It is made clear that the court has not expressed any opinion on the merits of the case. All contentions of the parties are left open. Thereafter, my lord, she submitted representation as annexure R, page 72. Lord, now by the impugned order, my lord, page 76.
Yes.
Her claim is been rejected on the ground that she is overqualified and she having a BE degree, my lord, is not qualified to be appointed to the post of junior engineer.
Yes. Where is that?
My lord, page 78,
76.
my lord,
78. Yes.
last paragraph. ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ರಿಟ್ ಅರ್ಜಿ ಸಂಖ್ಯೆ 55882 ಆಫ್ 2014 ನಲ್ಲಿ ನೀಡುವ ತೀರ್ಪಿನ ಸಂಬಂಧ ತಾವು ದಿನಾಂಕ 3/4/23 ಸಲ್ಲಿಸುವ ಮನವಿಯನ್ನು ನಿಯಮಾನುಸಾರ ಮತ್ತೊಮ್ಮೆ ಪರಿಶೀಲಿಸಲಾಗಿ ಉಲ್ಲೇಖ 4ರ ನೇಮಕಾತಿ ಆದೇಶ 11E ರಲ್ಲಿ ನೀವು ಆಯ್ಕೆಯಾಗಿರುವ ಹುದ್ದೆಗೆ ನಿಗದಿಪಡಿಸುವ ಅರ್ಹತಾದಾಯಕ ಪರೀಕ್ಷೆಗಳಿಗಿಂತ ಹೆಚ್ಚು ವಿದ್ಯಾರ್ಹತೆ ಹೊಂದಿದ್ದರೆ ಆ ಕಾರಣಕ್ಕಾಗಿ ವೃಂದ ಸರದಿ ಬಿಟ್ಟು ಹುದ್ದೆ ಬದಲಾವಣೆ ಅಥವಾ ಮೇಲ್ದರ್ಜೆಗೆ ಹುದ್ದೆಗಳಿಗೆ ಪದನಾಮ ಅಥವಾ ಪದೋನ್ನತಿ ಕೋರಿ ಮನವಿ ಪತ್ರ ಸಲ್ಲಿಸುವುದು ಪ್ರಭಾವ ಬೀರುವುದು ಅಥವಾ ಅಂತಹ ಯಾವುದೇ ಕ್ರಮ ಅನುಚಿತ ವರ್ತನೆ ಎಂದು ಪರಿಗಣಿಸಲಾಗುತ್ತದೆ. ಹಾಗೂ ಅಂತಿಮ ಭಾಗದಲ್ಲಿ 1-12 ನಲ್ಲಿ ನಿಬಂಧನೆಗೊಳಪಡಿಸಿ ಜಾರಿಗೊಳಿಸಲಾಗುವ ಈ ನೇಮಕಾತಿ ಆದೇಶ ನಿಮಗೆ ಒಪ್ಪಿಯಾದಲ್ಲಿ ನಮೂನೆ 8 ಅನ್ನು ಭರ್ತಿ ಮಾಡಿ ನಿಮ್ಮ ಅಧಿಕೃತ ಸಹಿಯೊಂದಿಗೆ ಈ ನೇಮಕಾತಿ ಆದೇಶ ಸ್ವೀಕರಿಸಿದ ದಿನಾಂಕ 15 ದಿನಗಳ ಒಳಗೆ ಮುಖ್ಯ ಆಡಳಿತಾಧಿಕಾರಿ ಹಾಗೂ ಕಾರ್ಯದರ್ಶಿ ಬೆಂಗಳೂರು ಜಲ ಮಂಡಳಿ 1ನೇ ಮಹಡಿ ಕಾವೇರಿ ಭವನ್ ಕೆಂಪೇಗೌಡ ರಸ್ತೆ ಬೆಂಗಳೂರು ಇಲ್ಲಿಗೆ ಸಲ್ಲಿಸಬೇಕು ಎಂಬುದಾಗಿ ತಿಳಿಸಲಾಗುತ್ತದೆ. ತಾವು ನೇಮಕಾತಿ ಆದೇಶದಲ್ಲಿ ಷರತ್ತು ನಿಬಂಧನೆ ಒಪ್ಪಿ ನಮೂನೆ 8 ಅನ್ನು ಸಲ್ಲಿಸಿದ್ದ ನಂತರವಷ್ಟೇ ತಮಗೆ ತೈನಾತಿ ಆದೇಶ ಜಾರಿಯಾಗಿದ್ದು ಮಂಡಳಿ ಕರ್ತವ್ಯಕ್ಕೆ ಸೇರ್ಪಡೆಯಾಗಿರುತ್ತದೆ. This is one of the conditions prescribed for the appointment, my lord. Your Lordship may kindly come to page 17, my lord.
70.
17. This is the appointment order issued to the petitioner on 22/1/2008, appointing her as a junior assistant. Now, one of the condition at page 19, my lord, says 11E, my lord. May I read, my lord?
Yes.
ನೀವು ಆಯ್ಕೆಯಾಗಿರುವ ಹುದ್ದೆಗೆ ನಿಗದಿಪಡಿಸಿರುವ ಅರ್ಹತಾದಾಯಕ ಪರೀಕ್ಷೆಗಳಿಗಿಂತ ಹೆಚ್ಚು ವಿದ್ಯಾರ್ಥಿ ಹೊಂದಿದ್ದರೆ ಆ ಕಾರಣಕ್ಕಾಗಿ ವೃಂದ ಸರದಿ ಬಿಟ್ಟು ಹುದ್ದೆ ಬದಲಾವಣೆ ಅಥವಾ ಮೇಲ್ದರ್ಜೆಗೆ ಹುದ್ದೆಗೆ ಪದನಾಮ ಅಥವಾ ಪದೋನ್ನತಿ ಕೋರಿ ಮನವಿ ಸಲ್ಲಿಸುವುದು ಪ್ರಭಾವ ಬೀರುವುದು ಅಥವಾ ಅಂತಹ ಯಾವುದೇ ಕ್ರಮ ಅನುಚಿತ ವರ್ತನೆ ಎಂದು ಪರಿಗಣಿಸಲಾಗುತ್ತದೆ. I am not seeking for upgradation. I am seeking for promotion.
Yes.
Therefore, my lord, on page 78 now, my lord.
Yes.
On this ground, by endorsement, my claim for promotion is being rejected.
No.
One. Secondly, my lord, second paragraph.
Yes.
At page 79, my lord. ಅಲ್ಲದೆ ನೀವು ಅರ್ಜಿ ಸಲ್ಲಿಸುವ ಸಮಯದಲ್ಲಿ ಜಾಲ್ತಿಯಾದ ಮಂಡಳಿ ಮತ್ತು ವೃಂದ ನೇಮಕಾತಿ ಬಡ್ತಿ ನಿಬಂಧನೆ 2004ರಲ್ಲಿ ಕ್ರಿಯಾ ಅಭ್ಯಂತರ ಹುದ್ದೆಗೆ ಮುಂಬಡ್ತಿಗೆ ಈ ಮುಂದಿನಂತೆ ಶೈಕ್ಷಣಿಕ ವಿದ್ಯಾರ್ಥಿಯು 3 years diploma in engineering or technology or equivalent, preferably in public health, and 6 months duration course in computer science ಎಂಬುದಾಗಿ ನಿಗದಿಪಡಿಸಲಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಸದರಿ ನಿಬಂಧನೆಯಲ್ಲಿ BE ವಿದ್ಯಾರ್ಥಿ ಹೊಂದಿರುವ ತಮಗೆ ಕ್ರಿಯಾ ಅಭ್ಯಂತರ ಹುದ್ದೆಗೆ ಮುಂಬಡ್ತಿ ನೀಡಲು ನಿಯಮದಲ್ಲಿ ಅವಕಾಶ ಇರುವುದಿಲ್ಲ. On these two grounds, my lord, my claim is being rejected. But firstly, my lord, the condition that is prescribed in the appointment order is not attracted because I am entitled for promotion in terms of the C&R rules.
Yes.
Secondly, insofar as, my lord, higher qualification, my lord, is not a qualification that can disqualify me for promotion to the post. Now, your lordship may kindly come to the C&R rules, my lord, at page 25, which I read.
Yes.
Is in respect of junior engineer. Now, your lordship may kindly come to promotion to the post of executive engineer, my lord, serial number 4, page 24.
Yes.
Lord, by executive engineer, by promotion from the cadre of assistant executive engineer on seniority cum merit, or by deputation from any department undertaking of government having relevant experience, preferably in public health engineering. Lord, qualification should have put in a minimum of 4 years of service as assistant executive engineer and shall possess a degree in engineering technology or equivalent qualification. So a degree is mandatory for an engineering executive engineer. Lord, junior engineer, they say it is a qualification is diploma. Lord,
No, you can't be an executive engineer.
No.
Unless you executive
Degree.
executive engineer, you cannot be.
No. Before that, Malan, qualification for executive engineer is higher qualification of engineering degree.
Question is that.
Now, question
can
is,
it be
Malan,
denied for higher qualification?
Yes.
That is the what.
Now, your lordship may kindly come to. Lord, first contention is, my lord, I could not have been disqualified by virtue of, my lord, I possessing the higher degree.
Yes.
Lord, the judgment of Honorable Supreme Court, my lord, in the case of the first judgment I am relying on. Lord, 2010-15 SCC 596, my lord. Lord, this is relating to recruitment to the post. Lord, your lordship may kindly come to page para 7, my lord. May I read?
Yes.
It is no doubt true, as stated by the High Court, that when a qualification has been set out under the relevant rules, the same cannot be in any manner whittled down and a different qualification cannot be adopted. The High Court is also justified in stating that the higher qualification must clearly indicate or presuppose the acquisition of lower qualification prescribed for that post in order to attract the part of the rule to effect that such of those higher qualifications which presuppose the acquisition of lower qualification prescribed for the post shall also be sufficient for the post. If a person has acquired higher qualification in the same faculty, such a qualification can certainly be stated to be presuppose the acquisition of a lower qualification prescribed for the post. In this case, it may not be necessary to seek for, under the relevant rules, for the purpose, for the post of assistant engineer, degree in electrical engineering of Kerala University or other equivalent qualification recognized or equivalent thereto has been prescribed. For a higher post, when a direct recruitment has to be held, the qualification that has to be obtained obviously gives an indication that such qualification is definitely higher qualification than what is prescribed for the lower post, namely the post of sub-engineer. In that view of the matter, the qualification of degree in electrical engineering presupposes the acquisition of the lower qualification of diploma in that subject prescribed for the post shall be considered to be sufficient for that post. Lord, here also, my lord, the diploma qualification, acquiring BE degree presupposes acquiring diploma, my lord. Then, my lord, para 9, my lord, in the event the government is of the view that only diploma holders should have applied for the post of sub-engineer, but not all those who possess higher qualification, either this rule should have excluded in respect of the candidates who possess higher qualification. Kindly note, my lord, either this rule should have excluded in respect of candidates who possess higher qualification, or the position should have been made clear that the degree holder shall not be eligible to apply for the post. But that is not so in the present C&R rules. Therefore, my lord, the junior engineer post, the diploma qualification presupposes, the degree qualification presupposes diploma qualification, my lord. The second judgment which I am relying on is 2002 SCC 606, my lord.
Yes.
Para 18, my lord. Para 20, my lord.
Yes.
Read.
Yes.
If an employee does not perform the duties attached to the post, the disciplinary proceedings can certainly be taken against him. An employer cannot throw up his hands in despair and devise a method denying appointment to a person who otherwise meets the requisite qualification on the ground that if appointed, he would not perform his duties. The qualification prescribed is minimum. Higher qualification cannot become a disadvantage to a candidate.
Yes.
Not insofar as the third judgment, Lord, 1994.
On same line.
No, on the same line. But there is some, this one, my lord, para 16, my lord, the guidelines have been prescribed in this judgment. From what has been stated above, last we've got.
Yes.
The following legal proposition emerges regarding education qualification being a basis of classification relating to promotion in public service. Higher qualification is permissible basis of classification, acceptability of which will depend on the facts and circumstances of each case. Higher education qualification can be basis not only for barring promotion, but also for restricting the scope of promotion. The restrictions placed cannot, however, go to the extent of seriously jeopardizing the chances of promotion. To decide this, the extent of restriction shall have also to be looked into to ascertain whether it is reasonable. Reasons for this are being indicated later. What it says is, my lord, that the restriction cannot come in the way of jeopardizing the promotion.
Yes.
Lord, the last judgment what I am relying on is, my lord, 2025 latest judgment, my lord. Para 36, my lord.
Yes.
Para 36, my lord. We hasten to add that whether or not the action of the employer to exclude an aspirant from the process of selection on the ground that either he is overqualified for a particular post or has qualification which being over and above what is ordained by the statutory rule or rules framed under the proviso to Rule 309 of Constitution does not match the qualification specifically required, is justified has to be decided considering the rules governing the selection. The qualification prescribed the nature of duty to be performed, the nature of service to be rendered, and host of other factors. It has to be remembered that at the time of employer needs to have the right people at the right place and not always the higher qualified has to be considered. We know of the decision holding that overqualification cannot be a disqualification, since such an approach amounts to discouraging acquisition of qualification on one hand. On the other, such an approach would be seen as arbitrary, discriminatory, and not national interest. Therefore, my lord, the acquisition of higher qualification could not be a disqualification for granting promotion.
Yes.
Lord, in the meantime, Lord, the very same employer has granted promotion to the persons who have acquired BE degree.
Where is that?
Annexure T series, my lord. Page 82, my lord. Lord, Shri R. Jagdish,
Annexure D.
Annexure T, my lord. Series which I have produced, my lord.
Yes.
Shri R. Jagdish, my lord. He is a degree holder
Yes.
and he is being promoted.
Yes.
Lord, for a moment.
No, is there any seniority list for Group C employees our?
Based on the seniority, my name was recommended. But based on the seniority, they ought to have considered my claim in 2010 itself.
Yes.
Because of the B degree, my lord, they rejected my claim. Subsequently, my lord, I was placed under Rule 32 to discharge the duties of the post of junior engineer. And my lord, by Annexure T series, several of the page 82, my lord.
Yes.
See, R. Jagdish, my lord, he is a holder of BE degree and he's been promoted. My lord, initially as assistant engineer, junior engineer, and thereafter, my lord, he is also further promoted as assistant executive engineer. My lord,
Yes.
page 80 is the order by which he was promoted as assistant engineer, my lord. Serial number 8. Therefore, my lord, they could not have denied me promotion. My lord, since I was qualified and eligible as on 2010 itself, merely on the ground that I have the higher qualification.
Yes. Yes, Mr.
My lord, my objection statement will be kindly taken, my lord.
Yes. Yes.
My lord, para number 1.
Yes.
The appointment order 11E in the bottom of the first page, my lord. Para number 1, my lord.
Yes.
First para. Bottom, I can the appointment ಕೊಡಬೇಕಾದ್ರೆ 11E ಪ್ರಕಾರ
Yes.
ಅವರು you can influence ಮಾಡಿ 11. I have clearly stated in this way, the qualification held by her is higher than the one prescribed in C&R rules of the board, and that as per clause 11E of the appointment order dated 22/1/2008, the petitioner would not make any claim to change of cadre. ಇಲ್ಲಿ change of cadre ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಅವರು. ಅದರಿಂದ
ಎಲ್ಲಿದೆ?
ಕೊಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಅಂತ.
Where is that he has asked for change of cadre, Mr.
ಈಗ ಅವರು the post she has acquired and now what she was
that is on promotion. She is seeking a promotion, not change of cadre, Mr. Promotion ಆದ್ಮೇಲೆ cadre change ಆಗುತ್ತೆ. It is not that by overturn she is asking to give a change of cadre. On seniority, on eligibility, she has asked to give a promotion. It is not change of cadre, Mr. That is wrong.
That's the main ground, my lord, ours from the board. And ಹಾಗಾಗಿ ಅದು
No, the what you have stated in that endorsement is also that is that. Then
Yes,
which law which prohibited to give a promotion on denying the promotion on that higher this thing, higher qualifications, she cannot be promoted.
My lord, under the C&R rules, the qualification fixed is then page number 3 ಅಲ್ಲಿ slab column ಮಾಡ್ಬಿಟ್ಟು I have shown it, my lord. Junior engineer ಗೆ number of posts 57 post vacancy ಇತ್ತು. 90% by the direct recruitment and 10% by the promotion from ministerial cadre of group C. For direct recruitment, the appointment of 3 years diploma in engineering or technology or equivalent preferable in public health engineering. And then 6 months duration course in computer science. ಅದು page number 3 ಅಲ್ಲಿ para number 3 I have clearly stated in the column slab.
ಆಯ್ತು, ಅದನ್ನೇ ಅವ್ರು ತೋರಿಸಿದಾರಲ್ಲ ಇದ್ರಲ್ಲಿ.
ಹೌದು ಮನೆ ತೋರಿಸಿದ್ರೆ. ಹಂಗಾಗಿ ಇವ್ರದ್ದು ಅಲ್ಲಿ ಕೊಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಅಂತ ಯಾಕಂದ್ರೆ ಇವರು 25% ನಾವೇ ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಪ್ರಕಾರ 25% ಜಾಸ್ತಿ ಮಾಡಿದೀವಿ ಅಂತ ಅಂದ್ಬಿಟ್ಟು 7/3/2014 ನಲ್ಲಿ ಇದಾಗಿದೆ ಅಂತ, ಬಟ್ ಇನ್ನೂ ಅದನ್ನ ಮಾಡಿಲ್ಲ. ಈಗ ಸ್ಟಿಲ್ ವಿ ಆರ್ ಪ್ರಮೋಷನ್.
You have rejected on two ground. One is that she is sought for a change of cadre. It is not change of cadre. Second is that she is higher qualified. Higher qualification is not a bar. That is not that your endorsement to say that any other reason.
Yes, Malan.
Yes, that's all.
That's all, man.
Yes, third. State is the party.
No, state is a party, my lord.
You have any role to say? How can that say it's in a bar of higher qualification unless it specifically stated that these are all the reason it cannot be. Otherwise, this judgment says higher education qualification permissible on basis of a classification accepted which depending upon the facts or circumstances, second qualification can be the basis not only for barring the promotion but also for restricting the scope of promotion. Placed cannot however go to that extent of seriously jeopardizing the chances of the promotion. To decide this, the extent of restriction shall have also to be looked into the assign whether it is reasonable reason for this are being indicated later. It should be a reasonable restriction saying that by giving in a person who is having a higher qualification, it will affect this post. Here subsequently they have given some other persons also. Yes. In this writ petition, petitioner called in question endorsement dated 30th/5/2023 issued by respondent number 3 wide annexure S, whereby rejected the request of the petitioner to the promotion to the post of junior engineer. Petitioner is a holder of BA degree in electrical and electronics engineering and was appointed as a junior assistant on 22/1/2008 wide annexure A. As per that C&R rules of Bangalore Water Supply and Sewage Board, to the promotion to the junior engineer, one should have 3 years diploma in engineering or technology or equivalent, preferable in public health engineering. Second, 6 months duration course in the computer science. Since petitioner is qualified to be promoted as a junior engineer, his name has been recommended by the annexure.
Annexure E, page 44.
Annexure E by which respondent?
Not the Sibbandi Nirvanadhikari.
Andre ಏನದು?
That is, they called for the documents for document verification, the persons who are qualified, my lord.
Technically qualified ಸಿ ದರ್ಜೆ ಸಲ್ಲಿಸಿರುವ ನೌಕರರು ಪುಸ್ತಕ ಅಂಕಪಟ್ಟಿ ಮೂಲಭೂತ ಸಹಾಯಕ ಇವರಿಗೆ ತಲುಪಿಸಬೇಕಾದ ಸಂಬಂಧಪಟ್ಟ ಅಧಿಕಾರಿಗಳು ಕೋರಲಾಗಿದೆ. They have called for that.
Yes.
Qualified to be
consolidated list. ಯಾರು ಸಿ ಗ್ರೂಪ್ ಎಂಪ್ಲಾಯೀಸ್ ಯಾರಿದ್ರು ಅವ್ರದ್ದು ಎಲ್ಲರದು ಲಿಸ್ಟ್ ಅದು ಅಷ್ಟೇ.
Yes. Has to be promoted as per that C&R rules ಹಾಕೊಂಡ್ರಲ್ಲ. Thereafter, the respondent board has called for a qualified person who is working in Group C who was working in Group C cadre as per Annexure E dated 12/8/2010. In that, petitioner name has been shown in serial number 17. Thereafter, vide Annexure F, they have given a promotion to some of the employees who is working in Group C. In that, petitioner name has not been found. Therefore, petitioner has submitted a representation to consider her.
Page 56, my lord, Annexure J.
Submitted a representation with annexure.
J, my lord, page 56.
Submitted a representation with annexure J dated 18/9/2010 seeking promotion to the post of junior engineer. Since no action has been taken by the respondent, petitioner has approached this court by filing a writ petition in WP 55882 of 2014 dated 20th March. This court by order dated 20th March 2023 has permitted the petitioner to make one more representation to the respondent board within 2 weeks, and respondent board is directed to consider the same within 8 weeks from the receipt of such a representation. Thereafter, the respondent has issued that impugn endorsement dated 30th/5/2023. Being agreed by the same, the petitioner is before this court. Learned counsel appearing for the petitioner has submitted that petitioner request for promotion has been rejected on 2 grounds. On first ground, that the petitioner is seeking for a change of cadre on the basis of his higher qualification. He submitted that his request is for giving a promotion and he has not requested for change of cadre, change of higher cadre on the basis of higher qualification. He further contended that as per that C&R rule, the Group C employees who are working as a junior assistants are eligible to be promoted as junior engineer if they are having a 3 years diploma engineering or technical or equivalent, preferable in public health engineering. Petitioner has acquired higher qualification. He is holding a BA degree in electrical and electronic engineering. On the ground that petitioner having a higher qualification, his request for promotion has been rejected. He contended that promotion cannot be denied on the ground that the candidate has a higher qualification. When where is that? When that higher qualification is presupposed to the acquisition of the lower qualification prescribed for the post. Since in support of his contention, he has relied on judgment of Apex Court in 2010-15 SCC 596, 1994-6 SCC 282, 2025 SCC online SC 711 and 2000 volume 2 SCC 606. Therefore, he sought for allowing that writ petition. Per contra, Learned Counsel appearing for that board has submitted that. As per that appointment order with Annexure A, there are conditions. As per that condition number 11E, the candidate cannot influence that corporation to seek for change of cadre on the basis of his higher qualification. Since petitioner is seeking for a change of cadre, the same is contrary to condition mentioned in his appointment order. Therefore, the impugn endorsement has been issued. He further contended that ಇನ್ನೊಂದು contention. Further contended that even the person who has secured higher qualification of the degree, engineering degree, later they have been promoted. One of that is one Kumar MS. That appointment promotion order has been produced as Annexure T1. Jagdish ಇನ್ನೊಬ್ರು ಇದ್ದಾರಾ? Yes. And also R Jagdish,
Page 82, Annexure T.
Annexure
T, page 82, serial number 3.
Yes, one Jagdish wide Annexure T. They denied that promotion only to the petitioner that he is having a higher qualification. It is amounts to a discrimination. Orderly, continue. Secondly, he has contended that as per that C&R rule, the qualification prescribed for promotion to the junior engineer, one should have 3 years diploma in engineering or technology or equivalent, preferable in public health engineering. Since petitioner has overqualified, therefore his case has not been considered. Hence, he sought for allowing that, dismissing that writ petition. Learned government advocate submitted that just because the employee having a higher qualification that higher qualification is presupposed that acquisition of the lower qualification prescribed for the post, he cannot be denied that promotion unless there is a specific provision for restriction the scope for promotion. Heard the learned counsel for the parties. Feroz, read papers. It is not in dispute. Petitioner is a holder of BA degree in electrical and electronic engineering and was appointed as a junior assistant on 22/1/2008. It is also not in dispute that 10% also not in dispute for the junior engineer, 10% is by promotion from the ministerial cadre staff, bracketal is group C of the board possessing requisite qualification. To fill up the 10% promotion quota in the cadre of junior engineer, the respondent board CK eligible candidates in group C to be considered for the promotion to the post of junior engineer as per Annexure E dated 12/8/2010. In that request, petitioner name has been placed in serial number 17. The qualification prescribed to the post of junior engineer for a promotion to the post of junior engineer, one should have 3 years diploma in engineering or technology or equivalent, preferably in the public health engineering. Second, 6 months duration course in computer science. Petitioner is holding BA degree in electrical and electronic engineering. The qualification held by the petitioner, a BA degree, is presupposed the acquisition of lower qualification prescribed for the post of junior engineer. Just because petitioner is holding higher qualification, his case for a promotion to the post of junior engineer cannot be denied unless if the rules restrict such a promotion. In this case, neither that rule restrict for promotion to the junior engineer who has possessed higher qualification. Even in the endorsement or in the objection statement filed by that corporation, as stated that the higher qualification as stated, is there any restrictions for promoting to the junior engineer who is having a higher qualification? The apex court, in case of Jyoti KK and others, 2010-15 SCC has held that if the person has acquired higher qualification in the same faculty, such qualification can certainly be stated to presuppose the acquisition of that lower qualification prescribed for the post. He cannot be denied for the appointment on the ground that he has secured higher qualification. The relevant paragraph, para 7, 8 and 9. In 2025 SCC online, SC 711, paragraph 36 extract. In 2000, volume 2 SCC 606, para 20. The apex court, in case of Kodandraman and others, 1994-6 SCC 282, the higher qualification for the promotion can be restricted. Higher qualification can be restricted for the promotion. But that restrictions cannot go to the extent of seriously jeopardizing the chance of the promotion. The relevant paragraph, para 16. In the case in hand, there is no any such restrictions has been placed either in the C&R rules, as not stated in the endorsement or in the objection filed by the respondent. Under these circumstances, the impugn endorsement placed. The specific case of the petitioner that he is seeking a promotion in the quota 10% reserved for Group C. He is not seeking a change of higher cadre on the basis of the higher qualification. The reason given in that endorsement is contrary to the material available on record. In view of the above, impugn endorsement dated so and so is liable to be quashed. Accordingly, is quashed, the respondent is directed to consider the case of the petitioner for a promotion. ಆಮೇಲೆ ಅದ್ರಲ್ಲಿ ಇನ್ನೊಂದು later they have also
promoted persons who are holding a degree, they have been promoted.
yes later that person who are holding a BA degree has been promoted as a junior engineer as per that annexure T and T1. ಅದನ್ನ ಸೇರಿಸ್ಬಿಟ್ಟು allowed is quashed, the respondent is directed to consider the case of the petitioner for promotion to the post of junior engineer if petitioner otherwise eligible in accordance.
Blood. From the date the juniors were promoted and to grant all consequential benefits.
And also from the date is junior is promoted if otherwise eligible.
And also grant all consequential benefits, my lord, because
If they given, it is the law. If they are not given, again one more case you have to be filed and come to
time frame, my lord.
within 3 months from date of arrest of document.
Serial number 43, my lord. Next week, any date may be given, my lord. The senior is at some inconvenience, my lord. Serial number 43, my lord.
43.
Please, my lord, next week, any date may be given, my lord.
Yes, at the request of counsel for the petitioner, leave this matter.
Next week, my week ಆಗಲ್ಲ. ಏನಿದ್ರು 11.
Serial number.
Serial number 32. It may be time, may be.
32
You are appearing
yesterday.
for
Petitioner, my lord.
petitioner. Yes,
Well, for respondent,
Yesterday, my lord has sought clarification about substitution by an amendment. my lord. What is
compassionate
that
ground
effect?
as son ಗೆ adopted son.
we got that original circular. It says,
That has been not accepted by the division bench of the Honorable Court. That has been rejected by the division bench, my lord.
notification ಅನ್ನ.
Yes, my lord.
Which is that division bench?
ಅವ್ರು ಏನ್ ಮಾಡ್ತಿದಾರೆ ಅದು?
ಹೌದಾ?
Notification ಅಲ್ಲಲ್ಲ, ಅದರಲ್ಲಿ 9/4/2021 there is an amendment, my lord. ಆ amendment ಅಲ್ಲಿ, Lord, it says, it shall come into force from the date of publication in the Karnataka Gazette ಅಂತ.
Lord,
21 ಆದ್ಮೇಲೆ ಬರುತ್ತೆ.
ಇಲ್ಲ,
ಹಿಂದಿನವರೆಗೆ ಬರೋದಿಲ್ಲ ಅದು ಒಂದು.
ಇಲ್ಲ,
And
even
it has
otherwise,
been
my lord,
omitted.
I have seen this.
What is that omit?
I have seen the judgment, my lord, omit and the substitution, my lord, what my lord has sought yesterday, my lord.
Yes.
If there is no specific provision, it affects from retrospective effect. It will be prospective on the judgment.
Judgment.
I will place that and I
ಅಲ್ಲ,
will argue that.
ಇದು ಯಾವ್ದು ಹಿಂಬರ ಇದೆ.
And very same contention is
Not notification, madam.
considered in that case.
Now, where is that notification? Notification ಅಲ್ಲಿ ಏನಂತಿದೆ?
With effect from ಅಂತಾನೆ ಇದೆ on the notification, date of
So it is
notification,
said that omitted from, it is prospective.
date of notification.
Yes, mister. What you want, alla, that is what that, mister. You are not entitled, it is a prospective. As when do you want?
Next week, my lord.
Yes, Mr. Rajendra.
ಅಲ್ಲ, notification ಇದೆ ನನ್ನ ಹತ್ರ.
ಅದ್ರಲ್ಲಿ ಏನಂತಿದೆ?
ಅಲ್ಲ, ಅದರಲ್ಲಿ
With effect
omitted
from the
ಅಂತಿದೆ ಒಂದು, ಆಮೇಲೆ it shall come into force from the date of their final publication in the official gazette, 2021.
Also the word omitted, it means
ಹೌದು,
it is a
ಹೌದು.
prospective.
ಹೌದು.
Yes, Mr. ಎಲ್ಲಿ ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ದಾರೆ ಅಂದ್ರೆ ಯಾವ್ದದು?
ಪ್ಲೇಸ್ ಮಾಡಿದೀನಿ, my lord.
ಏನ್ ಹೇಳಿದ್ದಾರೆ? ಇದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿದಾರ?
ಇಲ್ಲ, ಇವ್ರು ಹಾಕಿದ್ ಏನ್ ಹಾಕಿದ್ರೆ 9/4/21 ಪ್ರಕಾರ ಈ ಸೆಟ್ ಕಂಡೀಷನ್ ನಾಟ್ ಅಕ್ಸೆಪ್ಟಬಲ್ ರಿಜೆಕ್ಟೆಡ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ, ಅದರಲ್ಲಿ
ಇವ್ರು ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
in fact state government has preferred an appeal. I got a copy of the order, my lord.
ಅಲ್ಲ, ಸಿಂಗಲ್ ಜಡ್ಜ್ ಯಾವ್ದ್ರಿ ಅದು ಆರ್ಡರ್?
ಅಲ್ಲ, ಅದಿದೆ.
Supreme Court is clarified in that.
Supreme Court ಅಲ್ಲಿ the very same issue is now pending. Really, against the division bench of this honorable court order, my lord, state of Karnataka has preferred an appeal. Adರಲ್ಲಿ 3(3) ನೇ eligibility and adopted son ಅಂತ.
The rule came to be amended only in so and so, and under that present norm, adopted children can be considered for compulsory. This case, however, the employee died and well before that amendment, therefore it is.
Well before the amendment.
Issue notice to the special leave petitions, notice is, where is that division bench order?
To my lord, it's
ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್ ಲಾಸ್ಟ್ ಟೈಮ್.
ಕೊಡಿ, ಕಾಪಿ ಕೊಡ್ತೀನಿ, ಕೊಡಿ ಅದ್ಯಾ.
ನಂಬರ್ 11 ಮತ್ತೆ
ತೋರ್ಸ್ಲಿಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ ಒಮಿಷನ್ ಅಂದ್ರೆ ಏನು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. Application has to be considered for a rule applicable to state of.
This is the order of the division against which, my lord,
ಪ್ಯಾರಾ ನಂಬರ್ 11, my lord, sir. And last ಅಲ್ಲಿ ಪ್ಯಾರಾ ನಂಬರ್ 15.
Short question which apartment amendment made to that rule also is regarding whether that adaptations are can consider application for compulsory appointment.
ಪ್ಯಾರಾ ನಂಬರ್ 15, my lord, sir. Next.
Para number
15.
The above secretary whereof review that opinion application made by the applicant consider in this background difficult to face family. Adoptions. When the matter is settled, that what is that meaning of adopt?
Son is a son, daughter is a daughter ಅಂತಿದೆ.
Substitution, insertion
ಹೌದು.
and omission. What is the meaning ಅಂತ settle ಆದ್ಮೇಲೆ you can't say that because of compassionate ground it is in a separate
ಹೌದು.
interpretation and if it is in a land reform separate interpretation. Interpretation of the word is same.
Paragraph
Just because
16.
you can't say that. Yes,
Paragraph 16 ಮೇಲೆ ಬಂದು.
anyhow that Supreme Court itself has taken note of that
ಹೌದು.
and issued a notice. Let us see that.
Lordship can issue the rule, my lord, he is working now.
Yes, leave this matter after 3 weeks.
Yes.
34, my lord. 48. 48, you will come back.
34, my lord. I will have to file my objections.
34.
Serial number 43.
You are appearing for whom?
For the respondent, my lord.
Have you informed other side?
Informed, my lord.
You inform and come mention at 2:30.
My lord, I am for serial number 43, my lord.
ಅರ್ಜುನ್
Next week, any date, my lord.
43 we have given ಯಾವ date ಕೊಡ್ತಾರೆ?
Next week, any date, my lord.
Next week ಇಲ್ಲ. Next week ಎಲ್ಲ ರಜಾ ಇದೆ, 3 ದಿನ working day. Yes. 33.
38.
Go back.
ಅಣ್ಣ 34 ಫೈಲ್ ಅಣ್ಣ 34 ನೋಡಿ ನೋಡ್ರಣ್ಣ 34 ಇದೆ ತಗೊಂಡು ಹೋಗ್ಬಿಡ್ರಣ್ಣ ಆರಾಮಾಗಿ ನೋಡ್ರಣ್ಣ ಆಮೇಲೆ ನನಗೆ
ಹೇಳಿದ್ರು ಕೊಡ್ಲಿಲ್ಲ ಸಬ್ಮಿಟ್ ಮಾಡಿ ಬರ್ಲಿ ಅಂತ ಹೇಳಿ
ಅದಕ್ಕೆ ಕಾಯ್ತಾ ಥ್ಯಾಂಕ್ ಯು.
ಕಮಿಷನ್ ಏಜೆಂಟ್ ready 43 ಹಾ ಬರ್ತೀನಿ ಊಟ ಮಾಡ್ಕೊಂಡು ಬರ್ತೀನಿ
Is yours.
ಒಂದೇ ನಿಮಿಷ ಹೋಗಿ ಬಂದೆ ಊಟ ಮಾಡ್ಕೊಂಡು ಬರ್ತೀನಿ ಫಾಸ್ಟ್ ಆಗಿ ಈಗ ಊಟ ಮಾಡ್ಕೊಂಡು ಬನ್ನಿ
ಎಲ್ಲಾಸ್ ಇದಾಗಿದೆ. ಅದ್ರಲ್ಲೊಬ್ರು ಅಡ್ವೊಕೇಟ್ ನಿಂತಿದ್ದಾರೆ, ಒಬ್ರು ಇಲ್ಲ. ಸೇಮ್ ಪರ್ಸನ್ಸ್ ಇದ್ದಾರೆ.
ಸರಿ ಹೋಯ್ತಾ ಹೋಗ್ಲಿ ಈಗ
ಬ್ಯಾಂಕಿಗೆ ಬರ್ದಿರಿ.
Who told you that it will not be considered? Next is yours, madam. It's only after calling out the matter it will come to know that whether it will be considered or not.
I was told to ask for a date. No, I want the hearing to be there. I'm coming from outstation, sir. Yes, sir. Yes, sir.
20.
ಇದಾರ ಊಟ ಆಯ್ತು ಅವ್ರದ್ದು? Yeah, you are from Hyderabad, right? Yeah, tell me. You tell, I have come all the way from. Neglect them, don't see them at all. Be on your front line to reach your objective. That's what I do. Sit, madam, I tell the court officer to support you. Sit. One madla. Huh? Sit, madam. It is your seat. See, you need to be more confident. When you are hitting the opponent. Sir, ಊಟಕ್ಕೆ ಕರೆದ್ಬಿಟ್ಟು ಹಿಂಗೆ ನೀವು ಮರೆ ಆಗ್ಬಿಟ್ರೆ ಸರ್ One minute.
afternoon election petitions will be taken. And no. After the election petitions are over, the rest of the cases in the list will be called. It will come after the election petition because it is fixed for 230 matters.
Then
After that, all the election petition cases,
how many will be there?
I don't know. That
So
we
there is
should see
very
in the
thin
list.
chance
You
that-
find out in the list. No, not like that. You will be heard. Because you submit that you have come all the way from the long place.
But when has the submission time is gone?
No, time is not gone. Time is always there. Okay. Check up in the list. Check up in the list. How many 230 matters are there?
मुझे नहीं आता सर, help me. I don't know how to look.
ಇಲ್ಲ ಅವರು ಕೇಸ್ ವರ್ಕರ್ ಎಲ್ಲ ಕರಿ ಕರಿ. ಮೇಡಮ್ ಯಾರು ಬನ್ನಿ ಒಂದ್ ಸ್ವಲ್ಪ ಮೇಡಮ್. ಇದು ಆರ್ಡರ್ ಶೀಟ್, ಇದು ಪಿಟಿಷನ್, ಇದೇ ನಮ್ಮದು. ಎಕ್ಸ್ಟ್ರಾ ಕಾಪಿ ಬೇಡ ಇಷ್ಟೇ. ನಮ್ಮ ಸಾಹೇಬ್ ಇದನ್ನ ನೋಡಿ ಇದು ಹಂಗೆ ಹಾಕಿದ್ದೀರಾ, ಅದು ರೌಂಡ್ ಮಾಡಬೇಕು. ಅವರು ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಚೇಂಜ್ ಆಗಿದೆ. ಅಲ್ಲ ನಿನ್ನೆ ಆಗಿ ಹೋಗಿದೆ ಬಾಕ್ಸ್ಗೆ, ಮತ್ತೆ ಅಲ್ಲಿ ಯಾರು ತಂದು ಇಟ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಅವ್ರು ಯಾರು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಈಗ ಏನಿದೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್, ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಅಂದ್ರೆ ಯಾವ್ದ್ರಲ್ಲಿ ಎಲ್ಲಿರುತ್ತೆ? ನಿಮ್ದು ಹಳೆ ಫಸ್ಟ್ ಸ್ಕ್ರೂಟಿನಿ ಅಬ್ಜೆಕ್ಷನ್. ಅವ್ರು ಅದನ್ನ ಕೇಳ್ತಾರೆ, ಅದೆಲ್ಲಿದೆ ಹೋಗಿದ್ದ ಅದನ್ನ ಕೇಳ್ತಾರೆ. ಇದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್. ಈಗ ಇದು 1 ಎಲ್ಲ ಕ್ಲಿಯರ್ ಆಗಿದೆಯಾ?
ರೀಫಂಡ್ ಕೇಳಿದೆ ಮಾಡ್ಬಿಡಿ, ಮತ್ತೆ ಇನ್ನೊಂದು ಅಪ್ಲಿಕೇಶನ್
ಇಫ್ ಎನಿ ಅಂತ
ಜಾಸ್ತಿ ಇದೆಯಾ ಅಂತ.
ಬಟ್ ಇವ್ರು ಹೇಳೋ ಪ್ರಕಾರ ಪಾರ್ಟಿಷನ್ ಅಲ್ಲಿ ಇರಲ್ಲ ಅಂತಾರೆ.
ಒಂದ್ಸರಿ ಇರ್ಬೋದು, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಏನೋ ನೋಡಿ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಇರ್ಬೋದು.
ಇಫ್ ಎನಿ ಅಂತ ಇಫ್ ಎನಿ ಇಫ್ ಅಡ್ಮಿಸಬಲ್ ಆಸ್ ಪರ್ ಸೆಕ್ಷನ್ 66. ಅದು ಅವ್ರಿಗೆ ಇಷ್ಟ ಆಗಲ್ಲ ಯಾರು
ಬೇಡ ಅಂತ.
ಎತ್ತೊಳ್ಳಿ ನಿಮ್ದು ಅಡಿಷನಲ್ ಕಾಪಿ ನಿಮ್ಮ ಅದನ್ನ ಆಮೇಲೆ ಚೇಂಜ್ ಮಾಡ್ಬಿಡಿ ರೆಫರ್ ಶೀಟ್ ಅಲ್ಲಿ. ಇದು ಯಾರು ಬರೆದ್ರು ಅವ್ರ ಕಡೆನೇ ಕ್ಲೀನ್ ಆಗಿ ಬರ್ಸಿಸಿ.
Serial number 33, my lords. Appeal for respondent number 3. Inform ಮಾಡಿದೀನಿ petitioner. Date may be fixed in next week.
If I'm permitted, my lords.
They are insisting for a date may be fixed.
33.
Yes.
The difficulty is, my lords, about the promotion, which is granted to, my lords, my junior, denied to me, my lords, during the pendency, my lords, I superintended also. But there is an observation of this court that the matter can be considered irrespective of not such retirement. Not lordship may consider not there is urgency in that circumstance.
No, he wants time. What is your submission, Mr.?
ಅಲ್ಲ ಅಲ್ಲಿ ಯಾಕಂದ್ರೆ ತುಂಬಾ ಟೈಮ್ ಆಗೋಗಿದೆ ಆಲ್ರೆಡಿ. ಒಂದು ಅದಕ್ಕೋಸ್ಕರ ಹತ್ರದಲ್ಲಿ by next week your lordship may kindly have a date fixed, my lord, so that the matter can be
Request
considered.
of counsel for respondent number 3. Leave this matter on 3rd September.
With kind permission, this one passed over matter.
No, that you have election petition will be. Yes. You call pass over after that. Yes.
230 matter, serial number 49. Ramachandra G. Bhatt for petitioner. Serial number 49, Ramachandra G. Bhatt. Serial number 31, Vikas M. Sri Rupa Rai, petitioner 14% for Kanti Bhushan, B. Pramod.
I represent the respondent number 4, please, my lord.
I appear for respondent 1 to 3.
Sir, I want to make a submission for 3 points. One is that the duration of the area should be 29 months at the rate of 33% of pay and allowance under Section 31, 1957 Act, whereas only 27% of pay just for 8 months has been granted for me by the Navy. Number 2, Your Honor, the calculation memo is wrong, what they have submitted. They have suppressed the details of the dearness allowance, which is coming around 97,000. The third fact is there, Your Honor, my signatures are, somebody has forged my signature in the pension documents and withdrawn all the pension benefits, including, and also the retirement benefits such as gratuity and dearness allowance has been commuted. That's why to alter the calculation memo, that has directly affected, Your Honor. I got the RTI dated 23rd of August. So, but that has affected all the retirement benefits were already withdrawn long back, because on 29th of August I have tried asking the Navy RTI, asking to provide me the documents where my pen in the sir on. Sir, Navy has removed my spouse name and child name from all the official records of central government employee, my husband, which I brought to the notice of the court in September 2023. Based on that, there was an order to bring my husband and add his name to the contempt petition, Your Honor. So basically, my names were removed. My names were removed from the official records also. And there is also a disobedience of the contempt order.
Lords, Lords, petitioner, my lords, is the wife of respondent number 4, my lords. He is there, my lords. He is the husband, my lords. My lords, they have married on 2nd of February 2010, my lords. And respondent number 4 has also adopted the son of the petitioner as a son, my lords. There is adoption deed. Now, the wife,
Yes,
wife,
sir.
my lords, wife of respondent number 4. They have married in the year 2010. And my lords, and after that, my lords, after marriage, respondent number 4 has adopted the son of the petitioner as son, my lords. Through first marriage, she had got a son, my lords. That son has been adopted by the respondent number 4. Now, my lords, the claim of the petitioner is respondent 4 is working in the Navy. There seems to be some dispute between the husband and wife, my lords. So she is seeking for a maintenance for herself and the child, my lords. Pursuant to which, my lords, there was some communications between the petitioner and the department, my lords. Annexure A is issued, my lords, pursuant to that. If my lords may kindly peruse first, my lords, prayer, page 19. There are 2 prayers, my lords. First prayer is, my lords, challenging the validity of Annexure A and asking for revision of maintenance which has been granted. Second is, my lords, direction to, my lords, that withhold all the retirement monetary benefits which is payable to the respondent number 4 is the second prayer.
That was already.
In something. let them correct it if I am wrong. For that purpose, second prayer is made. Now, annexure A may be seen, my lords, for a moment, which is at page number 22, my lords. This is what is under challenge. Chief of so-and-so has approved an amount of maintenance allowance to Ms. So-and-so in accordance with section 31 of the Navy Act at the rate of 59,170 so-and-so with effect from July 22nd. Arrears of maintenance allowance for the period from so-and-so, excluding so-and-so, is to be recovered from the officer. However, in view of statutory limit imposed under section 32 of the Navy Act so-and-so with respect to limit of deductions that shall not exceed in any 1 month, 1/2 the individual pay and allowance for that amount which works out to be so-and-so. The officer is marked for the demob with effect from 31st of August 23. This is retirement minutes, date of retirement. Accordingly, the maximum recoverable maintenance allowance along with arrears to be recovered from the officer is as follows. A, maintenance allowance of so-and-so. Arrears of maintenance allowance to be recovered so-and-so. Total amount of 5,37,920 would be recovered from the officer as maintenance allowance, including arrears till 31st August 23. Balance of unrecovered arrears of maintenance allowance from the officer as on 31st August 23 would be rupees so-and-so. It is requested necessary action to be taken to pay maintenance allowance, including arrears with effect from April 23rd of at the rate of so-and-so, and the receipt of this letter be acknowledged. My lords, for the both wife and the child, my lords, maintenance allowance is taken from the salary, my lords. There is a provision under the Navy's Act, my lords, under section 31. My lords, if the sailor or the Navy person is working, my lords, with the department, my lords, if he's not taking care of his wife and child, my lords, there is a provision provided that up to the extent of 1/3, my lords, we have to give a salary deduction from over there and pay. ಇಲ್ಲ ಅದು ಬೇಕಾಗಿಲ್ಲ ಅವಾಗ ಬೇಕಾಗಿಲ್ಲ because the provision itself provides. Pursuant to this, it is done. My lords, from 31st August 23, he has retired, my lords. He is no more with us. Petitioner had filed a contempt petition, my lords. May just pass on the order in that one. Return ಏನಾಗುತ್ತೆ ಮೆಲೋಡ್ಸ್ ವಿ ಆರ್ ರೇಸ್ಡ್ ಡಿಫರೆಂಟ್ ಕಂಟೆನ್ಷನ್ಸ್. ಇದ್ರಲ್ಲಿ ತಾವು ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ನೋಡಿದ್ರೆ ಕಂಟೆಂಪ್ಟ್ ಆರ್ಡರ್ ನಲ್ಲಿ
instead of 33%, only 27% of pay is given to me.
That I will just explain it. Taken correct, my lords. My lords, operative portion is at page 20, my lords. There are various observations, my lords. It was this one, my lords. The official respondent shall forthwith release all the terminal benefits of service and the periodical accruing pension to the 7th respondent. 4th respondent was 7th over there, my lord. However, retaining that part of money payable as maintenance to the complainant under the commander's order dated 10/4/23. 10/4/23 is annexure A, my lords. The official respondent are directed to deduct from the pension payable to the 7th respondent such part of amount as is required to pay monthly maintenance to the complainant and remit the same to her bank account periodically. If and when the complainant withdraws her MC number 273 of 2023 in the second additional so and so, which she has undertaken to withdraw before us today and submits a certified copy of the withdrawal order. We direct the Department of Defense accounts. This is a direction given that pay the things and give all the ID cards, whatever it is there, to the complainant, my lords. And the last one is, my lords, the fourth one is complaint shall not object to the complaints of direction issued in the immediately preceding paragraph above, which mandates release of terminal benefits and periodical payment of pension to the 7th respondent. Should she raise any such objection, the official respondent may withhold the payment of maintenance amount till after the appropriate orders are obtained by in the pending WP. This is the pending WP, my lords, which is there. Next page, my lords, nothing herein above observed shall be construed as prejudicing the contention of the 7th respondent in the complainant's pending WP number so and so, in as much as all such observations are made only for the purpose of disposal of this case. Now, my lords, the two relief which were sought was, my lords, validity of annexure A and saying that don't release pensioner benefits. Second relief, my lords, because of this direction, we have released it, my lords, as we can't withhold it. By this court, whatever it was there, it is paid, my lords.
Official respondent shall forthwith release all the terminal benefit of this and periodical occurrence pension.
Howdo? This is complied, my lords.
However, retaining
My lords,
part of the money payable to the maintenance of
complainant.
under the
My lords, it has been paid to the complainant. Her case is,
they are disputing that.
no, she's saying instead of 1/3, it should be the amount, whatever the amount part it is there, my lords. She is receiving it, but she is trying to say what we are paying is
Here it
not
is not received.
proportional.
Not receive, Your Honor.
Lord, may I make a submission?
33%, 22% would be for the spouse and 11% for the child. In case there are two children, it will be 5.5 each. Making, for I have one child, so it is making 11%. And 33% of pay and allowance, that is the dearness allowance. If you see the calculation memo, which is. Your Honor, yes.
I'll just pass on the relevant rule, my lords.
Lord, may I make a submission, please, my Lord? Lord, the annexure A where the writ petitioner is challenging, seeking for enhancement of the maintenance allowances granted by the naval authorities.
Area.
Lord, our submission, please, my Lord, is, my Lord, the alternative remedy is available for the petitioner is under section 14 of the Armed Forces Tribunal Act 2007. Where any aggrieved person by virtue of these orders passed by the naval officers can be challenged before the tribunal, agitating their whatever grievances before the tribunal. So since being there is an alternative remedy available for the petitioner may be directed to approach the appropriate forum with appropriate petition.
I do not wish to, because there was a discrimination against me. They have purposely, in spite of knowing that there's a marital discord.
31, my lords. Section 31. Navy's.
The order is passed under section 31 of the Navy Act, whereas the appeal provides under section 14 of the Armed Forces Tribunal Act.
31, if my lord says, my lords. Liability for maintenance of wife and children. 1. The person subject to naval law shall be liable to maintain his wife and his legitimate or illegitimate children to the same extent as if he were not so subject. But the execution enforcement of any decree or order for maintenance passed or made against such person shall not be directed against his pay, his personal pay, arms, ammunition, equipments, instrument, or clothing. Notwithstanding anything contained in the subsection 1, where it appears to the satisfaction of the central government or the chief of naval staff or the prescribed authority that a person subject to naval law has without a reasonable cause deserted or left in destitute circumstances his wife or any legitimate child, unable to maintain himself, or has by reason of contracting a second marriage become liable to provide separate maintenance to his wife, or where any decree or order is passed under any law against a person who is or subsequently becomes subject to naval law for maintenance of his wife or legitimate or illegitimate children, and a copy of decree or order is sent to central government or the chief of naval staff or the prescribed authority. Central government or the chief of naval staff or the prescribed authority may direct a portion of his pay of the person so subject to naval law to be deducted from his such pay and appropriated in the prescribed manner towards the maintenance of his wife or children. But the amount deducted shall not exceed the amount fixed by the decree or the order, if any, and shall not be at a higher rate than the rate fixed by the regulation made under this act in this behalf, provided that in the case of a decree or order or maintenance referred to above, no deduction from pay shall be deducted unless central government or the chief of naval staff or the prescribed authority is satisfied that the person against whom such decree order has been passed or made has had a reasonable opportunity of appearing or has actually appeared either in person or through a duly appointed legal practitioner to defend the case before the court by which a decree or order is made, passed or made, where it speaks of the areas also, my lords, where areas of maintenance under a decree that goes on, my lords. Percentage I will point out, my lords.
There is a review.
If my lords is 32.
33 it is coming.
except when the deductions are made under subsection 1, 2, and 4 of section subsection 28 or subsection 1 and 2 of section 29. Total deduction from the pay. Sorry. From pay and allowance of an officer or sailor shall not exceed in any 1 month one half of his pay and allowance for that period.
This is.
And my lords, along with our objection.
Subsection 28 and 29. What is 28, 29?
Please, my lords, I'll just. 28 is, my lords, deduction from pay and allowance of officers. The following deductions may be made from the pay and allowance of an officer without recourse to trial by a naval tribunal, namely, all pay and allowance for every day of absence without leave unless general, my lords.
Any reason behind this?
Beyond that, my lords.
My lord.
If my lord sees, my lords,
What is the law?
my lords, in our
Deductions are made under the section.
My.
So the total deduction from the pay and allowances of the officers or the sailors shall not exceed any 1 month half of his pay and allowance for the month. Andre 50% you can deduct.
ಇಲ್ಲ ಅದರಲ್ಲೂ ಬರುತ್ತೆ. My lords may kindly see my objections at page 28, my lords. There is a details which we are given it along with my objections, annexure R3. My lords, if my lords permit, I will read from the background or it will clear the facts, my lords. Page 28 ನಲ್ಲಿದೆ background ಅಂತ ಇದೆ. 28.
Yes.
It's a reassessment of maintenance allowance in the heading. This one. Background. Wife of so-and-so had previously forwarded her application dated 22nd November 21 seeking maintenance allowance from IN for herself and the child. Post-examination of maintenance application, the competent authority at the headquarters, MOD, did not approve the grant of maintenance to the lady under section 31 of the Navies Act, and the Honorable Family Court, City Civil Court, Hyderabad was already seized of the maintenance issue under section 125 of the CRPC. Post communication of the decision of the competent authority, the lady withdrew her petition for grant of maintenance under section 125 of CRPC from the Honorable so-and-so and submitted an application dated 22nd July 2022 to so-and-so seeking maintenance allowance. Simultaneously, the lady filed a writ petition number so-and-so before the Honorable High Court of Karnataka at Bangalore seeking issuance of direction to the Indian Navy towards consideration of her application dated 22nd July 22 for grant of maintenance. The Honorable High Court of Karnataka at Bangalore, by order dated 18th October 22, directed the Indian Navy to consider the lady's application dated so-and-so for grant of maintenance by giving an opportunity of hearing to the husband and pass appropriate orders in accordance with law. Accordingly, the competent authority at so-and-so had approved grant of maintenance allowance to the lady and the child, rupees 59,170 point so-and-so, rupees 47,336 for wife and rupees 11,834 for child with effect from July 22 with arrears of rupees 2,89,196 for which period from July 22 to January 23 be recovered in 7 installment of rupees so and so each. Present status. The Honorable High Court of Karnataka.
This is only that. See, whatever you are granted, it is lesser than that what is prescribed under the.
My lords, that rule position, my lords will get at page 29. 29 rule position the ಹೇಳ್ತಾ ಇದೆ. 7. As per section 31(1) of the Navies Act, the execution or enforcement of any decree or order for maintenance passed or made against the person subject to naval law shall not be directed against his pay, arms, ammunition, equipment, instrument, or clothing. Further, section 31(10) of the Navies Act state that the expression pay includes all the sum payable to the person subject to naval law in respect of his services other than the allowances in lieu of lodging, ration, provision, clothing, and traveling allowance. Also, as per the statutory review order SR so-and-so, maintenance allowance should not exceed 1/3 of such pay in respect of wife and children of such person and 1/4 of such pay in respect of illegitimate of such person. As apparent from the relevant rules, the deduction under the section 31 of the Navy Act shall not be at a higher rate of 1/3 of the pay in respect of wife and legitimate children of such person. Further, as a matter of policy and considering the aspect of maintenance. ಅಲ್ಲ
33%.
ಅಲ್ಲಿ ನೀವು ನೋಡಿದ್ರೆ 3110 ನಲ್ಲಿ ಪೇ ವಿಚ್ ಇನ್ಕ್ಲೂಡ್ಸ್ ಆಲ್ ದಿ ಸಮ್ ಅಲ್ಲಿ ಇದಾಗುತ್ತೆ.
What are the payment has to be made, which is different. First we'll come to that, what is the percentage? 1/3 means 33.
ಅದ್ರಲ್ಲಿ ತಾವು ನೋಡಿದ್ರೆ ನೆಕ್ಸ್ಟ್ ಇದೆ ಸ್ವಾಮಿ. Following guidelines are added to 22% of a individual's paid allowance in respect of wife, 5.5% of an individual's paid allowance in respect of each legitimate child staying with the mother too is entitled to be maintained the person. 22%.
Higher rate of 1/3 of the pay
Hmm.
for wife and legitimate children of such person. 1/3 ಅಂತ ಇದೆಯಲ್ಲ.
ಹೌದೌದು. ಅದರಲ್ಲಿ ಎಷ್ಟು ಅಮೌಂಟ್ ಅಂತ ಬರುತ್ತೆ?
First you say it is not 33%.
1/3 ಅಂತ ಹೇಳ್ತಾ ಇರೋದು.
1/3 ಅಂತ ಅಂದ್ರೆ ನೀವು 33% ಅಲ್ವಾ?
ಅದು ಅಮೌಂಟ್
33% ಆಗುತ್ತೆ.
ಹೇಗೆ ಅರೈವ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ. 1/3 ಆಫ್ ದ ಪೇ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ವೈಫ್, ದಟ್ ಇಸ್ ವಾಟ್ ಇಟ್ ಇಸ್ ಸೆಡ್ ಅಂಡ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಟೇಬಲ್ಸ್ ಕೊಟ್ಟಿದ್ದೀರಿ. ಒಂದು ತೋರಿಸ್ಬೇಕು. 22% of an individual paid allowance in respect of any legitimate child not staying with the father or mother. ನೈನ್ ನಲ್ಲಿ ತಾವು ನೋಡಿದ್ರೆ ಹೇಗೆ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದಿರಿ ಅಂತ ಡೀಟೇಲ್ಸ್ ಇದೆ.
See, 1/3 of that such pay in respect of the wife and children of such person. Yes.
Your Honor.
ಆ ಟೇಬಲ್ ನಲ್ಲಿ ತಾವು ನೋಡಿದ್ರೆ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಆಫ್ ಮೇಂಟೆನೆನ್ಸ್ ಅಲೌನ್ಸ್ ಹೌ ಇಟ್ ಇಸ್ ಡನ್ ಅಂತ ಇದೆ 9 ನಲ್ಲಿ. Considering the limitations enshrined under section 31 of the Navy's Act and SRO so and so and the extent guidelines, the maintenance allowance in respect of Mrs. so and so and the child was calculated as under A. Total pay of the captain so and so for December 22. Idu amount so 3,36,000. Mandatory exemption from total pay allowance TPT, DA, RME and so. Idu mandatory deductions du barta ide. Then net payable available for calculating maintenance allowance is there, my lords.
Your Honor.
Amount of maintenance.
First, what is the total amount? Adralli 1/3 ಇಷ್ಟು ಬರುತ್ತೆ ಅಂತ ಹೇಳ್ಬೇಕು. ನೀವು ಇಷ್ಟು ಅಮೌಂಟ್ ಹೇಳಿದಿರಲ್ಲ, whether it is 1/3 or not, how can you make out?
ಇಲ್ಲಿ 22% ಅಲ್ಲಿ ತಾವು ಈ ನಲ್ಲಿ ನೋಡಿದ್ರೆ ಅಮೌಂಟ್ ಆಫ್ ಮೇಂಟೆನೆನ್ಸ್ ಅಲೌನ್ಸ್ ಫಾರ್ ದಿ ವೈಫ್ ಅಟ್ 22% ಆನ್ ನೆಟ್ ಪೇಯಬಲ್ ಆಫ್ ದಿ ಆಫೀಸರ್ ಇಸ್ ಇಂಡಿಕೇಟೆಡ್, my lords. 47,000 DE ನಲ್ಲಿ.
Honor.
Mother is also entitled to maintenance by the person subject to the maintenance amount shall be restricted. Child get restricted to 11%.
11%.
There, it will restricted to 11. Otherwise 22% ಅಂತ ಅದೇ ಹೇಳ್ತಾ ಇದ್ದೀರಾ. Mother ಗೆ 1/3 is there, that 33%.
ಹೌದು.
7%.
Yeah. So here the B and C is manipulated. They have suppressed the dearness allowance. Actually, the dearness allowance and gratuity has been commuted. It is showing in the pension order, pension details of my husband. I have it. It's showing 0% because it has.
In that amount you are entitled.
Yes, sir. Pay and allowance. 33% of pay is the basic pay, and allowance is the dearness allowance, which the government gives to, to take care of the growing expenses. So that has been manipulated. They are saying mandatory.
Showing that 0 because he has taken a loan or something. Whether that can be deducted.
Mandatory amount.
Just because he has taken a loan, she cannot be denied. That's what she is saying. That what is the law that?
My lords, at that time, my lords, he was under our service, my lords. After August.
Contempt court said even after that pension you have to do it. You have to accept it. That is what that.
That it is there, my lords.
Otherwise, after retirement, we can.
I can't have any grievance, and even the Army's tribunal is there, my lords. Where
they can't say that there is an alternative remedy. Contempt court said that you raise everything in this case and you have to decide. Now we can't say that go on because reason benches direct.
That's in the contempt act.
Whether that DA, she is entitled for 33%. Just because it is committed, can you deny that? That if that is so, show me that which is the law. That is what that she does. And you give that first, you give a picture. Salary is of rupees 10 lakhs.
then we can say that what is the 33% of 10 lakh. If you say that 3 lakhs, we can't say that whether it is a 33% or 25%. First you give that this is his salary. Then after the retirement, his pension is this. In that 33% is, you give the tabular, then you can understand that. Then also answer that whether DA, he is entitled, she is entitled or not. That you give the tabular, yes ma'am.
Your Honor, they have manipulated here in point number B. They are saying that mandatory exemption is DA. DA cannot be a mandatory expense. Dearness allowance, it cannot be a mandatory expense, like mandatory deduction.
For that we are asking that he has to answer whether it can be exempted.
I'll ascertain, my
If
lord.
it is not exempted, then just because it is committing, it can be reduced to the petition.
I'll ascertain, my lord.
That we have to answer. And we make a chart, separate chart. This is the salary. 1/3 there is no dispute. 1/3 comes to 33%. 11%. If there is no wife, if it is only a child, it is 22%. If maintenance to that wife, then child will get only 11%. That is what that your rule.
Yeah, they've mentioned what it is mentioned. That's the
So-
thing.
Yes.
One more. There is a contempt of the 259, disobedience of the contempt order also, Your Honor. I was clearly directed to provide me with the medical card for me and my child till he turns 25. And what they did, they have given me a card which doesn't have any pin, so it is not functioning. And I have tried approaching the Navy through email also. They are denying. They are saying that it is between you and your husband. So
ಅದು ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀರಿ. ಅವ್ರು ಏನಂತಂದ್ರೆ
It's
ಪಿನ್
like a debit
ಪಿನ್
card.
ಹಾಕ್ಬೇಕು. ಈಗ ಹೆಂಗೆ ATM ಕಾರ್ಡ್ ತರ ಪಿನ್ ಇರುತ್ತೆ, ಅದು ಪಿನ್ ಇರುತ್ತೆ, ಅದು ಅವ್ರ ಹಸ್ಬೆಂಡ್ ಶೇರ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. We have provided.
If there is any violation of the contempt court order, you have to file an application. This is very used and I can't do it.
We have provided
Yes, my
everything.
lord.
If this direction is not complied,
That card is
Yes, ma'am.
provided in the open court in the contempt proceedings.
Without pin.
The PIN number is written in the pouch.
No.
all that will be decided by that court with the direction.
ಅಲ್ಲ ಅದಿದ್ರೆ it's between the petitioner and R4. I can't do anything. We have provided the details. They have given the card. Pin ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ it's between them.
ಇಲ್ಲ ಅಂತಂದ್ರೆ ಅಲ್ಲಿ court ಅಲ್ಲಿ ಹೇಳಿದ್ರೆ ಅವ್ರ ಆರ್ಡರ್ ವೈಲೇಟ್ ಆಗಿದ್ರೆ
ಅವ್ರು ಇದ್ ಮಾಡ್ಕೋಬೇಕು. ಅದ್ರದ್ದು ನಮ್ I can't.
Yes, you file this detail.
I will provide
If
this.
the order is not compliant, you can go to the contempt court only.
Yes, my lord.
That amount which has to be given and all will determine.
I'll get the details.
You get that instruction.
For 29 months, it is calculated. If it is even
All that is now that it is not correct, it appears to be. Therefore, we are asking that to give a split up figure.
Yes,
What
my
is
lord.
his salary? 33% of the salary is this. This is the dearness allowances, 33%. Like that, let me
Yes.
give that split up.
Yes, my lord.
And
Thank
whether
you.
in the DA you are not entitled, why it is not entitled, he has to give an explanation.
Yes, my lord.
Give that. When will you give, Mr.
Let's, I'll request some time to get the details. ಸ್ವಲ್ಪ time ಬೇಕಾಗುತ್ತೆ.
When do you want, madam?
After 1 month.
Yes. On 8th or 9th December, October.
Okay,
Yes,
okay,
9th October.
okay,
Please.
Your Honor.
Meantime, you file it and serve a copy to.
Please, please.
My lord, meanwhile, if the PIN can be shared, my son has to go through medical procedures.
My lord, the PIN is written in the pouch which we have provided to her, my lord. It is
No,
visible in
there,
the pouch.
I have the card. Their PIN is not given.
My lord, kindly look, my lord, kindly direct her to look into the pouch. Pouch, it is written. It's the pouch. it
Let
is
him
written.
give him the PIN. What is there in that?
Give one more time. No problem. Same thing now. If you give second time, she can't use it for it. Because second card, same card you have to give an.
By email?
Number of the petitioner. You send a SMS, that PIN.
Email or email?
Email. If
We have no access to the PIN. PIN already is there. Anyhow, I'll
There-
find out with the
PIN is
petitioner, please, my lord. Provide either and through an SMS or through email, please, my lord.
you provide your
I
email.
will find out with the petitioner.
Yes, Your Honor. To whom I have to give?
That
I'll give it to him, Your Honor. He has, Your Honor. Thank you so much.
Cell number 32, 33, adjourned. Cell number 34, Shrikant MP for petitioner, Brijesh Patil.
For petitioner. Yes. My lord, the matter pertains to, my lord, the appointment to the post of principal in the institution. Your lordships heard the matter, my lord. I'm with a PhD qualification. My lords, my student is appointed, my lords, the current recruitment rules of the Parishad, my lords, which I brought to your lordship's notice. Page number 47, my lords, of the petition.
Yes.
That is, my lords, promotion from the cadre of professor reader if no suitable person is available for promotion by direct recruitment. Though, my lords, I was there in the institution, they went for direct recruitment. Your lordships, my lords, wanted the other side to place material, my lords, as to why they went for direct recruitment, my lords, without verifying the fact that, my lords, we were there. And how the issue is considered, my lords. Till now, a reply is not filed.
Yes. In which school, Mr.? Where you are? University. Yes, where you are working? Where you are working?
My lords, I am an employee of Chitrakala Parishad. My lords, I am
Chitrakala
working Chitrakala Parishad. My lords, I am working
And
as,
that-
my lords,
Who has to give that promotion?
I'm for the respondent
my
number.
lords, the management.
Chitrakala Parishad, my lord.
Management.
But I'll file my written
Management.
objections in this matter. I'll file
No,
my
why you have
objections.
not filed it from
But
2024?
It is ready, my lord. It is ready. The
What
only
is
thing
your,
that-
why you are not giving a promotion? You are going for a direct recruitment when there is a
Lord, because he's not the eligible.
not eligible.
That is my case. And my lord, it is not even the college who decides. There is an external jury of 6 members who were appointed, and they were the ones, my lord, who had conducted the interview and selected. And I'm not even the one who selected.
No, a copy is served to you, Mr. Objection.
No, my
I'll
lords,
have
it
to
is
file
not
it, my lord. It is ready.
You serve a copy to him and file it in the
Please,
counter.
I'll
We'll
file
have
it
it next.
counter.
Yes. When do you want?
Next week, my lord, I need it. Ready.
Yes, leave this matter on 11th.
It will-
Yes.
Can it be, my lords, on 3rd, my lords, another matter is being listed,
Yes, 3rd.
obliged.
Cell number 35, Raghupati MJ for petitioner, connected matter, Subramanya Bhattiyam.
Yes.
This is the case of.
What is this, Mr.?
The appointment of Gram Sahayak, my lord.
Lord, in this case, on the last occasion,
Hmm.
Lord, your lordship.
No, that I have raised one question that, what is that point which has been raised?
Lord, that is your lordship wanted to
There is
know
a
the.
notification for the recruitment of the Gram Sahayak, my lord.
Hmm.
But in this post, my lord, as per the circular of 1978, there is no notification for appointment. It is meant for the particular community and particular family, my lord. That is the, as per that, my lord, the petitioner was appointed to the vacant place of the one Govindappa. My lord, as per annexure,
Where is your appointment order?
Lord, your lordship
annexure
wanted-
B, my lord.
My lord,
Annexure?
May I make this submit?
Yes.
Your lordship wanted to see the notification pursuant to which appointment has taken place.
Yes.
Lord, may I just pass on?
Yes. Yes, Mr.
Please,
Now
my lord.
that you are appointed as what?
Lord, as Gram Sahayak, my lord.
When?
Lord,
What is that annexure A you are challenging?
but I'm not annexure AA is my termination order. Lord, without given opportunity for giving explanation, they terminated the petitioner from the post of Gram Sahayak, my lord.
Annexure A?
AB, my lord, 83, page number.
ಕವಿಶ್ವರು ವಿಚಾರಣೆ ಮೊದಲಾಗಿ ಸಲುವಾಗಿ ಹೊಸದಾಗಿ ವಾಸಸ್ಥಳ ಪ್ರಮಾಣ ಪತ್ರ, ಪಡಿತರ ಚೀಟಿ, ಚುನಾವಣೆ ಗುರುತಿನ ಚೀಟಿ, ಬ್ಯಾಂಕ್ ಪಾಸ್ ಬುಕ್, ಮನೆ ಬಾಡಿಗೆ ಕರಾರು ಪತ್ರ ಮತ್ತಿತರ ದಾಖಲೆಗಳನ್ನು ತಿದ್ದುಪಡಿ ಮಾಡಲು ಪ್ರಯತ್ನಿಸುತ್ತಿರುವುದು ದಾಖಲೆಗಳ ಸಮೇತ ಕಂಡುಬಂದಿದ್ದು ಹಾಗೂ ಸರ್ಕಾರದ ಆದೇಶದಡಿ
Why he has been terminated from the service?
My lord, this is a second round litigation.
Hmm.
Earlier litigation, my lord, the authority has been dismissal from service without holding an inquiry. Alleged that the petitioner is remaining unearthed absent, and against that post, the third respondent has been appointed. So thereby, this honorable court has been set aside the appointment of the third respondent and termination of the petitioner and giving liberty to conduct the inquiry, issuing a notice, my lord. My lord, thereafter, without issuing the notice on the subject of the unearthed absent, the authority has been issued a notice calling for my testimonials. I produced the testimonials now saying that it is not a pertaining to the post of the Mandi, the present circle.
Yes.
Alleging that though it is not pertaining to the as per the recruitment of.
Where is that notification for appointment?
My lord, before that, my lord, I clarified that what is the process for recruitment of this gram cycle. My lord, page number 87 is there. What they are contained by the impugned order. Please, my lord. ಕೆವಿ ರಮೇಶ್ ಕುಮಾರ್ ಅವರು ಮೂಲ ಕಂದಾಯ ವೃತ್ತದ ಗ್ರಾಮ ವಾಸಿಯಾಗಿರುವುದಿಲ್ಲ. ಕೇವಲ ಗ್ರಾಮ ಸಹಾಯಕರ ಹುದ್ದೆಯಲ್ಲಿ ಪಡೆಯಲು ಲಾಭಾಂಶ ಮನೋಭಾವದಿಂದ ದಿನಾಂಕ 6/11/23 ವಿಚಾರಣೆಗೆ ದಾಖಲೆಗಳನ್ನು ಒದಗಿಸುವ ಸಲುವಾಗಿ ಹೊಸದಾಗಿ ವಾಸ ಸ್ಥಳ ಪ್ರಮಾಣ ಪತ್ರ, ಪಡಿತರ ಚೀಟಿ, ಚುನಾವಣಾ ಗುರುತಿನ ಚೀಟಿ, ಬ್ಯಾಂಕ್ ಪಾಸ್ಬುಕ್, ಮನೆ ಬಾಡಿಗೆ ಕರಾರು ಮತ್ತಿತರ ದಾಖಲೆಗಳನ್ನು ತಿದ್ದುಪಡಿ ಮಾಡಲು ಇತ್ತೀಚಿನ ದಿನಗಳಲ್ಲಿ ಪ್ರಯತ್ನಿಸುತ್ತಿರುವ ದಾಖಲೆ ಸಮೇತ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಹಾಗೂ ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ದಿನಾಂಕ 22/3/79 ಆದೇಶದಂತೆ ಗ್ರಾಮ ಸಹಾಯಕರ ಹುದ್ದೆಯ ನೇಮಕಾತಿ ಸಂದರ್ಭದಲ್ಲಿ ವಂಶಸ್ಥರಿಗೆ ಪ್ರಥಮ ಆದ್ಯತೆ ನೀಡಬೇಕೆಂದು ಆದೇಶವಾಗಿರುತ್ತದೆ. ಅದರಂತೆ ಸರ್ಕಾರಿ ನಿಯಮ ಉಲ್ಲಂಘನಿಸಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. That is, my lord, my learned friend has produced in the reply statement annexure R3 page number 25, my lord, that is circular 22/3/1997.
Annexure R3,
my lord, page 25, my lord.
Yes.
Well, I permit to read second para onwards, my lord. The intention of the government is to be restricted the scope of the recruitment of the gram cycle to the member of the family of the interior village servant who are working as such during the previous year. The deputy commissioner of all the district are therefore requested to issue necessary instruction to the Tahsildar to adopt the following procedure. Addition to the procedure mentioned annexure 2, the GO with 15th September 1978 stated above, the selection of the candidate for the appointment to the newly created post of Grama Sahayaka, several villages for the group of village. The selection by the Tahsildar should be confined to the member of the backward family of inferior village officer like Thotis, Nirgantis, Talaris, Setis, Sendi, Malikar, so on, so on. I mean, the petitioners belongs to the Melada, the Talwar Inamati family, my lord.
Yado?
Talwar
Inam. Yes.
Please, my lord. While he belongs to the Barbar, the registered list, my lord, the community, my lord. My lord, the circular says that the priority is given to the particular caste and particular family members. Thereby, annexure B has been passed. Kindly page number annexure B, my lord. Page number 20.
Page number
20. It is my appointment order, my lord.
No, appointment is called to the post of Grama Sevaka. To which village, mister?
It is, my lord, Mandikal village.
Mandikal. Yes. Your family is Talwar. Yes.
But as per the 78 circular, priority for that particular is, my lord. But thereby, my lord, on 3/1/2020, a Govindappa was reached age of superannuation in the Mandikal circle, my lord.
No, what is that annexure A? Annexure A in Torsidri new.
Annexure A is circular.
Circular, yes.
Right, that is, my lord, without holding an inquiry, they are not terminated for the Gram Sahayak post, my lord.
First yarn appoint madidru allige Mandikal ge.
First appointed with for the petitioner, my lord.
Petitioner.
Please, my lord. My lord, on 31/5/2010, the Govindappa was retired on the age of superannuation, my lord.
31/10?
31/5/2010.
2010.
But please, my lord. From that date onwards, the petitioner was discharging his duty as Gram Sahayak, my lord.
ಏನ್ ಅದಕ್ಕೇನ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ಏನಿಲ್ಲ.
No, as per the direction of it has to be meant for particular community, my lord.
Who is that earlier who was working?
Govindappa.
Who is he?
Govindappa also belongs to the such community.
ನಿಮ್ ಫ್ಯಾಮಿಲಿ ಯಾರ?
A family, it is our relative agdare.
Yes.
Even though with concern of that family, has to give an appointment, my lord. That has been specified that in the recruitment process, my lord, 5 member has been file an application for that post, my lord. After the direction of the deputy commissioner.
ಆಯ್ತು, ನಿಮ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಏನು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿಲ್ಲ ಅವರು.
Please, my lord.
ನಿಮ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಾ ಇದಾರೆ.
No, there is no dispute about that also, my lord. Because I was working from 2010. I am residing that Mandikal circle. I would transfer my voter list, my Aadhaar card, my residential certificate, my income certificates, because I am staying in the Mandikal circle. I obtained all the necessary documents, my lord.
No, as on the date when you were appointed.
Please, my lord.
Where you were residing?
Madam, but it's Kanithalli. There is not a dispute, madam.
Gani?
Kanithalli.
Ganithalli. How can you be appointed as a Grama Sevaka if you are not a resident of that village?
That is not an issue. That's why, madam. That's not an issue. That 78 circular is specifically for meant that particular family, particular category.
Where is that circular you said?
Now that is read.
Is it that from that village or anybody can be appointed?
The priority for village is the community, my lord. Page number 26. The selection by the Tahsildar should be confined to the member of the Barbadar family of inferior village of the officer like Toti, so and so, so and so, so and so.
ಈ ಕಮ್ಯುನಿಟರಿ ಕೊಡ್ಬೇಕಂತ ಅಷ್ಟೇ ಹೇಳಿರೋದು. ಪ್ರಯಾರಿಟಿ ಏನಿಲ್ಲ ಅಲ್ಲಿ.
Next class ನೋಡಿ.
Please,
next ಓದಿ.
The eligible member of the such family of the village or villages of the revenue circle of the village accountant will be interviewed in the group of the Tahsildar to the given the time for select the best among them to the basis.
Eligible member of such
family
of the village.
Please,
or that village of that revenue circle.
Please,
of the village accountant will be interviewed. Andre ಆ revenue circle ಒಳಗಡೆನೆ ಇರಬೇಕು ನೀವು.
The first is, my lord, belongs to the
ಅದು ಆ village circle ಅಲ್ಲಿ ಇರಬೇಕು.
Please, my lord.
ಅವರಿಗೆ ಪ್ರಿಫರೆನ್ಸ್ ಕೊಡಬೇಕು ಅಂತ ಇರೋದು.
Please, my lord.
ನೀವು was there in that village circle.
Madam, at the time of 2010, so I was Kanithalli.
Kanithalli is coming that village circle.
No, madam.
Then
please, my lord, please. The priority, my lord, 78 rules is what particular family, my lord.
Particular family in that village.
Please, my lord. Please, my lord. Even also, my lord, the priority for that person is given to the 2010. So I was working, so I obtained the certificate because of the residence that particular.
Now their allegation is that you are not belongs to that village. Now you are creating the documents to.
Not creating, my lord. For
allegation.
Please, my lord. For providing appointment, I am residing that Mandikal circle. I obtained that certificate and discharging the duty, my lord. Then, my lord, 2019. They are been terminated me without warning an inquiry. Please, my lord.
ನಾವು ಈಗ ನೋಟಿಸ್ ಕೊಟ್ರು, ನಿಮ್ಮನ್ನ ಟರ್ಮಿನೇಷನ್ ಮಾಡಿರೋ ಉದ್ದೇಶ ಏನು ಅಂತ ಅಂದ್ರೆ ನೀವು ಆ ವಿಲೇಜರ್ ಅಲ್ಲ ಅಂತ.
Please, my lord. I am not resident. I am resident. I am residing from 2010. My appointment is 2017.
No, you after appointment ಅಲ್ಲಿ ಹೋಗಿದ್ದೀರಾ.
Please, my lord.
But you are not the permanent resident of that village. That is what their case.
Please, because, my lord, the first instance is, my lord.
ಕೆಲಸ ಸಿಕ್ಕದ ಮೇಲೆ ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ಇರ್ತಾರೆ. ನೀವು if you get a job in that UK, you will go on working in the UK. You not say that I am a resident of UK.
Allah, that is not the issue, my lord. Here, my lord, I am being appointed that post, my lord, because I am belongs to.
ಅಲ್ಲಿ ಉದ್ದೇಶ ಏನು ಅಂತ ಅಂದ್ರೆ ಆ ಕಮ್ಯುನಿಟಿ ಇದಾರಲ್ಲ, ಅವರು ಆ ಊರಿನಲ್ಲೇ ಇರೋರು. ಹಿಂದೆ ಅವರೆಲ್ಲ ಏನಾಗಿದ್ರು ಅಂತಂದ್ರೆ ಅವರೆಲ್ಲ ಹಳ್ಳಿ ಇದಾಗಿದ್ರು. ಅವ್ರ ಫ್ಯಾಮಿಲಿಲೇ ಯಾರಿಗಾರ ಕೊಡ್ಬೇಕು.
That's why, my lord.
ಉದ್ದೇಶ ಅಷ್ಟೇ ಇರೋದು.
That's why.
ಬೇರೆ ಬಂದ್ಬಿಟ್ಟು ನಿಮ್ಮ ಹಳ್ಳಿಲಿ ನೀವು ತಗೋಬಹುದು ಅಂತ. That is what that is it, Mr. Government Advocate? Yes. Now how you have been appointed that even though he is not a resident, Mr. You have allowed him to continue for 10 years.
Any length of service, my lord. If appointment has been obtained by illegality, my lord, they don't get the benefit of Article 311. There is no such protection as per the Apex Court's full bench decision in Vishwanath Pillai case, my lord.
Yes.
And also, my lord, any length of service will not confer legitimacy on an illegal appointment. That is my submission.
Yes.
May I pass on this judgment?
You are a resident of same village.
Yes.
No, no, any.
We have produced in
but he is
annexure
not-
R1, annexure R series, my lord. R1, we have produced along with our statement of objections that he is a resident of Kanitahalli. My lord, in this judgment, may I point out from this one, my lord, judgment. My lord, para 12 to 15 may kindly be noticed.
Yes.
Bottom of the page, para 12.
ಅದು ಯಾವ್ದೋ ಒಂದು ಇದ್ರದ್ದು ವಜಾ ಮಾಡಿದ್ವಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ಮೊನ್ನೆ. ಮುರಾರ್ಜಿ ದೇಸಾಯಿ ಸ್ಕೂಲ್ ಯಾವ್ದೋ ಒಂದು.
ಅಲ್ಲ ಇದರಲ್ಲಿ
yes, referring this, yes.
Article 311 provides that a member of a civil service of the union or the state shall not be dismissed or removed by any authority subordinate to that by which he was appointed, that the employee shall not be dismissed or removed or reduced in rank except after an inquiry
Para
in
15. Which paragraph?
Para 12, man, bottom of the page. Para, at page 113. Man.
Yes, yes.
Your Lordship. Article 311 provides that a member of a civil service of the union or a state shall not be dismissed or removed by any authority subordinate to that by which he was appointed, that the employee shall not be dismissed or removed or reduced in rank except after an inquiry in which he has been informed of the charges against him and has been given a reasonable opportunity of being heard in respect of those charges, in exercise of the power conferred by subsection 1 of section 3 of All India Services Act 1951, the central government in consultation with the governments of states concerned framed All India Services discipline and appeal rules. These rules lay down the detailed procedure as to the manner in which the action is required to be taken against the delinquent public servant. Relying upon Article 311, the provisions of the rules, it was contended by Shri So-and-so, learned senior counsel for the appellant, that the service of the appellant could not be terminated without following the procedure laid down therein. Lord, thereafter, Lordship may come to Lord, para 14. Man.
Yes.
Bottom of the page. Rule 6 of the rules provide, this can also be skipped, my lord. Your Lordship may directly come to para 15.
Yes.
This apart, the appellant obtained the appointment in service on the basis that he belonged to scheduled caste community. When it was found that by the scrutiny committee that he did not belong to the scheduled caste community, then the very basis of his appointment was taken away. His appointment was no appointment in the eye of the law. He cannot claim a right to the post as he had usurped the post meant for a reserved candidate by playing a fraud and producing a false caste certificate. Unless the appellant can lay a claim to the post on the basis of his appointment, he cannot claim the constitutional guarantee given under Article 311 of the Constitution. As he had obtained the appointment on the basis of a false caste certificate, he cannot be considered to be a person who holds a post within the meaning of Article 311 of the Constitution of India. Finding recorded by the scrutiny committee that the appellant got the appointment on the basis of a false caste certificate has become final. The position therefore is that the appellant has usurped the post which should not have gone to a member of the scheduled caste. In view of the finding recorded by the scrutiny committee and upheld by this court, he has disqualified himself to hold the post. The appointment was void from its inception. It cannot be said that the said void appointment would enable the appellant to claim that he was holding a civil post within the meaning of Article 311 of the Constitution of India. But thereafter, in para 19, my lord, the court says it can the punishment cannot be even reduced to that of compulsory retirement, even so that they can get pensionary benefit. Para 19. It was then contended by Shri So-and-so, senior counsel for the appellant, that since the appellant has rendered about 27 years of service, the order of dismissal be substituted by an order of compulsory retirement or removal from service to protect the pensionary benefits of the appellant. We do not find any substance in this submission as well. The rights to salary, pension and other service benefits are entirely statutory in nature in public service. The appellant obtained the appointment against a post meant for a reserved candidate by producing a false caste certificate and by playing a fraud. His appointment to the post was void and honest in the eye of the law. The right to salary or pension after retirement flows from a valid and legal appointment. The consequential right of pension and monetary benefits can be given only if the appointment was valid and legal. Such benefits cannot be given in a case where the appointment was found to have been obtained fraudulently and resulted on a false caste certificate.
Yes.
But even when there is no involvement of the candidate in the wrongdoing, I mean, even if it cannot be proved, my lord, this honorable court has held that the beneficiary of an illegal appointment cannot be continued. Division bench of this honorable court
Yes. No, last occasion I said even you will also lose that opportunity. Why?
No, because
In
my
this
lord,
case-
I was validly appointed in place of the petitioner. Now, my lord, because the dishonorable court held on the earlier occasion that termination is illegal because there was no inquiry, my lord, I was directed to be, my name was directed to be deleted, and my lord, he was directed to be continued. So now, my lord, on account of the subsequent dismissal, my lord, I am entitled to continue.
No, what is that? You have filed a writ petition for what?
Because, my lord, I have filed a writ petition only for a direction restraining the respondents, my lord, from discontinuing me from the
Yes.
services. So there is an interim order.
No, now once your appointment is quashed, then they have to do it reappointment.
No, because they have already appointed me, my lord.
No, your appointment is quashed by this court.
No, my lord, my appointment was, please see, my lord, the earlier order,
Yes.
my lord, that is produced. My lord, at page 65.
Yes. Yes.
At page 68, paragraph 6.
Yes.
In my view, since the third respondent was appointed in the place of the petitioner on the ground that the petitioner was unauthorizedly absent, and the petitioner was not even notified or cause was sought for his alleged unauthorized absence, the third respondent could not have been appointed. It is therefore necessary to quash Annexure E and direct the Tahsildar to reconsider the matter after hearing the petitioner, and until then, the petitioner shall be reinstated, however, without any monetary benefit, so on and so forth. But this honorable court said, since his termination was illegal because there was no opportunity, my lord, since I was appointed to his place, my lord, I cannot continue.
No, it is appointment is quashed.
Lord, that is because
No,
my
whatever
appointment,
by the reason, I cannot say that with this order which is quashed, we are not quashing that order. That will go that. Then they have to reconsider your appointment. Your
Lord,
appointment, you have not challenged that. Or
That-
you, that there is no clarification that.
no, I
If-
have, of course, my lord, as a matter of fact, I filed a writ appeal, but writ appeal came to be dismissed.
Then,
Now, my lord, my submission is, since I was appointed to his place, that is the place of the petitioner, and now, my lord, having regard to the fact that there is a categorical
no,
finding.
now that your appointment is quashed, he has been reinstated, then there is no post, vacant post. Now he has been dismissed on some other ground. Now that vacancies arises, now they have to be reappointed in accordance with the rules. That is what that now, your appointment is also gone that.
Lord, my submission is, Lord, please have a look at my appointment, my lord. Of course, it is a
No, that is
common
whatever
order.
may be the things, but annexure E is quashed. Now I cannot direct them to give an appointment. It is against that quashing of that order. Their only option is that now his case is dismissed. Now the post is vacant now. Now they have to be called for an application in accordance with law. Yes.
Earlier occasion, my lord, he has challenged my appointment. The second respondent has clarified that he is not belongs to the community of the Barbar. Thereby, is
No, that now everything will be kept open. Now they will call for an application and
my lord,
who are eligible, they will be appointed.
sorry, my lord, one copy is there. With respect of my lord, my learner friend asking that he is not a resident of the family. In this judgment, my lord, the claim of the respondent was appointed on the ground that the petitioner is not a resident of that particular village. The fourth respondent is not belongs to that community. The Sahayak court has set aside the appointment of fourth respondent. The post is meant for the particular community, my lord. That's
ಅಷ್ಟೇ ಮಾಡೋದು ಈಗ ಹೊಸದಾಗಿ ಇದ್ರ ಪ್ರಕಾರ ದೇ ಹ್ಯಾವ್ ಟು ಬಿ ಕಾಲ್ ಫಾರ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್ ಆಸ್ ಪರ್ ದಟ್ ಸರ್ಕ್ಯುಲರ್ ವಿಚ್ ಇಸ್ produced by that, they have to call for an application from that candidate of that communities, which are the communities entitled, who are resident of that village or the circle.
ಇದರಲ್ಲಿ ಕಮ್ಯುನಿಟಿ ಅಂತ ರೆಸಿಡೆಂಟ್ ಅಂತ ಹೇಳಿಲ್ಲ ಸರ್.
Yearly. ಏನಂತ ಹೇಳಿದ್ದಾರೆ?
Last, I have only one.
You have to petition disposed of.
First, last,
appointment of the respondent was not
fourth
required
para
in the
in the-
notification enforcement. Otherwise eligible to be appointed a gram sevaka and said post is still available. Petition shall be considered for appointment at the post of gram sevaka in accordance with.
Fourth,
ಅಷ್ಟೇ ಹೇಳಿರೋದು.
ಅಲ್ಲ fourth para in the finding.
ಇಲ್ಲಿ ಯಾಕೆ ಏನನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ?
In this case, my lord, The petitioner is challenging the appointment of the fourth respondent, who is not a belongs to the community. The fourth respondent has taken the contention. The petitioner is not belongs to the village circle there. The dishonorable court has said that the first priority has given to the particular family. At the fourth page in the this one.
The respondent is invited applicant fill up that Gram Sevaka consequent to which petitioner was the member of the family Bharat were applied in order to select the suitable kind of host. Respondent not passed directions sought by the respondent to fix the date of interview. What petitioner was found to be belongs to the family of the brother. However, the name of the respondent is also appeared in the appointment order was been issued in view of the letter address. Letter former so. Following this, respondent issued an order appointing the respondent Gram Sevaka was working in a Gram Sevaka since honorable basis. The petitioner therefore this court challenging the appointment order. Really, the fourth rule in fact really the rest. This is how that nobody is bringing the two sets copies. This is how we are practicing in High Court, Mr.
The learner council of petition submitted the Gram Sahayak was temporary post created to providing the assistance of the.
Para 4 you are reading.
Please.
Up to para 4 it's in a contention of the parties. Yes.
Contended that the respondent for did not belongs to the family of the Barabar and therefore he was entitled for the appointment of the Gram Sahayaka. Sorry, he submitted that it is only the family members of the Barabar who are to be appointed on the ad hoc basis and not the respondent number 4. He contended that the respondent number 4 did not belongs to the family of the Barabar and therefore he was not entitled for the appointment as a Gram Sahayak. The per contra learner council for the respondent submitted that petitioner is not resident of the Kaparahalli and the post of the Gram Sahayaka was at Kaparahalli. Therefore, he submitted that petitioner has no locus standi to question the order of the appointment of the fourth respondent number 4. He further contended the respondent number 4 was working as a Gram Sahayaka at Kaparahalli for more than 4 years without any salary and that in recognition of the service, the respondent number 4 was appointed. He also submitted that the appointment was only for a period of 5 years and the same has not been extended from time to time. He contended that the petitioner and respondent number 4 are now on the verge of reaching the age of please. That the same issue is there. Learner council for the advocate supported the contention of the respondent number 4. The contender the respondent number 4 had more experience than the petitioner and therefore better qualified to be appointed the Gram Sahayaka. I have heard the learner council for the petitioner and additional government advocate and the learner council the appraisal notification dated 16/9/78 issued by the respondent number 4 that Tahsildar was required to be appointed a Gram Sahayaka on temporary basis for a period of next 5 years. The person who are traditionally discharging the duties of inferior village officer who were 25 years and above, not older than that 65 years age. Therefore, the post of the Gram Sahayaka had to be filled up on temporary from the among the family members of the Barbardar of the inferior village officers. It was not the case of the respondent member that he or his family members for the Barbardar and therefore was not intended to be appointed of the for the post of Gram Sahayaka. It is not the case for that there was an inferior village officer of Talwar or any other inferior village of that Kuparali and contrary to the father of the petitioner was rendering service of the Talwar at Jedikunte.
Barwad family antandre includes all this.
Please.
ಮತ್ತೆ ಅಲ್ಲಿ ಬರ್ವಾಡ್ದರಿಗೆ ಕೊಡಿ ಅಂತಲ್ಲ ಬರ್ವಾಡ್ ಅಂತ ಅಂದ್ರೆ ಸಿ ಬರ್ವಾಡ್ ಫ್ಯಾಮಿಲಿ ಆಫ್ ದ ಇನ್ಫೀರಿಯರ್ ವಿಲೇಜಸ್ ಲೈಕ್ ತೋಟಿ
ಪ್ಲೀಸ್
ಬರ್ವಾಡ್ ಅಂತ ಇವ್ರು ಎಲ್ಲದರಲ್ಲೂ ಕೊಡಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು
that is my lord. As rightly content that learner council for the respondent and the post of Gram Sahayaka did not filled up by the period of 4 years. If the respondent number 4 is continued the post and he has aged about more than 65 years age, the opportunity shall be granted to the petitioner to be appointed as Gram Sahayaka. You may madam, he is not belongs to that community that has been heard in the malad page number 47 annexure K is that malad.
It is not belongs to which community?
Please malad, it is heard that malad page number 47 annexure K. Earlier malad rejection of his appointment.
ಅವ್ರು ಇಲ್ಲ ಅಂದ್ರೆ ಅವ್ರು ಬರಲ್ಲ ಬಿಡಿ ನಾವೇನ್ ಅವ್ರಿಗೆ ಕೊಡಿ ಅಂತ ಹೇಳ್ತಾರೆ.
Please malad.
We are saying that they have to call for an application. Who are eligible, they will give you and you can also apply. They will consider that. Yes. Tell
Malad, just one document, annexure R3 at page 11. That document is the Vasasthala Drudikarana Patra.
No, that he is also not disputing that.
Malad, subsequently, but it has given the residence certificate has been granted. As
R3?
per Malad, as per Malad, in memorial act.
Page 11.
No, he is also not disputing that he is
is not belongs to that
Mandikal.
Mandikal. He's saying that after appointment, still he is working in that Mandikal, he is residing now. Now he is getting that documents to be converted, transferred to that
Not
Mandikal.
transfer, my lord. Before my appointment also I'm working, staying there. Thereby
Documents illala.
ಇದೆ ಸ್ವಾಮಿ annexure A16. I was
ನೀವೇ ಹೇಳಿದಿರಲ್ಲ ಮಂಡಿಕಲ್ ಅಲ್ಲಿ ಇರ್ಲಿಲ್ಲ ನಾನು ಈ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಂತ.
my lord, residence, saying that resident but that village, my lord, annex.
That is what that resident in what.
Please, my lord. As on the date of my appointment, my lord. Madam, page number 77 and 78, my lord. 77, my lord, my caste and income certificate.
ಆಯ್ತು ಅದಲ್ಲ ರೆಸಿಡೆನ್ಷಿಯಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಬೇಕು.
Please, ಅದು ಎರಡು ಇದೆ ಸ್ವಾಮಿ.
ಎಲ್ಲಿದೆ?
Page number 77, annexure K.
77. ಏನಿದು?
Lord, KV Ramesh Kumar bin Venkatappa Sanskripilayama Sons ಅವರು ಮಂಡಿಕಲ್ಲು. That is date, my lord, 18/4/2016.
ಯಾವಾಗ ನೀವು ಅಪಾಯಿಂಟ್ ಆಗಿದೆ?
My lord, I appointed on 15/2/2017.
ಏನಿದೆ ಇದ್ರಲ್ಲಿ?
ಮಂಡಿಕಲ್ಲೇ ಇರುವಂತದ್ದು ಸ್ವಾಮಿ.
ಎಲ್ಲಿದೆ?
My lord, first KV Ramesh Kumar bin Sri ವೆಂಕಟೇಶಪ್ಪ ತಂದೆ ಸೋನ್ಸು ಇವರು ಮಂಡಿಕಲ್ಲು ಚಿಕ್ಕಬಳ್ಳಾಪುರ ವಿಳಾಸ ಮಂಡಿಕಲ್ಲು ಗ್ರಾಮದಲ್ಲಿ ಮಂಡಿಕಲ್ಲು ಹೋಬಳಿ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ತಾಲೂಕು ಜಿಲ್ಲೆಯಲ್ಲಿ ವಾಸವಾಗಿರುತ್ತಾರೆ. As on the date of appointment.
ಚಿಕ್ಕಮಗಳೂರಲ್ಲಿ ವಾಸವಾಗಿದ್ದ ಅವರು ಅನುಸೂಚಿತ ಜಾತಿ ಬುಡಕಟ್ಟಿಗೆ ಅಂತ. No, this is a caste certificate.
Caste and residence, residence also says that ವಾಸವಾಗಿರುತ್ತಾರೆ.
ಇದೆ ರೆಸಿಡೆನ್ಷಿಯಲ್ ಸರ್ಟಿಫಿಕೇಟ್.
Next, my lord, annexure 78, my lord.
ಎಲ್ಲೈತೆ?
ಆದಾಯ ಮತ್ತು ದೃಢೀಕರಣ ಪ್ರಮಾಣ ಪತ್ರ. Next, annexure 79, page number Z, ವಾಸ ದೃಢೀಕರಣ ಪತ್ರ, my lord.
ಏನಿದೆ ವಾಸ ದೃಢೀಕರಣ ಪತ್ರ?
KV Ramesh Kumar bin ವೆಂಕಟೇಶ ತಂದೆ ಸೋನ್ಸ್ ಅವರು ಮಂಡಿಕಲ್ಲು ಗ್ರಾಮದಲ್ಲಿ ಸೋನ್ಸದಲ್ಲಿ ವಾಸವಾಗಿರುತ್ತಾರೆ. That is dated, my lord, 11/4/2016. Before my appointment, I was residing that circle.
You said that you are residing in that ಎಂತದ ಕುನಿ
Kanitahalli.
At the time before appointment, my lord, at the time of appointment I was the resident of the Mandikal.
Yes, Mr. It is he has produced the documents to show that he is in the annexure Z. ಇಷ್ಟೊತ್ತನಕ ಅವ್ರು ಏನೋ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬಿಟ್ಟು ಈಗ ನಾವು ಈ saying that.
ಅಲ್ಲ, the date of appointment is that, my lord, most important.
Lord, there is a reference to all these documents. Please have a look at page 85.
Yes.
Page 85. ಅದರಂತೆ ದಿನಾಂಕ 6/11/23 ಶ್ರೀ KV ರಮೇಶ್ ಕುಮಾರ್ ಅವರು ವಿಚಾರಣೆಗೆ ಹಾಜರಾಗಿ ಲಿಖಿತ ನಿವೇದನೆ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ ಹಾಗೂ ಸದರಿ ನಿವೇದನೆಗಳೊಂದಿಗೆ ಈ ಕೆಳಕಂಡ ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸಿರುತ್ತಾರೆ. Lord, these are the documents. Then, my lord, the next, ಈ ಕಚೇರಿ ಅಧಿಕೃತ ಜ್ಞಾಪನ ಪತ್ರ ದಿನಾಂಕ 15/2/2017 ಅನ್ವಯ ಮಂಡಿಕಲ್ಲು ಕಂದಾಯ ವೃತ್ತದ ಗ್ರಾಮ ಸಹಾಯಕ ಹುದ್ದೆಯಲ್ಲಿ ಮುಂದುವರೆಯಲು ಶ್ರೀ KV ರಮೇಶ್ ಕುಮಾರ್ ಬಿನ್ ಎಂ ವೆಂಕಟೇಶಪ್ಪನವರು ಅರ್ಹರೇ. Now, Lord, please see the last paragraph. ಶ್ರೀ KV ರಮೇಶ್ ಕುಮಾರ್ ಅವರು ಸಲ್ಲಿಸಿರುವ ಜಾತಿ ಮತ್ತು ಆದಾಯ ಪ್ರಮಾಣ ಪತ್ರ, ವಾಸಸ್ಥಳ ಪ್ರಮಾಣ ಪತ್ರಗಳು 2016ನೇ ಸಾಲಿಗೆ ಸಂಬಂಧಪಟ್ಟದ್ದಾಗಿರುತ್ತದೆ. ರಮೇಶ್ ಕುಮಾರ್ ಅವರು ವಾಸವರ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಿದಾಗ ದಿನಾಂಕ 16/8/2019 ನಂದಿ ಹೋಬಳಿ ಉಪ ತಹಶೀಲ್ದಾರ್ ಕಚೇರಿಯಿಂದ RD ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ರಂತೆ ಜಾತಿ ಮತ್ತು ಆದಾಯ ಪ್ರಮಾಣ ಪತ್ರ ಹಾಗೂ ವಾಸಸ್ಥಳ ಪ್ರಮಾಣ ಪತ್ರಗಳನ್ನು ನಂದಿ ಹೋಬಳಿ ಕಣಿತಹಳ್ಳಿ ಗ್ರಾಮದಲ್ಲಿ ವಾಸವಿರುವುದಾಗಿ ಪಡೆದಿರುತ್ತಾರೆ. ಆದ ಕಾರಣ ಶ್ರೀ KV ರಮೇಶ್ ಕುಮಾರ್ ಅವರು ಮಂಡಿಕಲ್ಲು ಗ್ರಾಮದಲ್ಲಿ ವಾಸವಿಲ್ಲ ಎಂಬುದು ಸ್ಪಷ್ಟವಾಗಿ ಕಂಡು ಬರುತ್ತದೆ.
2019 ಅಲ್ಲಿ you have taken that
That is what is that annexure. That is what is that annexure R3.
Why you have taken that?
That has been declared as invalid, my lord. That has been invalid.
Who has invalid?
Okay.
No, why you have taken that residential certificate when you are appointed here?
My lord, in the 2016, I was from the 2010 onwards, I am residing in Mandikal village. Subsequently, I applied for I obtained all the testimonials, my lord. Those certificate also has been invalid, my lord. Even otherwise, my lord.
See, why you have applied for another certificate to that?
That has been renewed, my lord.
No, why you have obtained, Mr. You are here. You are not getting any instruction and making submission, Mr. What is this, Mr. Civil court ಅಲ್ಲಿ ಕರ್ಕ ಬಂದು ನಿಲ್ಸ್ಕೊಂಡು ಕೇಳಿ ಆರ್ಗ್ಯೂ ಮಾಡ್ದಂಗ್ ಮಾಡ್ತಿರಲ್ಲ. Yes. Yes, what is that? Why you have obtained this later?
Sorry, my lord.
Why you have obtained that certificate after that your appointment?
My lord, that has been cancelled, my lord.
2019 ಅಲ್ಲಿ ಯಾಕ್ರಿ ಅಲ್ಲಿ ಅಲ್ಲಿ ಏನ್ ಇನ್ನೊಂದು ಕೆಲಸಕ್ಕೆ ಹಾಕಿದ್ರಾ?
ಇಲ್ಲ, my lord.
But why you have taken that when you are?
My lord, 2019, my lord, I was terminated. My lord, as per the order of my lord.
ನೋಟಿಸ್ ಅಂತ ಬರುತ್ತೆ ಅದು ನಾನು ತಗೊಂಡಿಲ್ಲ.
Yes, Mr. How your officer has issued this?
ಆಧಾರ್ ಕಾರ್ಡ್ ಲಿಂಕ್
When there is already an existing that he is resident of that.
ನಾನು ತಗೊಂಡಿಲ್ಲ.
ಎಷ್ಟು ಬೇಕಾದ್ರೆ ಕೊಡ್ತಾರಾ? ವೋಟರ್ ಲಿಸ್ಟ್ ಎಷ್ಟು ಬೇಕಾದ್ರೆ ಆಯ್ತು, ಆಧಾರ್ ಕಾರ್ಡ್ ಎಷ್ಟು ಬೇಕಾದ್ರೆ ಆಯ್ತು, ಇದು ಎಷ್ಟು ಬೇಕಾದ್ರೆ ರೆಸಿಡೆನ್ಸಿಯಲ್ ಸರ್ಟಿಫಿಕೇಟ್, ಕ್ಯಾಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್. Then how he can be issued that he is not a resident? There is a procedure how to issue. How is this Tahsildar has issued this 2019 when he is there?
I will clarify that. I will get instruction on date may be given for that matter.
Then how he has issued, Mr. You also get that how? Yes, how he is insert, then why you have applied when there is already a resident certificate?
I will clarify that, please.
As on that day, when appointed, he has produced that certificate unless it is cancelled. He is a resident of that. Yes. From the beginning, you are arguing that no, I am resident of such. After that appointment, what is this? Horrible. Yes.
ಎಲ್ಲಿ ನಾಳೆ ಎಲ್ಲ ಏನ್ ಬರಲ್ಲ.
Appadi our government. Please this matter of 2 weeks.
Date may be given.
Yes. On 8th September. Yes. Yes. Appadi. Yes. We have, when there is a direction, interim order grant. 1/8/2020. Yes. Yes. This court on 1/8/2025 has directed the government to secure original records. Government advocate has submitted that in spite of his communication, he has not received the original records from that. Who has to submit? Second respondent.
Tahsildar.
Second respondent, Tahsildar, is directed to appear before the court next date of hearing, and he has also has been asked to give an explanation.
8/9.
When the petitioner is already obtained residential certificate 11/4/2016 to show that he is a resident of Mandikal. When that certificate is existing, the Tahsildar has issued one more certificate 16/8/2019 to show that petitioner is the resident of Kanitahalli. To that effect, Tahsildar is also directed to file an affidavit with explanation. Please this matter and so on. Yes.
Cell number 36 adjourned. Cell number 37 Vinay D. Wasmat for petitioner. Vamshi Krishna C.
Yes.
Please, Malad.
Yes.
Appear for the petitioner in this matter.
Yes.
My lords, I appear for the respond number 1, my lords. I seek for a
Yes.
short adjournment, my lords.
Leave it to your lordship. Writ
Yes,
of
what is
mandamus.
this?
It is
What
a
is
writ
that?
of mandamus seeking direction against respondent number 1 and 2.
What
to
direction?
To consider the application of petitioner wide annexure D.
What is that?
My lord, it is a application to exit from the national pension scheme system. Petitioner's son was working with respondent number 1 hospital and he was enrolled in NPS scheme with respondent number 2. He died while in service in the year 2022. He was diagnosed with jaundice and ultimately succumbed to the fever. 2022 nalli she is given she is a nominee. The petitioner herein is the mother who is a nominee. She gave a representation to respondent number 1 for release of all the death benefits and all those things. Respondent number 1 wrote a letter communication to respondent number 2. ಅಲ್ಲಿ ತೊಂದರೆ ಏನಾಗಿದೆ ಅಂದ್ರೆ ನಾಮಿನಿನಲ್ಲಿ ಮದರ್ ಹೆಸರಿದೆ ಬಟ್ ಬೇರೆ ಆನ್ಯುಟಿ ಡೀಟೇಲ್ಸ್ ಇದಲ್ಲೆಲ್ಲ ವೈಫ್ ಹೆಸರು ಬಂದಿದೆ. ಸೊ ದೇ ಕ್ಲಾರಿಫೈಡ್ ಅಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1 ದೇ ಸೆಡ್ ಅವ್ರ ವೈಫ್ ಕಡೆಯಿಂದನೂ ಒಂದು ಡಿಕ್ಲರೇಷನ್ ಅಥವಾ ಒಂದು ಅಫಿಡವಿಟ್ ಹಾಕ್ಸಿತಾರ ಅಂತ. ದಟ್ ಈಸ್ ಆಲ್ಸೋ ಬೀನ್ ಡನ್. The wife, she is given a representation with an affidavit to both respondents 1 and 2 stating that she will not claim any benefits.
No, your representation is to exit from that national pensional scheme.
Please.
What is that?
That is my son's this thing, my lord. ಅವನು ತೀರ್ಕೊಂಡಾದ್ಮೇಲೆ ಅದರಿಂದ ಎಕ್ಸಿಟ್ ಆಗಿ ನನಗೆಲ್ಲ ಬೆನಿಫಿಟ್ಸ್ ಬರಲಿ ಅಂತ. Since she is a nominee.
Yes, mister, you consider that representation.
My lords,
2022.
My lords, we are not the answering respondents, my lords, because our limited role is, my lords, we act as an intermediary. We take the documents and then we in turn process it to the respondent number 2. So
Who
from
has
our
to
side,
answer,
my lords,
who is appearing for R2?
It is, they are served and unrepresented. Your Lordship may kindly see annexure H ಆದ್ಮೇಲಿಂದ
ನೀವು ಯಾರಿಗೆ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಇಬ್ರಿಗೂ ಕೊಟ್ಟಿದ್ದೀನಿ. ರೆಸ್ಪಾಂಡೆಂಟ್ 1ಗೂ ಕೊಟ್ಟಿದ್ದೀನಿ, ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2ಗೂ ಕೊಟ್ಟಿದ್ದೀನಿ.
Now, who has to answer?
respond number 2, my lords, because all the duties, whatever the respond number 1 had to adhere to, and all of their obligations, whatever representations we have received from the petitioner, we have in turn forwarded that to the respondent number 2, my lords.
E-Government Technology Limited. Is it government undertaking?
Respondent one number 1 autonomous government undertaking ಬರುತ್ತೆ. Respondent number 2 I have no idea, my lords.
No, Jaydeva Institute of Technology. Who
ಅದು
is that?
autonomous
It's aided,
government.
my lords. It's aided,
Aided
funded by the government, my lords.
No. What about respondent number 2? Who is that respondent number 2?
I don't think they have entered appearance, my lords.
Huh?
They haven't entered appearance, my lords.
No,
Respondent
that
number
is true, mister. What is that National Security Depository
Depository
Limited?
Limited, my lords.
Is it a private company?
No, it's government, my lords.
No, what they are doing that in Jaydeva Institute of Cardiology? How it is related?
My lords, because we run a hospital, my lords, and the petitioner's son was working with the hospital for a certain duration. So, with respect to the pension system, my lords, whatever has to be deducted from the employer's side, so that is in turn processed with the respondent number 2 entity, my lords. So the claim here, my lords, even the respondent number 3 has given her no objection for the petitioner to withdraw all the benefits that
What is that
has been
respondent
accrued in
number
the name
2?
of the son.
Lords, according to my this thing, I feel that since respondent number 1 is the person who has to pay me salary,
No.
ನನಗೆ ಏನ್ pension ಬರಬೇಕು, ಏನ್
What
gratuity.
is your post?
I was working, the deceased person was working as an assistant lab technologist.
In that
Respondent 1.
respondent number 1. Who is that respondent number 2?
Respondent number 2, respondent 1 and 2 they are tied up. Respondent number 1 hospital ಯಾರ್ಯಾರು ಕೆಲಸ ಮಾಡ್ತಾರೆ ಅವ್ರದ್ದು pensions gratuity ಎಲ್ಲ respondent number 2 ಕೈಗೆ ಹೋಗುತ್ತೆ. ಕಟ್ ಮಾಡಿ salary ಕೊಡ್ತಾರೆ. So those things will be deposited before respondent number 2.
National Securities Depositors Limited. No, see, that means if that respondent number 1 approved, 2 will sanction.
Obviously.
Yes, mister.
My lords, it is the other way, my lords, because our limited role is, my lords, as soon as, because here if you look at it, my lords, the petitioner's son himself has voluntarily opted for a particular scheme with the respondent number 2, my lords. So it is not some tie-up with his, which came, the scheme was not.
Nobody is
added as a
answering that.
document.
What is the second respondent? Yes, at the request of counsel for the petitioner. Respondent number 1, leave this matter on 11th. Yes.
Please.
Right, my lords.
Madhu CS for petitioner, Krishnamurthy D.
I seek pardon of your lordship that I am
Yes.
unable to attend physically, my lords.
Yes, Mr.
My lords,
Yes.
in the last date of hearing, your lordships have directed the government authority to consider my case for admitting granting aid, my lords. And in fact, the learned government council has accepted the reality and admitted that there is no fault of the petitioners, my lord.
Yes, just give that brief facts, Mr. Madhu.
My lords, I was appointed as lecturer in history in third respondent institution in the year 2004, my lords.
Yes.
Thereafter, my appointment was approved without granting aid, my lords, in the year 2006.
Yes.
In spite of several requests and the directions by the Department of Pre-University Education, my proposal for admitting into granting aid was not sent by the management, my lords. Consistently in the year since 2015 till date, several directions were issued by the competent authorities, my lords, including the deputy director, and principal secretary, my lords.
Where is that order? Directions issued by that authority. Which is that annexure? Which is that annexure, Mister?
Annexure M, Millard.
Annexure?
M.
Page number?
Page number 63, Millard.
Yes. No, this is under appeal. AG takes note, petitioner contend that he has filed a petition number so and so, and the same is yet to be disposed of, therefore seek direction.
In 68 minute, page number 68, the operative portion is there. Right. In
You read Adesha 67. 67 Adesha. ಮೊದಲನೇ
ಮೊದಲನೇ ಮತ್ತು ಎರಡನೇ ಪ್ರತಿವಾದಿಗಳು ಈ ಆದೇಶ ತಲುಪಿದ 15 ದಿನಗಳೊಳಗಾಗಿ ಅರ್ಜಿದಾರರನ್ನು ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸುವ ಸಂಬಂಧ ಪ್ರಸ್ತಾವನೆ ಅಥವಾ ಅರ್ಜಿದಾರರ ಬೆತ್ತನಿ ಸಂಯುಕ್ತ ಪದವಿ ಪೂರ್ವ ಮಹಾವಿಶ್ವವಿದ್ಯಾಲಯ and so and so places ಇಲ್ಲಿ ಅನುದಾನಿತ ಇತಿಹಾಸ
management is not sent, then ಉಪನಿರ್ದೇಶಕರು has to be send a proposal. Yes, I remember that. What? Yes, Mr.
Closed.
No purpose in, my lord, he cannot be admitted to grant in aid at this stage. The institution has failed to submit the representation in a timely manner. Therefore, although there were.
You see that page 67.
No, I understand, my lord. There was a direction to the government also. My lord, that order has been issued without, my lord, having regard to the fact. As per the rules, my lord, if the college is it does not have the sufficient student strength, my lord, no post can be admitted to grant in aid. Now the college was on the verge of being closed down, and now recognition has been taken away. Now the college, it is now on the verge of closing down, my lord. And apart from that, my lord, because of the management's this one, the petitioner has not worked from 2009, my lord. Now to admit him from, now the problem is to transfer him to, my lord, I just want to pass on 2 documents. To admit him to grant in aid, now they do not have the sufficient student strength and they are on the verge of closing down. That apart, my lord.
No, 2024 this direction, Mr.
My lord, on that, by that time, the college was on the verge of closing down. By when the order of the principal secretary was passed, my lord, in the review.
ಆಯ್ತು, ನೀವು ಅದನ್ನೇನು recalling application
ಅಲ್ಲ, ಅದಕ್ಕೆ ಒಂದು now we have asked the revision of that to reconsider that order. Nothing has happened so far, my lord.
That you have to be
Now
told, Mr.
there is a difficult situation. I'm just expressing the difficult situation. May I just point this out, my lord? In 2014, the DDPI, the concerned DDPI reports, my lord. Your lords may kindly turn to the second page. ಈ ಮೇಲಿನ ಎಲ್ಲ ಹೇಳಿಕೆ ಹಾಗೂ ಈ ಕಚೇರಿಯ ದಾಖಲೆಗಳಿಂದ ತಿಳಿದು ಬರುವ ಅಂಶವೇನೆಂದರೆ, ಶ್ರೀ ಚಂದ್ರಶೇಖರ್ ಎಂ ಇವರನ್ನು 1/10/2005 ನಿರ್ದೇಶಕರ ಪತ್ರದನ್ವಯ ಬಿಡುಗಡೆ ಮಾಡಲಾಗಿದೆ. ನಂತರ ದಿನಗಳಲ್ಲಿ ಚಂದ್ರಶೇಖರಯ್ಯನವರನ್ನು ಅತಿಥಿ ಉಪನ್ಯಾಸಕರನ್ನಾಗಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದು 14/3/2009 ಅತಿಥಿ ಉಪನ್ಯಾಸಕರ ಕರ್ತವ್ಯದಿಂದ ಬಿಡುಗಡೆ ಮಾಡಿರುತ್ತಾರೆ. ವಿಚಾರಣೆ ಸಂದರ್ಭದಲ್ಲಿ ಆಡಳಿತ ಮಂಡಳಿಯಾಗಲಿ ಅಥವಾ ಪ್ರಾಚಾರ್ಯರಾಗಲಿ ವೇತನ ನೀಡಿದ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆಯನ್ನು ನೀಡಿರುವುದಿಲ್ಲ. So he has been appointed in 2004. Then in 2005 he has been relieved. Then he has been continued as guest lecturer till 2009. And thereafter he has not at all worked.
But your principal secretary has directed as an appellate authority.
We have sought this one, my lord, because as per the rules, principal secretary has given a direction. But as per the rules, the college is was already having shortage of students and was on the verge of
that should have been brought to his notice. ಪತ್ರವನ್ನು ಉಪನಿರ್ದೇಶಕ ಸಲ್ಲಿಸಿದಾಗ ಒಂದು ವೇಳೆ ಆಡಳಿತ ಮಂಡಳಿಯು ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಿದ್ದಲ್ಲಿ ಉಪನಿರ್ದೇಶಕ ಬಗ್ಗೆ ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸುವ ಪ್ರಸ್ತಾವನೆ ಸಿದ್ಧಪಡಿಸಿ ನಿರ್ಧರಿಸಿಕೆ ಸಲ್ಲಿಸತಕ್ಕದ್ದು. ಪ್ರಸ್ತಾವನೆ ಕಳಿಸಿ ಅವ್ರು ರಿಜೆಕ್ಟ್ ಮಾಡ್ಲಿ, because on this reason.
And from our side, my lords, we have issued NOC also. For us, direction is that we have to issue NOC. I represent the institution, my lords. We have given the NOC to the Disciplinary.
ಅವರು ಪರಿಶಿಷ್ಟ ಪಂಗಡಕ್ಕೆ ಮೀಸಲಾತಿಯಾದ ಹುದ್ದೆ ಆಗಿರೋದ್ರಿಂದ ಮತ್ತು ಅತಿ ಮುಖ್ಯವಾಗಿ ಬ್ಯಾಕ್ಲಾಗ್ ಹುದ್ದೆ ಆಗಿರೋದ್ರಿಂದ ವಿಳಂಬಕ್ಕೆ ಆಸ್ಪದ ನೀಡದೆ ಹಾಗಾಗಿ ಇಷ್ಟವಾಗಿ ಅನುದಾನಕ್ಕೆ ಕ್ರಮ ಕೈಗೊಳ್ಳತಕ್ಕದ್ದು. ಪ್ರಕಾರ ಕನಿಷ್ಠ ಮೂಲ ವೇತನ ಪಾವತಿಸಲು ಆಡಳಿತ ಮಂಡಳಿ ಬಾಧ್ಯವಾಗಿದ್ದು ಪರಿಶೀಲಿಸಿ ಅರ್ಜಿ ಆದೇಶ ದಿನಾಂಕದಿಂದ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸುವವರೆಗೆ ಅರ್ಜಿದಾರರಿಗೆ ಕನಿಷ್ಠ ವೇತನದ 3 ತಿಂಗಳ ಒಳಗಾಗಿ ನೀಡಲು ನಿರ್ಧರಿಸಲಾಗಿದೆ. Yes, you have to pay that minimum wages. Are you paying that? Till they have to be confirmed.
The institution is closed right now, my lords. And even grant in aid has been taken off. Initially, my lords, I appointed the petitioner, my lords. Subsequently, the government does not grant, my lords, because the post is reserved for candidates of SC, my lords, scheduled caste. Because of that reason, my lords, they did not consider the grant in it. Because of that difficulty, I could not do anything, my lords. The proposal is not given by the government. If the proposal is not,
ultimately, this is for implementation of that order passed under 133.
Please.
Where there are two things. One is that there is a direction to that deputy director to submit a proposal. ಸಲ್ಲಿಸದಿದ್ದಲ್ಲಿ ಉಪನಿರ್ದೇಶಕ ಈ ಬಗ್ಗೆ ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸಿ ಪ್ರಸ್ತಾಪಿಸಿ ಸಿದ್ಧಪಡಿಸಿ ನಿರ್ದೇಶಕರಿಗೆ ಸಲ್ಲಿಸತಕ್ಕದ್ದು ಅಷ್ಟೇ. ಯು ಹ್ಯಾವ್ ಟು ಸೆಂಡ್ ಇಟ್ ಟು ದಟ್ ಡೈರೆಕ್ಟರ್. ಸದರಿ ಹುದ್ದೆಯಲ್ಲಿ ಪರಿಶಿಷ್ಟ ಸೋಂಶ ನೀಡಿದ 2 ತಿಂಗಳ ಒಳಗಾಗಿ ಭವಿಷ್ಯಾನ್ವಯವಾಗಿ ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸುವ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ನಿರ್ದೇಶಕರಿಗೆ ನಿರ್ದೇಶಿಸಿದೆ. 2005ನ ನಿಯಮಗಳ ಪ್ರಕಾರ ಅರ್ಜಿದಾರರಿಗೆ ಕನಿಷ್ಠ ವೇತನದ ಪಾವತಿಸಲು ಆಡಳಿತ ಮಂಡಳಿಗೆ ಬಾಧ್ಯವಾಗಿದ್ದು, ಪರಿಶೀಲನಾ ಅರ್ಜಿ ಆದೇಶದ ದಿನಾಂಕದಿಂದ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸುವವರೆಗೆ ಅರ್ಜಿದಾರರಿಗೆ ಕನಿಷ್ಠ ಮೂಲ ವೇತನ 3 ತಿಂಗಳ ಒಳಗಾಗಿ ನೀಡಲು ನಿರ್ಧರಿಸಿದೆ. That also there.
Yes, my lords, and that has to be considered by respondent number 1, my lords, and my lords kindly see the
ಪದವಿ ಪೂರ್ವ ಇಲಾಖೆ ನಿರ್ದೇಶಕನ ಪಾಲಿಸಿದ ಕರ್ನಾಟಕ ರಾಜ್ಯದ ಉಲ್ಲೇಖನೆ ಮಾಡಿರುವ ಕಾರಣ ಅನುದಾನ ಹಿಂಪಡೆಯುವ ಬಗ್ಗೆ ಸ್ಪಷ್ಟ ವರದಿಯನ್ನು ಸರ್ಕಾರಕ್ಕೆ ವರದಿ ಮಾಡತಕ್ಕದ್ದು.
And my lords may kindly see the prayer also, my
Yes,
lords.
he is seeking only implementation of that order.
Yes,
He
my
lords.
recommended.
Now the management is now trying to shift the blame on the government. The lordships may kindly see page 33. There was a direction, my lord, as early as 23/2015. My lord, that the petitioner must be taken back, my lord. The lordship may kindly see the final order, page 35.
Yes.
ಅನುದಾನಿತ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜುಗಳಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದು ನಂತರ ವೇತನಾನುದಾನಕ್ಕೆ ಒಳಪಟ್ಟಂತಹ ಯಾವುದೇ ನೌಕರರು ಅನುದಾನಕ್ಕೆ ಒಳಪಟ್ಟ ದಿನಾಂಕಕ್ಕಿಂತ ಪೂರ್ವದಲ್ಲಿ ಸಲ್ಲಿಸಲಾದ ಸೇವೆಗೆ ಯಾವುದೇ ಸೌಲಭ್ಯಗಳನ್ನು ಪಡೆಯಲು ಅರ್ಹರಾಗಿರುವುದಿಲ್ಲ ಎಂಬ ವಿಚಾರಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಸರ್ಕಾರವು 2014ರಂದು ಶಾಸನವನ್ನು ಜಾರಿಗೆ ತಂದಿರುತ್ತದೆ ಎಂಬ ಅಂಶವನ್ನು ಆಡಳಿತ ಮಂಡಳಿಯ ಗಮನಕ್ಕೆ ತರಲಾಗಿದೆ. ಮೇಲ್ಕಂಡ ಎಲ್ಲಾ ಅಂಶಗಳನ್ನು ಗಣನೆಗೆ ತೆಗೆದುಕೊಂಡು ಶ್ರೀ ಚಂದ್ರಶೇಖರ್ ಎಂ ಇತಿಹಾಸ ಉಪನ್ಯಾಸಕರು ಈ ಆದೇಶ ತಲುಪಿದ ತಕ್ಷಣ ಕರ್ತವ್ಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಿಕೊಳ್ಳುವಂತೆ ಆಡಳಿತ ಮಂಡಳಿಗೆ ಮತ್ತೊಮ್ಮೆ ಸ್ಪಷ್ಟ ಆದೇಶ ನೀಡಿದೆ.
ಆಯ್ತು, ನಿಮ್ದು ಆದೇಶನ ಅವ್ರು ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ you could have withdraw that this thing recognition.
Now since 2021, my lord, they haven't had the sufficient student strength since 2021.
No, that's I can't decide all these things. That's what I am saying, that when that your secretary has decided, only thing he is seeking that to implement that order. 133.
The order in review by the secretary.
Annexure M ಏನದು?
My lord, that annexure M is the order in review by the secretary, my lord. 133. Review by the secretary, government.
M.
Annexure M, page 63. That has come in, your lordships will notice, 34/2024.
34/2024.
Since 2021, my lord, the college has not had sufficient student strength.
Annexure M ಅದು.
Annexure M. Now, my lord, the difficulty is this, my lord. Now, unless he is admitted to grant in aid, he cannot be transferred to another college. The other document which I have produced, my lord, I had given 2 documents.
Yes.
Bethany College has it's a minority institution. They have refused to take him. Now he can be accommodated elsewhere. That can be done, but he has to be first admitted to grant in aid.
That is
now
what...
to admit him to grant in aid, the college does not have the student strength.
Now, grant in aid has been revoked is what my instruction is. The institution is closed.
Only the recognition.
No,
my
not
lord, in
that
any
present
case,
situation.
my lord, in a situation like this, my lord, the liability
No,
should...
you take decision whatever you want. Only that direction is that ಉಪನಿರ್ದೇಶಕರು ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸುವ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಸಿದ್ಧಪಡಿಸಿ ನಿರ್ದೇಶಕರಿಗೆ ಸಲ್ಲಿಸುತ್ತಾರೆ. Then the director is directed 2 ತಿಂಗಳ ಒಳಗೆ ಭವಿಷ್ಯ ನಿಧಿ ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸುವ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ನಿರ್ದೇಶಕರಿಗೆ ನಿರ್ದೇಶಿಸಿ. He has to take a decision for...
There may be a direction to, my lord, send the proposal in, since the management has not given the proposal.
Yes.
Let the...
Now that management has given NOC. Now
NOC,
that deputy director has to...
But the management should continue to be liable for making payment of minimum wages, my lord. That liability should not be, then they should not be evade that liability. My lord, that reason being, I'll just add one more point. As per the collegiate education rules also, my lord, they are required to pay same pay scales as what is being paid to government employees in equivalent posts in government
But the
colleges.
concession has been shown by your secretary saying that pay only that minimum wages. ಕನಿಷ್ಠ ಮೂಲ ವೇತನ ಪಾವತಿಸಲು ಅದು ಅರ್ಜಿ ಕೊಟ್ಟಿರೋದ್ರಿಂದ
That is a statutory duty imposed on the
he has
private
to
management
seek for
that
an-
they cannot
Yes.
evade.
They may consider that and pass orders, my lords. Even the prayer is with regards to
Order is already there.
consideration of the application.
Partly mandamus prayer to respond to send a proposal according to the directions. In this writ petition, petitioner sought following relief. Third respondent. Third respondent is an institution, huh?
Institution.
Yes. Third respondent institution was started in the year 1984-85. On 26/12/1990, third respondent college is admitted to granting aid. At that time, the post of the lecturer in history was not included to the salary grant, on the ground that said post was reserved for SC category. No, you have appointed in the beginning itself. He has appointed,
Yes,
but
madam.
since it is in a post reserved for SC, he is an ST.
Yes.
It has been, yes.
The government puts an
The
objection. to
post of the lecturer in history, the petitioner was appointed, adrili granting aid, admitted to the granting aid. Petitioner was appointed as a history lecturer.
that. Yes.
The post which was reserved for SC. Since petitioner has belongs to that ST category, the post of the lecturer in history was not included in the salary grant. Now, when you have appointed, Mr., why that this proposal has come later?
Lords, I was appointed in 2004, my lords.
12/3/2004 is the date of appointment.
1/3?
2004 month.
2003.
Now, why that in the beginning, 1990, that history lecturer was not admitted to granting aid?
It was
That was
vacant.
the
post,
proposal
my lords,
itself.
Since
Why,
there
Mr.?
Since there was no candidate belong to SC category, my lords, it was remained as backlog post, my lords.
No, that it was not filled.
It was not filled, my lords.
Itarakali, 1990, government of it was admitted to the granting aid. While admitting into the granting aid, the post of the lecturer in history was not included to the salary grant, as the said post was not filled up by the candidate belongs to that scheduled caste. When you have appointed,
1/3/2004, my lords.
on 12/3/2004, petitioner was appointed as a lecturer in history in the third respondent institution. Appointment was approved granting aid
Without granting aid, it
Without
was
granting
approved,
aid.
my lord. On 27/9/2006.
on 29/7/2016. The appointment of the petitioner was approved without granting aid. On 5/2/2015,
The Director, Department of PU Education, directing the second respondent to send a proposal of the petitioner for admitting into the granting aid.
After reinstating him, my lord, because he was removed without inquiry.
Earlier,
This was on 5 to 2015. my lord.
yes, 5 to 2015,
There-
when he was removed,
In the year 2009, my lords.
2009.
that is not relevant, only that why he has been sent, yes. On 17/12/2015, the Director, Department of PU Education, directed the second respondent to send a proposal of the petitioner for admitting to the granting aid. Since management has not sent the proposal for recommending the petitioner name for admitting the granting aid, petitioner has approached the secretary. Petitioner has filed a revision under section 133 of Education Act.
May, my lords?
Revision is 131.
Earlier, I had approached the director, my lords, under 131, who in turn allowed my appeal and directed the management to submit the proposal, my lords. Thereafter, I approached the secretary, my lords, to implement the
No.
order of the director.
Director has given a direction. What is the direction?
That is the one, my lord, the 23 2015.
23?
2015.
Yes.
Which I pointed out.
He has filed an
Uh,
appeal under section 131 of.
I'm sorry, my lord, that is 5/6/2021. my lord. Revision is under 131.
Yes, filed a revision under 131 of Education Act before the director pre-university. Wide annexure K dated 5/6/2021. What is the direction she has given?
My lord, to take him back into service, then management may just
ನಿಯಮಾನುಸಾರ ಸಲ್ಲಿಸಲು ಅವಕಾಶ ನೀಡಿದೆ. ಅವರ ಆಡಳಿತ ಸರ್ಕಾರದಿಂದ ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸಿದ ದಿನಾಂಕದ ವೇತನಕ್ಕೆ ನಿಗದಿಪಡಿಸಿ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಬಹುದಾಗಿದೆ. They have directed to submit a proposal.
Yes, three things, my lord. I have summed it up. To take him back into service, then the management to send a proposal to fix the first pay salary from the date of admission to granting aid.
Now that,
Then
it will give a continuity. Since they have not sent a proposal, he has approached the director.
Yes.
Director has directed the management to send a proposal. Yes. By order dated 5/6/2021, the director has directed the management to send a proposal to the government for approval of the appointment of the petitioner for admitting the granting aid. Thereafter, management has not sent that proposal. Petitioner has filed a review under section 133 of Education Act before the secretary, principal secretary, respondent number 1. By order dated 30/4/2024, the principal secretary has passed the following order extract ಮಾಡಿ 64 ಅಲ್ಲಿ order portion ಮಾತ್ರ. Thereafter, as per the directions of first respondent, the deputy director has not sent the proposal to the director. Hence, petitioner is approached this court. Learned government advocate appearing for the state has submitted that. Now that institution is at the verge of closing, the government is also withdraw that salary grant to that institution.
And he further submitted that from 2009 2009 ಇಂದ ಇಲ್ವಾ work ಮಾಡ್ತಿಲ್ವಾ?
2009 ಇಂದ ವರ್ಕ್ ಮಾಡ್ತಿಲ್ಲ.
From 2009 petitioner is not working
As per the report of the DDPI.
as per the report of the DDPI. Therefore, the deputy director has not submitted any proposal. Be that as it may, by order dated 30/4/2024, in the revision filed by the petitioner under section 133 of Education Act, the first respondent has specifically directed.
Review.
Yes, 133 is review. Specifically directed the deputy director to send a proposal to the director, and the director is directed to consider that proposal submitted by the deputy director in accordance with law. In view of the above, the deputy director is directed to our party madilva.
Deputy director.
Fifth respondent, deputy director is
Respondent number
directed
5,
to-
my lord.
Yes, fifth respondent is directed to, deputy director is directed to submit a proposal as directed by the first respondent in revision dated 30/4/2024 within 2 weeks from today. Within 2 months from today. After that, the director is directed to consider that proposal sent by the deputy director in accordance with law within 2 weeks from the date of receipt of that, 2 months from the date of receipt of that proposal. With that observation, writ petition is disposed of.
My lords, the liability of the management with regard to payment of minimum basic wages, my lords, I have been prevented from attending the duty since 2009, my lords.
No, here the direction is, no, see, that liberty is reserved to the petitioner to submit a representation to that management for payment of salary till the government, the director considering his representation for proposal. Director is considering this proposal. Let him submit that, you let him consider. If such a, for you, if such a representation is submitted to the management, management is directed to consider the same in accordance with.
We'll consider it, they have to consider it, my lords, we can.
No. During this period, he is entitled for that salary.
Basic payment,
Yes, that we have to be give.
but I have been.
Their liability will come only after if they are admitted to the granting aid.
Please.
Yes.
Great.
Number 39, P.N. Nanjareddy for petitioner, A. Chandra.
Yes.
Appear for the petitioner.
The matter where you have sought for
In this
direction,
case-
virtue of your lordship's order, Your Honor. My IA is filed on.
The last kindly say short synopsis.
My memo is dated 5th August 2025, wherein your lordship, the petitioner and the petitioner in that, if your lordship gets the memo, memo kodi kotta.
Yes.
Along with the order copy of your lordship, I have just filed it, Your Honor. Sudhamani petitioner in 25/8/52 and the present petitioner were under the same charge sheet, Your Honor, and same charge memo and same
ಇದರಲ್ಲಿ ಇಷ್ಟೇ
final.
ಒಂದು ನಿಮಿಷ ಹೇಳ್ತೀನಿ. Giant enquiry was held. Initially it was held, my lord. Thereafter, my lord, the enquiry officer held that the charges are not proved. Thereafter, the management issued show cause notice stating that there is disagreement with the findings of the enquiry officer. Therefore, in terms of regulation, my lord, 11A of the regulations, my lord, I have extracted. My lord, they have to take, my lord, its logical end. Instead of that, they have appointed an enquiry officer, second enquiry officer. It is not permissible. That is the only issue.
Your lordship has dealt that in the previous.
It can be,
judgment.
it can be.
Your lordship has dealt that.
Page
Your
11
Honor.
of the writ petition, last.
Yes, page 11.
Page 11 of the writ petition.
This
ಇಲ್ಲಿ
aspect.
ಅದನ್ನು ಹೇಳ್ತೀನಿ ಸ್ವಲ್ಪ ಇರಿ ಸರ್.
Yes.
11A, action of the inquiry report. The disciplinary authority shall, if it disagrees with the findings of the inquiry authority, on any articles of charge record its reasons for such disagreement and record its own findings on such charge if the evidence on record is insufficient for the purpose.
You give that full. There is other options also. Is there?
Yeah, sorry.
No, this is KCSR or they have their own regulation?
Of course,
Own regulation.
Own regulations in parameter with
Yes.
11.
ಇನ್ನು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ಲ. ಇನ್ ದ ಮೀನ್ ಟೈಮ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಆರ್ಡರ್.
ನೆಕ್ಸ್ಟ್ ಕ್ಲಾಸ್ ನೋಡಿ ಸರ್. ಒಂದು ನಿಮಿಷ.
The second inquiry was also dealt in the earlier matter. Your lordship has also given a finding on that.
Yes, yes, let us, yes, which is that 11, yes.
11A2 and next 3, class 3 also. They have to call for issue show cause, and if they disagree, they can impose punishment, though there is no need for appointing second inquiry officer.
To be imposed on the board employee itself in not withstanding anything content make an order of imposition. Yes. See, reason to be recorded by its writing.
Yes.
Remit the case to that inquiry authority for further inquiry and report. They can remit back that. Remit back, that doesn't mean that same officer. That means to say they can do it, giving an appointing that.
Yes. Identical circumstances.
Yes.
Copy.
Yes.
In this case also, last may kindly say, the so fact though, that para 3,
Yes.
the freaks leading to the filing of so and so. The petitioner joined the service of the response for so and so for short in the year 1981 claims to have been confirmed in so and so. And DPG section, he was placed under suspension in contemplation of the certain disciplinary proceedings. These disciplinary proceedings were initiated by issuing articles of charge dated so and so. The inquiry officer who held the inquiry in terms of the charge sheet held the charge as partly proved insofar as loss caused to the company is concerned and the act of the petitioner as it was held to be not proved by the inquiry officer. The findings reads as illi ದಾಖಲಾರ್ಸೋ ಅದೆಲ್ಲ ಆದ್ಮೇಲೆ during the pendency of the consideration of the report of the inquiry officer, the petitioner was relieved from service on his attaining the age of superannuation on 31/5/2016. 2 days before relief of the petitioner on retirement, show cause notice was issued on 28/5/2016, which reads as follows. The investigation officer, that means after the inquiry report, you last may kindly say. The investigating officer, Anil Rampal so-and-so, has submitted his investigation report along with annexures, copy of which is enclosed herewith. The investigation report submitted by Anil Rampal is accepted. It is proposed to levy penalty of ₹11 lakhs so for the loss caused by you to Karnataka soaps and detergents on account of negligence and dereliction of duties. You are hereby called upon to submit your reply within 15 days of the receipt. If the report of the inquiry officer is juxtaposed with the show cause notice issued to the petitioner on 28/5/2016, it becomes clear that the disciplinary authority did not disagree with the findings of the inquiry officer, but secured a separate report, Lordship may kindly say, from investigation officer who opined in the report that the petitioner was responsible for certain loss in the company and proposed a penalty of recovery of 11 lakhs for the alleged loss. This report of the investigation officer did not form part of inquiry proceedings. The inquiry officer having held that the allegations with regard to causing loss not proved, the disciplinary authority, without disagreeing with the findings of the inquiry officer, would not have issued a show cause notice holding the petitioner guilty of the allegation and directing recovery of loss contrary to the report of the inquiry officer. It also to be noticed that there was no notice issued by the disciplinary authority seeking to disagree with the findings of the inquiry officer. The show cause notice is issued to show cause as to why recovery should not be initiated against the petitioner. The petitioner, by his reply dated 6/6/2016, submitted the inquiry officer had not held him guilty of the allegations of causing loss. The show cause notice came to him as a rude shock and sought that recovery of
ಇದು
loss.
applicable ಆಗಲ್ಲ ಬಿಡಿ.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಇವ್ರು
ಎನ್ಕ್ವೈರಿ ಆಫೀಸರ್ ರಿಪೋರ್ಟ್ ಅನ್ನು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟು ಆಮೇಲೆ ಎನ್ಕ್ವೈರಿ ಆಫೀಸರ್ 2-3 ಚಾರ್ಜಸ್ ಗೆ ನಾಟ್ ಪ್ರೂವ್ಡ್ ಅಂತಿತ್ತಲ್ಲ, ಒಂದ್ಸರಿ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಂಡ್ಮೇಲೆ ಇನ್ನೊಂದು ಪಾರ್ಟಿಗೆ ಅದನ್ನ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಂಡಿಲ್ಲ ಅಂತ ಹೇಳಿ
ಅಲ್ಲ ಇದಲ್ಲ
ಇನ್ನೊಂದು ಎನ್ಕ್ವೈರಿ ಆಫೀಸರ್ ಕಂಡಕ್ಟ್ ಮಾಡಿ ಎನ್ಕ್ವೈರಿ ಮಾಡ್ಬೇಕು. ಅದು ಬಿಟ್ಬಿಟ್ಟು ಯಾರೋ ಒಬ್ಬನ ಹತ್ರ ಒಂದು ರಿಪೋರ್ಟ್ ತಗೊಂಡ್ಬಿಟ್ಟು ನೀನ್ ದುಡ್ಡು ಕೊಡೋ ಅಂತ ಹೇಳಿದ್ರು ಅಂತ. ಹಿಯರ್
ಇದು ಅಲ್ಲ ಅನಲೈಸ್ ಸೇಮ್ ಆಲ್ಮೋಸ್ಟ್ ಸೇಮ್
ಅನಲೈಸ್ ಐ ವಿಲ್
ಇರ್ಲಿ ಅದು ರೆಗ್ಯುಲೇಷನ್ ಆಲ್ಸೋ ಸ್ಪೀಕ್ಸ್ ಲೈಕ್ ದಟ್. ಯು ಲಾಸ್ಟ್
once you have accepted that inquiry officer's report and said that second show cause notice for these charges you have to pay, again they cannot say that one more inquiry. ಇಲ್ಲಿ ಇವರು ಎನ್ಕ್ವೈರಿ ಆಫೀಸರ್ ರಿಪೋರ್ಟ್ ಅನ್ನು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಂಡಿಲ್ಲ ಅವರು. therefore there is an option for them to go for an
no they have disagreed. You last mechanism
disagree ಅಂತ ಅಂದ್ರೆ
ಅಲ್ಲ disagreed ಆದ್ಮೇಲೆ we have submitted the report show cause notice ಕೊಟ್ರು, ಪೆನಾಲ್ಟಿ ಹಾಕಿ ಇಶ್ಯೂ ಮಾಡೋದು, ಮತ್ತೆ ಬೋರ್ಡ್ ಅಲ್ಲಿ ಇಟ್ಬಿಟ್ಟು ಮತ್ತೆ ಅಪಾಯಿಂಟೆಡ್ ಎನ್ಕ್ವೈರಿ ಸೆಕೆಂಡ್ ಎನ್ಕ್ವೈರಿ ಆಫೀಸರ್. That is not permissible.
No, what is that they have
Annexure V page Annexure R sorry Annexure V Miller.
what is that inquiry is exonerated.
ಇಲ್ಲ ಇಲ್ಲಿ ಎನ್ಕ್ವೈರಿ ಎಕ್ಸಾಮಿನೇಟ್ ಆಗಿಲ್ಲ ಇನ್ನ.
ಏನ್ ಮಾಡಿದ್ರು?
ಮತ್ತೆ ಎಕ್ಸಾಮಿನೇಟ್ ಆಗಿದೆ.
ಮತ್ತೆ ಯಾಕೆ ಶೋಕಾಸ್ ನೋಟಿಸ್ ಕೊಟ್ರು ನಿಮಗೆ?
ಡಿಸ್ಅಗ್ರಿಮೆಂಟ್ ಗೆ.
ಮತ್ತೆ ಅದ್ ಮಾಡ್ಬೇಕಂತಾನೆ ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಹೇಳ್ತಿರೋದು.
ಅಲ್ಲ ಕರೆಕ್ಟ್, ಡಿಸ್ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿದ್ಮೇಲೆ ಅದ್ಮೇಲೆ ಹಂಗೆ ದೇ ಶುಡ್ ಪ್ರೊಸೀಡ್. ಅದಕ್ಕೆ ರೆಗ್ಯುಲೇಷನ್ ಓದಿದ್ ನಾನು
ಯಾವ್ದ್ರದ್ದು
11A2(3). They have to proceed. ಹಂಗೆ punishment. There is no need for inquiry, second inquiry officer.
ಮಾಡ್ಬೋದು, ಎರಡು ಆಪ್ಷನ್ಸ್ ಇದೆ.
ಇಲ್ಲ
that is what that I have read. You which is that annexure.
ಅಲ್ಲ ಸಪರೇಟ್ ಆಗಿ ಕೊಟ್ಟರಲ್ಲ annexure ಫುಲ್ ಬಂತಲ್ಲ ಅದರಲ್ಲಿ.
ಅಲ್ಲ ರೆಗ್ಯುಲೇಷನ್ ಎಲ್ಲ ಓದಿದ್ರಲ್ಲ
ಅಲ್ಲಿ ಅದೇ 11 ಇದಕ್ಕೆ ಫ್ಲಾಪ್ ಹಾಕಿದ್ರು.
Disciplinary authority, if it is not itself the inquiring authority, may for the reason to be recorded by it in writing remit the case to that inquiry authority for further inquiry and report, and the inquiry authority shall thereupon proceed to hold the further inquiry according to that provision rule 11. See, the inquiry authority shall thereupon proceed to hold the further inquiry in accordance to that regulations 11. Again fresh de novo.
ಅಲ್ಲಲ್ಲ ಫ್ರೆಶ್
not agreed.
ಅಲ್ಲ ಡಿ ನೋvo ಬರೋದು ಇಲ್ಲಿ, ಅದು ಡಿ ನೋvo ಹೇಳಿಲ್ಲ ಅದರಲ್ಲಿ ಅವರು.
See, according to that provision of regulation 11 ಅಂತಂದ್ರೆ regulation 11 start from the beginning.
ಸರಿ, ಈಗ ತಾವು ನೋಡಿ ಸಮ್ Annexure B.
This point your lordship has discussed in the previous judgment which I have just produced, your honor. For which I am just seeking disposal on the same ground, because the petitioner in that writ petition and the petitioner in the present writ petition are in the same charge memo.
Except
May I
joint
read out
inquiry
paragraph number 3, my lord.
except joint inquiry ಬಿಟ್ರೆ this point was not canvassed.
Para number 3, my lord. Your lordship's judgment along with the memo I have just produced. She, learned counsel so and so submits that in an inquiry report submitted by the first inquiry officer, paragraph number 3, my lord. Inquiry officer, the charges against the petitioners have not been proved. The disciplinary authority, before taking a decision to initiate a de novo inquiry, has not issued notice to the petitioner. The initiation of the de novo inquiry is contrary to law. Therefore, the inquiry report submitted by the second inquiry officer, void so and so, and consequent final so called notice at Annexure Q may be set aside. So and so, counsel for the respondent number 1 and 2 submits that before initiation of the de novo inquiry, notices has been issued to the petitioner and she has participated in the inquiry. Now she cannot challenge the inquiry report submitted by the inquiry officer so and so as per Annexure P. And he contended that the second show cause notice has been issued void Annexure Q, calling upon the petitioner to give a reply. The petitioner can give a reply, taking her contentions, and the competent authority will consider the same and pass the order. Heard the learned counsel for the parties and peruse the writ petition papers. As per the report submitted by the inquiry officer so and so, the charges against the petitioner have been proved. Under the BESCOM regulations, if the disciplinary authority is not satisfied with the inquiry report, they can order for de novo inquiry, or if they have sufficient materials to reverse the findings, they can pass order in accordance with law. Since the respondent number 2 has taken a decision that the matter requires to be de novo inquiry, then so and so is appointed as an inquiry officer, and the petitioner has participated in the inquiry. The second inquiry officer submitted a report stating that the charges leveled against the petitioner is approved and issued a sub-quash notice at Annexure Q. Under these circumstances, the petitioner be permitted to file a detailed objection to Annexure so and so to the appointment of the second inquiry officer within 15 days from the date of receipt of the certified copy of the order. The respondent is directed to consider the same and pass appropriate order in accordance with law. All the contentions of the parties are left open. This is where your lordship has fixed a time frame. There is a stay in this. It is the same inquiry report. It is the same charge memo, Your Honor, and it is the same so-cast notice. May I convince that it is the same annodukke? If your lordship in your order, I say that if a four weeks time is granted to us, because the petitioner in that writ petition and the petitioners are both available. If your lordship takes the show cause notice at Annexure W98.
Let him complete. Yes, Mr.
ಅವ್ರು ಹೇಳೋದಂದ್ರೆ ನಮ್ಗೆ ಅದರಲ್ಲಿ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ವಿ ಕೆನಾಟ್ ಪ್ರೊಸೀಡ್ ಅಂತ. ಲೆಟ್ ದಮ್ ಪ್ರೊಸೀಡ್ ಇನ್ ದಟ್ ಕೇಸ್.
No, I am deciding your case, Mr. You argue that.
ಅಷ್ಟೇ ನಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್.
Yes, that's all.
Yes, ma'am. If your lordship takes 98, my lord.
In this writ petition.
ಎರಡು ಚಾರ್ಜ್ ಮೆಮೊನಲ್ಲಿ ಇಬ್ರು ಇದ್ದಾರೆ ಅನ್ನೋದಕ್ಕೆ ನಾನು ಒಂದೇ ಒಂದು
ಅದೊಂದೇ ಅವ್ರ ಮೈನ್ ಗ್ರೌಂಡ್ ಜಾಯಿಂಟ್ ಎನ್ಕ್ವೈರಿ ಅಂತ.
Yes, nim contention I will take it that. Yes.
ಅಲ್ಲ
this writ petition. Petitioner.
ಅಲ್ಲ ಇದರಲ್ಲಿ you lost may also say that regulation in terms of that regulation that also may be considered.
Yes, on regulation consider ಮಾಡೆ ನಾನು ಅಲ್ಲಿ ಫೈಂಡಿಂಗ್ ಕೊಟ್ಟಿರೋದು.
ಇಲ್ಲ ಇದ್ರ of course ತೋರಿಸಿಲ್ಲ ಅವರು. ನಾನು just
Yes, I will consider your argument. Yes. I will take that judgment also which you have relied on. How it can be distinguished.
ಅದರಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ?
I will distinguish you. Wait, Mr. Yes. This writ petition. What is that E, F, G and all you are challenging?
That is charge sheet bed.
Yes, which is that?
Main ಬಂದು ನಮ್ಗೆ annexure V and Q.
ಅಲ್ಲ W is the final show cause notice, Your Honor.
V and W na?
V and W. In the previous writ petition,
V and W.
What is that V?
V, that
the
is
report of the inquiry.
Appointment of the inquiry officer.
New this thing.
ಹೌದು.
Inquiry
New
officer.
second inquiry officer.
Yes. This writ petition. Petitioner called in question Annexure V dated 3rd January 2024, whereby respondent has appointed second inquiry officer conducting a departmental inquiry and Annexure W. Then show cause notice ಏನಕ್ಕೆ?
Final show cause notice after the inquiry report was submitted.
Inquiry report ಎಲ್ಲ submit ಆಗೋಗಿದೆ.
ಅಲ್ಲಿ ಅವ್ರು ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿದ್ದಾರೆ.
Yes.
ಅಲ್ಲ ಅದೆಲ್ಲ ಆಗಿದೆ. ಬಟ್
ಅದನ್ನೇ ತಾವು ಹಳೆ ಆರ್ಡರ್ ನಲ್ಲೂ ತಾವು ಅದನ್ನ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದೀರಾ.
And Annexure W dated 17th August 2024. After concluding that inquiry, second show cause notice has been issued for recovery of loss. ಏನದು recovery of yes, loss caused to that corporation. What is that petitioner?
storekeeper.
Storekeeper here.
After retirement it was
Was working as a storekeeper
in synopsis ಅಲ್ಲಿ
respondent corporation.
detail ಆಗಿ.
When he was in service.
ಇಲ್ಲ after retirement ಮಾಡಿದ್ರು.
After retirement.
ಅಲ್ಲ ಸರ್ವಿಸ್ ನಲ್ಲಿ ಇದ್ದಾಗ ಅವ್ರದ್ದು ಆಗಿರೋದು.
Initiate ಮಾಡಿದ್ರು. When he was in service.
ಇಲ್ಲ ರಿಟೈರ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಸರ್ವಿಸ್ ಇದು ಚಾರ್ಜ್ ಶೀಟ್ ಕೊಟ್ಟಿರೋದು. You lost my kindly.
ಅಲ್ಲ ಎನ್ಕ್ವೈರಿ ಇನಿಷಿಯೇಟ್ ಮಾಡಿದ್ದೆ ಅವಾಗ.
After retirement.
After retirement. Yes.
ನಿಮ್ ಕನ್ಫ್ಯೂಷನ್ ಸಿನಾಪ್ಸಿಸ್ ನೋಡಿ.
After retirement or before?
ಇಲ್ಲೇ ಇದು ಹಾಕಿದಿನ earlier.
When you have retired from the service?
Milad 9/5/2012 ಅಲ್ಲ ಇದು
When you have retired from the service?
2013.
When that inquiry has been initiated?
First charge sheet is in the year 2016.
16.
After
4 years. ಅದಕ್ಕೂ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೆ. ಒಂದು 4 days ಡಿಫರೆನ್ಸ್ ಆಫ್ಟರ್ 4 years ಯು ಲಾಸ್ಟ್ 214 A ಅದು ಬರಲ್ಲ ಅಂತ ಹೇಳಿ ಸ್ಟೇ ಇತ್ತು. ಆಮೇಲೆ 4 days ಡಿಫರೆನ್ಸ್ ಬರುತ್ತೆ ಅಂತ
ವಜಾ ಮಾಡಿದ್ರು
ಅಷ್ಟೇ.
ಅವರು ಚಾರ್ಜ್ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡುವಾಗ ಡಿಸ್ಕ್ರಿಪೆನ್ಸಿ ಇತ್ತು ಅಂತ ಚಾರ್ಜ್ ಮೆಮೋನಲ್ಲಿ ಬರ್ದಿದ್ದೀವಿ ಸರ್.
Yes.
He
was appointed as a storekeeper
ನೋಡಿ
and retired from the service on 28 to 2013 on attaining superannuation. Thereafter, departmental inquiry has been initiated on 17/9/2016. Allegation of misappropriation of fund.
Shortage of materials.
Yes. On 22/3/2022, one M. Ramachandra, retired district and session judge, was appointed as an inquiry officer. When he has been appointed?
Millard 15/3/2017.
15/3/2017.
Yes.
So and so has been appointed as inquiry officer.
The synopsis ಅಲ್ಲಿ clean ಆಗಿ ಹೇಳಿ.
Yes.
ಆಮೇಲೆ I have submitted my
Allegation of misappropriation fund. Joint inquiry has been initiated against the petitioner as well as one Srimati.
and others ಇನ್ನಿಬ್ಬರು ಮೂರು ಇದೆ.
Others, yes, and others. On 22/3/2022, the inquiry officer M. Ramachandra, retired district and session judge, submitted a report stating that charges leveled against the petitioner
and others,
petitioner and others was not been proved. Thereafter, the disciplinary authority did not accept that inquiry report submitted by the inquiry officer.
They have issued show cause note and replied for that.
Ultimately, they have not, yes. And passed an order for de novo inquiry.
ಅಲ್ಲ ಡಿ ನೋವ್ ಅಂತ ಹೇಳಲ್ಲ ಅದಕ್ಕೆ
ಅರ್ಥನೇ ಅದು. Yes.
ಅಲ್ಲ ಸೇಮ್ ಡಿಟರ್ಮ್
appoint a second inquiry officer.
Yes.
Second inquiry officer ಅಂತಂದ್ರೆ it is more beneficial than the de novo. Yes, second inquiry officer. Thereafter what? Petitioner has appeared before that
and submitted explanation.
Petitioner has submitted his explanation and appeared before that inquiry officer. The second inquiry officer has submitted a report that charges level against the petitioners and others have been proved. Pursuant to that,
show cause notice.
Impugn notice W has been issued
17/8/2024.
being aggrieved by that impugn show cause notice W and appointment of second inquiry officer has been challenged before this court.
Yes.
Reddy Learned Council submitted that the first inquiry officer has submitted a report stating that charges against the petitioner and others has not proved. Thereafter, under the regulation, there is no power for the disciplinary authorities to appoint a second inquiry officer. If they are disagree with that finding of that inquiry authority on any articles of charges, they can record his reason for such disagreement.
ಅಲ್ಲ ಮೊದಲು ಇರ್ದಿದ್ರೆ ಚಾರ್ಜ್ ಶೀಟ್ ಬೇರೆ ಏನು ಕೊಟ್ಟಿಲ್ಲ ಅವರು. ಮೊದಲು ಚಾರ್ಜ್ ಶೀಟೇ ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಇಶ್ಯೂಡ್ ಎನಿ ಅಡಿಷನಲ್ ಏನು ಕೊಟ್ಟಿಲ್ಲ.
ಅಲ್ರಿ ರೂಲ್ 11 ಏನ್ ಹೇಳುತ್ತೆ ಅಂತ ಹೇಳ್ತಾರೆ.
11A.
11. If they are disagreed with that
findings of the inquiry authority.
Finding of that inquiry authority on any articles of charges
11A.
and its reason for such disagreement and record its own finding on such charges if the evidence on records is sufficient for the purpose. They have no power to appoint second inquiry officer. Secondly, he has contended that, and in support of his contention, he has relied on judgment of this court in WP number 21160 of 2017, disposed of on 8th July 2021. He further contended that since the appointment of second inquiry officer vide annexure V is contrary to that regulation 11A of that act, the consequential notice issued pursuant to that report submitted by that second inquiry officer vide annexure W is unsustainable. Hence, he sought for allowing that writ petition. Learned counsel appearing for the corporation has submitted that the first inquiry officer has submitted a report stating that charges level against that all delinquent employee has not been proved. By exercising the power under regulation 11A, the board has taken a decision. Board has disagreed with that finding of that first inquiry officer and taken a decision to appoint second inquiry officer to conduct de novo inquiry. Thereafter, second inquiry officer has been appointed. Notice has been issued to the petitioner. Petitioner has submitted his reply and participated in that inquiry. Second inquiry officer, Shri Basuraj S. Tadhal, district and session, retired district and session judge, has submitted a report, inquiry report stating that charges has proved. Thereafterwards, second show cause notice has been issued vide annexure W.
Yes, ma'am.
Thereafter, petitioner has approached this court. Instead of submitting the reply, he has approached this court and challenging that. Hence, he sought for dismissal of that writ petition. How did the learned counsel for the parties peruse that writ petition? The respondent corporation has initiated joint inquiry against the petitioner and others employees of the corporation.
Which your lordship will find.
They are appointed one M. Ramachandra, retired district and session judge, as an inquiry officer. The disciplinary authority has appointed one M. Ramachandra, retired district and session judge, as an inquiry officer. He has submitted a report stating that charges level against that
petitioner have not been proved. Under section 11A of that regulation, that disciplinary authority, if it is not itself is the inquiry authority, for reason to be recorded by in writing, they can disagree with that inquiry report submitted by the inquiry officer. On the finding available on that inquiry report, they can impose that penalty, or they can appoint
they can appoint ಅಂತ ಇಲ್ಲ. That is
ನಾನು ಹೇಳ್ತಿರೋದ್ರಿ, it is I am giving that interview whether you are
further inquiry.
Further
inquiry is permissible. That is, if the inquiry has committed some mistake, disciplinary authority can point out these are the evidence which are not have been properly recorded.
Yes, that's,
we do it. Other inquiry as well, that is called further inquiry.
this is de novo, you can be do it, but yes.
De novo ಮಾಡ್ಬೋದು. That is judgment. That is not. De novo.
No, no, further inquiry, it is not that they can be given to that same officer. They can be given to that any officer.
Should continue from the stage where the defect has occurred.
Yes, that is what that. Alindane, they see, he is saying that they have not believed that earlier inquiry officer. They are appointed that further this thing.
Totally disbelieve ಮಾಡಕ್ಕಾಗಲ್ಲ because.
No, they have not done it. From that stage.
ಇಲ್ಲ ಆ ಸ್ಟೇಜ್ ಇಂದಲ್ಲ, ಅದು that's the reason. Report from the beginning they have started.
What is that they have started?
The inquiry ಮತ್ತೆ ಎವಿಡೆನ್ಸ್ ಅದು ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರು. That is a matter requires the consideration.
Until you get a report in your favor, you cannot go. So if you, okay, disciplinary authority is powered to say these reports have certain defect, you hold the inquiry from this stage, or say that certain witnesses were not recorded, you record. Automatic power is there. But in report ನಿಮ್ ಪರವಾಗಿ ಬಂದಿಲ್ಲ ಅಂತ ಮತ್ತೆ ಇನ್ನೊಂದು
that is the reason.
inquiry ಆಗ ಬೇರೆ ಮತ್ತೆ ಮಾಡಿ.
No, here you have framed that further evidence has been recorded.
Illa.
There is no evidence has been
Illa. That is wrong. We have no extra. He has participated.
ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ?
ಅದು ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಅಷ್ಟೇ.
No, that is not that he said that there is no, see on that evidence. Only they have appointed that.
ಅದಕ್ಕೆ ಅವರು ಅಬ್ಜೆಕ್ಷನ್ ಕೊಟ್ಟರು.
No, because he has given, see, ಎವಿಡೆನ್ಸ್ ಮೇಲೆ ಎವಿಡೆನ್ಸ್ ಕೊಡಕ್ ಬಿಡಲ್ಲ, otherwise it will be a
ಅದಕ್ಕೆ ನಾ ಹೇಳಿದ್ದು
ಅವರು ಪಿಟಿಷನ್ ಓದಿದ್ರು ಅವ್ರ ಹತ್ರ ಬರ್ದೇ ಇಲ್ಲ.
ಅದಕ್ಕೆ ನೋಡಿ
ಇವತ್ತು they cannot better their argument what is not said in the petition.
ಅದು ಒಪ್ಪಿಲ್ಲ ಅಂದ್ರೆ ಅವರ ಡಿಸ್ಅಗ್ರಿ ಯಾವ್ದು ನೋಡ ಅದು they can impose.
they can seek for a further inquiry.
ಅಲ್ಲ ಅದಕ್ಕೆ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದು ನಾನು, ಅದ್ರಲ್ಲಿ ಫರ್ದರ್ ಎನ್ಕ್ವೈರಿ ಮಾಡಿ ರಿಪೋರ್ಟ್ ಕೊಟ್ಟರೆ ಅದು
ಒಪ್ಪಿರಲ್ಲಿ ಡಿಸ್ಅಗ್ರಿ ಇಲ್ಲ, that I will consider.
ಅಲ್ಲ ಸರಿ, ಬಟ್
yes, they can direct it for further inquiry by appointing other inquiry officer.
ಅಲ್ಲ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆ ನೋಡಿ ಸರ್, ಸಾರಿ ಪೇಜ್ 100 ಅಲ್ಲಿ the present inquiry officer report, second inquiry officer, page 100.
Yes.
ಇವನ್ನೆಲ್ಲ ಎನ್ಕ್ವೈರಿ ಮಾಡಿದ್ದಾರೆ.
No.
Detailed inquiry.
See, ವಿಚಾರಣಾ ವರದಿ
ಅಷ್ಟೇ,
ವರದಿ ಸಬ್ಮಿಟ್ ಇರೋದಷ್ಟೇ. ಅವನು he can submit a fresh report on the basis of that evidence available, but he has to give one more opportunity for arguments.
ಅದಕ್ಕೆ ಶೋಕಾಸ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಅಷ್ಟೇ. He has not recorded second time evidence, mister. Where is that? That is not your case also. Yes. He can conducted a further inquiry by appointing new inquiry officer. In this case, that respondent corporation is not disagree with that, is disagree with that inquiry report submitted by
that inquiry officer, one Shri Basuraj, yes, Tadakkal.
ಪೇಜ್ 111
ಒಂದ್ಸರಿ
ಅದರಲ್ಲಿ ಎನ್ಕ್ವೈರಿ ಮಾಡಿದಾರೆ ಅನ್ನೋದಕ್ಕೆ ಪೇಜ್ 111 ಪೇಜ್ 111
ಎಲ್ಲಿ
PW1 Lokesh was examined as 2023 ಲಿ ಕೂಡಿ so and so.
ಕೆಳಗಡೆ ಸಾಕ್ಷಿ ನೀಡಿರುತ್ತಾರೆ. Where is that, mister?
Lokesh is not considered to this particular. It is Krishnamurthy. Krishnamurthy is the petitioner here. ಅದರಲ್ಲಿ ಬೇರೆಯವ್ರದ್ದು ಎಲ್ಲಾರ್ದು ಇದ್ದಿದ್ರೆ this cannot be pointed out here.
ಅಲ್ಲ ಇರ್ಲಿ ಬಟ್ ಎನ್ಕ್ವೈರಿ ಸಬ್ಸಿಕ್ವೆಂಟ್
ಎಲ್ಲಿದೆ? Now you are coming and searching. Yes. Yes. Disagree. In this case, disagree with that inquiry report submitted by first inquiry officer M. Ramachandra, retired district and section judge. And by exercising the power under 11A to conduct further inquiry, they have appointed new inquiry officer. Once Basuraj S. Tardal, retired district and session judge. Petitioner is participated in that inquiry. The inquiry, second inquiry officer has submitted a report stating that charges level against that petitioner and others has proved. On the basis that inquiry report has been accepted by the disciplinary authority and issued a notice wide annexure W. Therefore, there is no illegalities error in that impugn order passed by that respondent. In the case relied upon by the petitioner in WP 21160 of 2017, disposed of on 18 July 2021. In that case, the disciplinary authorities did not agree with that finding of that inquiry officer. Once they have accepted that inquiry report, they cannot obtain the report from that other sources and impose the penalty. They're not disagree with that finding of the inquiry officer, but secure the separate report from an investigation officer and passed a penalty for recovery. Therefore, that case is not applicable to the facts of this case. Accordingly, writ petition is dismissed.
Pending application.
Petitioner is permitted to submitted a reply. Liberty is reserved to the petitioner to submit a reply.
Para 7 of the earlier, para 7 of the earlier judgment.
Yes, yes. Petitioner is permitted to file an objection to that notice annexure Q.
W.
Annexure W.
ಅಲ್ಲ V and W ಅಪಾಯಿಂಟ್ಮೆಂಟ್
P is enquiry, the appointment ಆಗೋಯ್ತು.
ಅದನ್ನ ಹೇಳಿದಿರ್ತಾವ.
B and W. V and W.
Correct.
To that inquiry officer within
15 days from the receipt of certified copies of this.
Enquiry officer, discipline authority.
The disciplinary authority, yes. Within 15 days from the date of receipt of certified copies of this order, the respondent is directed to consider the same and pass an appropriate order in accordance with law. All the contentions of the parties are left open. Yes.
And this, in the previous order, what I have just produced, my lord, 6 weeks your lordship had granted. From the date of receipt of their reply, it's already 5 weeks old. By stay of this particular writ petition.
ಇದ್ರಲ್ಲಿ ನಾವು ಅದಕ್ಕೆ ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ. It is for you. You can keep it pending. They are happy. If they want to pass, you can pass.
This we will proceed immediately. The previous order we will proceed immediately.
No, I am not giving any fixing date.
Yes, ma'am.
Therefore, you can do it whenever you want.
Yes, ma'am.
Yes. Least permission matter fast over matter. We'll call that. All pending applications are disposed of. The next is a matter.
Number
40? Yes, 40. When do you want?
Let's day after tomorrow. Saturday, my lords, it is a special working day.
Yes, Saturday. Yes.
Serial number 46.
Serial.
No, you will call page Kariri.
Serial number 41, Raghupati S.
Saturday, all matters. No, you will have it on 30th Saturday. 30th Saturday. This week Saturday, so many matters, it may not reach, madam. Yes.
Serial
Yes, the 23rd. Yes.
serial number 42, C. Krishnamurthy.
42. Considering the seniority is not short one. 30th Saturday. No, 30th Saturday. Yes.
Serial number 43 adjourned. Serial number 44, Rakesh B. Bhatt.
Appearing for petitioner. Your lordships had asked me to produce an order rule.
Yes, 29th.
That reason it was adjourned.
29th.
29th, I have some meeting.
Yes, 30th. Yes.
Serial number 45, Harish N.R.
Appear for petitioner.
My appearing for respondent one.
Mandamus.
Fourth. Yes, fourth.
Mandamus estates.
I fourth will decide. Yes.
46, Vaishali Hegde.
Yes, eighth. Who has to file objection? State. Yes, Mr. You file an objection in the meantime. Yes.
47, Shekhar L.
47 my lord, only seeking
My lord, my appearing for respondent.
retirement benefits.
Retirement benefit. Yes, Mr. Sanjeev, what is?
Mandamus is paid, my lord. Mandamus can be issued.
Can be disposed of. What is that final hearing? 48. 48 here. Yes, Mr.
Assistant professor terminated without holding inquiry. The last occasion heard for some time ago, directed them to produce the records. The short matter, 28 or 29th.
29th. Yes. Yes, what is this, Mr. Shekhar?
Petitioner attained the age of superannuation on 39/20/2023, my lord. Lord, he made a representation on 6/1/25, my lord. Even after not settle the terminal benefits, my lord. Or initiate any disciplinary proceedings.
Yes, you consider, Mr. Yes, in this writ petition, petitioner sought following relief. Petitioner was appointed as an revenue officer in respondent corporation. He has retired from the service when? Yavat retired adri?
39/23.
On 39th?
Sorry. 31/1. 31/10.
ಅಲ್ಲ ಯಾವ ರಿಟೈರ್ಡ್ ಯಾವಾಗಾದ್ರು?
31/10.
23 he retired from the service on attaining the on 39/2023 attain age of superannuation. Date of events ಅಲ್ಲಿ ಇದೆಯಾ? ಯಾವತ್ರಿ
3110 sir.
ಮತ್ತೆ ಇಲ್ಲಿ ಸಿನಾಪ್ಸಿಸ್ ಅಲ್ಲಿ 39
Order dated my lord 39/23 with effect from 3110.
yes 31/10/2023 attain age of superannuation. Thereafter he has submitted a representation annexure E on 6/1/2025 fit with 10% interest. Respondent has not taken any decision, hence the petitioner is before this court. Learned counsel appearing for the respondent has submitted that this court grants some reasonable time. Representation of the petitioner vide annexure E dated 6/1/2025 will be considered in accordance with law. In view of the above, without expressing any opinion on the merit of the case, the above writ petition is disposed. Vide annexure E as expeditiously as possible, not later than how much time, Mr. 8 weeks from date of receipt of copy.
Application.
All pending applications.
Fast over matter, serial number 10, Shivashankar.
I appear for the petition counsel.
ಮುಂದೆ ಇರೋದಾ?
My lord, there is a scheme as per annexure A
Yes.
for appointment of legal defense counsel for the accused. As per annexure, my lord, respect kindly come to page 34. My lord, the petitioner was appointed on the last occasion as chief legal aid defense counsel for a period of 2 years. Respect
Yes.
kindly come to page 34, my lord. The mode of selection, last para.
Yes.
As per the direction of the Honorable Executive Chairman, so and so, on the basis of pendants of criminal cases and legal aid cases, the following posts in respective so and so needs to be filled up on contract basis for a period of 2 years on monthly salary with a stipulation of extension on yearly basis upon satisfied performance. As and today, my lord, I have been appointed as a chief defense counsel to the rural court. Actually, kindly come to my lord, page 61. Insofar as the extension, my lord, the mode is selected is page 61, my lord. Monitoring, paragraph 11.
Paragraph 11.
The work and performance shall be closely monitored by the secretary, so and so. And a monthly review meeting will be organized under the chairmanship of the chairman, so and so. The minutes of the meeting shall be sent to the so and so. A quarterly review meeting with every so and so office and the secretary, so and so will also be organized by the member secretary. SLSA and minutes shall be sent to any NALSA on behalf on half yearly basis. Review meeting shall be organized by NALSA. The formats for such data sharing will be shared at the time of launch. Monitoring shall be a continuous process, and at the end of 6 months, the performance of every human resources shall be evaluated by SLSA under the guidance of Honorable Executive Chairman, SLSA. Monitoring and mentoring committee shall monitor legal aid work of legal aid defense counsel office, the chief legal aid judge. Now, my lord, the term of the petition is come to an end, and therefore, my lord, the application has been invited.
Yes.
My lord, the petitioner has also made an application and also requested for continuation by virtue of this regulation, my lord.
Yes.
The said request has been, of course, I have also made an application. It has been rejected as per annexure H, my lord. It's at page, without giving any reasons, page 94. Now, my lord, the fifth respondent who has been appointed now as a chief defense counsel. As a matter of fact, my lord, she had applied. You will kindly come to page 18, my lord. Page 18 of the writ petition.
18.
18, my lord. In the middle, my lord, about 10 lines from the top, she had been selected as assistant legal aid defense counsel. Got it, my lord?
Yes.
She has been
Bangalore
selected
Rural
as
Aid.
assistant legal aid defense counsel in Bangalore rural so and so office, but she has not been selected in Bangalore urban district. Now she is working as assistant legal aid defense counsel in LADC office. Even she has applied in the year 2022 for the post of chief, deputy and assistant so and so in both urban and rural, but she was not selected for any post in both urban and rural district. Again, she has applied for the post of chief legal aid defense counsel and Deputy Legal Aid Defense Counsel in the month of January 2025, as per notification dated 24/12/2024. In that, applicant has applied for the post of Chief Deputy Legal Aid Defense Counsel in both urban and rural district, but she has not been selected even assistant in the urban district, but she has been selected for the post Chief and Deputy Legal Aid Defense Counsel. And there are concerns that she may be closely related to a member of the selected committee from her husband's side, who is an advocate and practicing in Bangalore Bar Association. Rashma kindly said, even for the, as on today, my lord, she has been working as the assistant legal, and she has got the term till 2027. No, my lord, my rejection, my lord, since I am entitled for the continuation on the basis of the assessment, my lord, I should have been continued for one more year. And moreover, she had applied both in respect of urban as well as rural.
No,
whereas in urban, she has not.
Here itself, she has been not continued, maybe on the merit.
It should be, my lord, when I have given representation, they should have said, my lord, you don't have the merit.
No, that it is in a contract, you can't claim as a right. 2 years is over.
2 years,
Continuation is for left to them. You can't say that you have to be continued.
True, my lord. Here, my lord,
there is a merit also.
That is true. The fifth respondent, my lord, Rashma kindly appreciate. She had applied 2022, both in respect of urban as well as rural, for 3 posts. She was not selected. No, she has been selected. Rashma kindly come to page.
No, that we will see.
96. 96.
Yes.
96, Jyoti Lakshmi. Well, it is selected in this 96 nalli, Jyoti Lakshmi NK, selected chief. This is the order, my lord, the impugned order, 96. Earlier, my lord, she has been in the service as in the service idiyalla. Rashma kindly appreciate.
That's it. Even if it is in a service, if they want to leave off and go to that other, there is no bar.
Page 18 alli, since she has got service, my lord, for my continuation, my lord, when the rule says, my lord, I am entitled for continuation.
The rule says 2 years is the term.
And
after that,
it can be
they
continued.
will assess. They will assess and decide.
Therefore, my lord, when I have given representation, my assessment, my lord, Rashma kindly say,
you
my lord,
take notice.
Today is the last date, my lord. I would be
relieved.
I would be relieved.
Committee, if they have decided that there is some complaint and allegations, then we cannot. We'll secure that records. We'll see that what has happened. If you succeed, we'll direct it to continue. Why do you worry that?
In all the districts, my lord, whoever appointed have been continued.
No. The reason is why she has been discontinued has to be verified. If there is no reason with the records, then we'll interfere. If there is any reason, then we cannot. Therefore, that option is left with that authority. We'll ask them to get in records, and you take an handsome.
I will take handsome, my lord.
Yes.
Lordship kindly have next week, my lord.
Yes.
Till then, my lord, status can be status of. No, because since he has been working as assistant legal defense.
You have to see your right. If you are succeeded, in your place, he has been appointed now.
ನನ್ನ place ಗೆ ಅಪಾಯಿಂಟ್ ಆಗಿರೋದು, but she has been working as legal assistant.
ಆಯ್ತು, ನೀವು succeed ಆದ್ರೆ ಅವರು ಹೋಗ್ತಾರೆ ಅಷ್ಟೇ.
Rashma kindly see annexure G, my lord.
That appointment of fifth respondent will subject to the result. We'll say that.
Relieve ಅಂತ ಹೇಳ್ತಾ ಇದೀನಲ್ಲ.
Yes.
Because a letter has been issued, my lord, for relieving today, because it comes to an end.
We will see that. We will secure the records. If there is no any such allegations, then if they are not given an explanation why she has not been continued, if all others continued, unless there is no allegation, then court will see that what's that to do. Then you have made an allegation against the fifth respondent.
Yes, my lord.
Suppose if you succeed, then she has to go, or they have to make an accommodation for both. That is for them to.
Of course, next week on date, I will take handsome.
You take handsome. Learned counsel for the petitioner is issue emergent notice. In addition, counsel for the petitioner is permitted to take out hand summons to respondent number 1 to 5.
Till then, status can kindly be granted. 1 week in agodilla.
Because appointment of fifth respondent is subject to the result of this writ petition. Leave this matter on 30th.
Appointment is subject to result of this.
Result. Yes, sir. Yes. Yes, our submission is accepted, office objection is overruled.
Your Lordship may kindly, my lord, may make one submission. Today, my lord, in the mediation, one matter got settled, that is RFA of 2011, my lord. The parties are all the way from Sagara to here. Kindly, your Lordship may have it tomorrow, my lord.
They are coming.
Yes, my lord. They are present, my lord.
Yes, 2:30 tomorrow.
Obliged.
ನಾಳೆ 2:30 ಹಾಕ್ಸಿ.
I'm moving.
Parties are coming, both the parties are agreed.
Both the parties are agreed.
Yes.
ಒಂದು ನಿಮಿಷ
ನಾನು ಹೇಳಿ ಬಂದಿದ್ದೀನಿ.
ಅವ್ರ ಕೈಗೆ ಕೊಡಿ. ನಂಬರ್ ನೋಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಹಲೋ ನಾಳೆಗೆ 2:30 ಅಂತ ನಮ್ದೆಲ್ಲ jurisdiction ನೋಡಿ.
ಹೌದು. 2011. ಡಿಗ್ರಿ ಎಲ್ಲ ಆಗಿದೆ. ಡಿಗ್ರಿ ಎಲ್ಲ ಮಾಡಿ
ವಿಶ್ವ ಲಿಸ್ಟ್ ಕ್ಲೋಸ್ ಮಾಡ್ತಾರೆ. ಇಲ್ಲ ಒಂದು RFA ಕ್ಲೋಸ್ ಮಾಡ್ಕೊ. RFA ನಂಬರ್
228
of 2011 ರಿಪೋರ್ಟಿಂಗ್ ಸೆಟಲ್ಮೆಂಟ್ ಎಮ್ಮನು ಬರುತ್ತೆ ಈಗ. ಈಗ ಸಾಹೇಬ್ರು ಈಗ ಎತ್ತಿದ್ದಾರೆ, ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ. ಪುಟಪೆಲ್ಲ ನಾಳೆ ಲಿಸ್ಟ್ ಆಗಬೇಕು 2:30
mediation
ಅದಿನ್ನೂ ಮೀಡಿಯೇಷನ್ ಎಲ್ಲ ಇದೆ. 228
2011
RFA 228 of 2011 ಫಾರ್ ರಿಪೋರ್ಟಿಂಗ್ ಸೆಟಲ್ಮೆಂಟ್ ಅಂತಾನೆ ಸ್ಟೇಜ್ ಹಾಕ್ಬೋದು. ನಾವು ಅದೇ ತರ ಸಾಹೇಬ್ರು ಈಗ 5-8ರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದು ಮೀಡಿಯೇಷನ್ ಸೆಂಟರ್ ಎಲ್ಲೋ ಕೊಯ್ದಿದೆ, ಅಲ್ಲಿಂದ ಎಲ್ಲ ಬರಬೇಕು, ಲೇಟ್ ಆಗುತ್ತೆ. ನಾಳೆ 2:30 ಅವ್ರ RFA ಪೆಂಡಿಂಗ್ ಬ್ರಾಂಚ್ ಹತ್ರ ಮಾತಾಡ್ಬೋದು. ಏನು ಅಡ್ವೊಕೇಟ್ ಎಂಡ್ ನೋಡಿ ಕ್ಲೋಸ್ ಲಾಸ್ಟ್ ಫಾರ್ ರಿಪೋರ್ಟಿಂಗ್ ಸೆಟಲ್ಮೆಂಟ್ ಅಂತಾನೆ ಬರ್ತಿದೆ. ಹಂಗೆ ಬರೀಬೇಕು. ಅಲ್ಲ ಎಲ್ಲಿದೆ ರೆಕಾರ್ಡ್ ಎಲ್ಲಿದೆ? ಮೀಡಿಯೇಷನ್ ಸೆಂಟರ್ ಎಲ್ಲಿದೆ? ಇಲ್ಲೇ ಸರ್ ತಗೊಂಡು ಹೊಡೋದು. ಪೆಂಡಿಂಗ್ ಅಲ್ಲ, ರೆಕಾರ್ಡ್ ಎಲ್ಲಿದೆ ಅಲ್ಲಿ ಕೊಟ್ಟು ಅದನ್ನ ತಗೊಂಡು ಪೆಂಡಿಂಗ್ ಹೋಗ್ಬೇಕು. ಬೇಗ ಈ ತರ ಪುಟಪ್ ಮಾಡ್ಬೇಕು, ನೀವೇ ಮಾಡ್ಬೇಕು. ಯಾಕಂದ್ರೆ ನಮ್ ಕಡೆ ಕೊಟ್ರೆ ಅವ್ರು ಡಿಲೇ ಮಾಡ್ತಾರೆ, ಲೇಟ್ ಆಗುತ್ತೆ. ಮಾಡ್ತೀರಾ ತಾನೆ? RFA ನಂಬರ್ ಎಷ್ಟು ಕೊಡಿ?
228 of 2011.
Double to eight,
228 of 2011.
ನಾನು ಅಡ್ವೊಕೇಟ್ ಕಡೆನೇ ನಮ್ಮ ಕೊಟ್ಟಿರ್ತೀನಿ, ಅವರೇ ಹೋಗಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 43
ಸೀರಿಯಲ್ ನಂಬರ್ 43 ಹಾಕೋದಾ?
5240
2311